All fresh matters you give. It will come on 11th, sir. ಎಷ್ಟು ತೊಗೊಳಕ್ಕಾಗತ್ತೆ ನಾನು ಕೊಡಿ. 11th ಬರುತ್ತೆ ಕೊಡಿ. All fresh matters you give. General award ಎಲ್ಲ ಕೊಡಿ. Fresh matter. ನಿಮಿಷ. Early hearing. Fresh matter. Monday and Tuesday, give it. Yes. Huh? Oh, that matter is it?
Yes.
All right, we'll post it. Give. Withdrawal, please give. Madam, withdrawal ತಗೊಂಬಿಡಿ. ಎಷ್ಟು matter ಇದೆ?
My lord, a submission, my lord.
Yes, one moment. Any submission this week?
It is
Memos are
on
over?
the other side.
2:30. ಯಾಕೆ? So, Monday ಕೊಡಿ. ಏನಾಗಲ್ಲ ಅದ್ರಲ್ಲಿ ಕೊಡಿ. ಕೊಡಿ ಸರ್, Monday. Huh? Why are you moving on the left hand? You're a left-hander? Oh, sorry. Sorry, ಕೊಡಿ. ಏನ್ ಬೇಕು? Two thirty. Wait. Yes.
Commercial arbitration, which was on the list on the last term, Lord, it is.
Which term?
Last term meaning just last week, Lord. Last time I tell you, not 3 weeks, 3 years, not the commercial execution is pending on account of allegation that stamp duty is not paid.
We'll see. Give it.
My lord.
Pending matter.
My
Next
lord,
Wednesday. Yes, madam.
I have submitted the memo already, my lord. It is regarding, I am for the petitioner herein, my lord. He was suspended by the NIPM. He was suspended by the NIPM and he was stopped from submitting his nominations for the elections, which is to be held on 7/7, my lords. He challenged the same in the a civil suit in Mangalore. However, the learned judge over there was pleased to issue an emergent notice for the same, my lord. However, we've challenged the same here in my lord. The same may be listed tomorrow, my lords.
What's the urgency?
The election is to be held on 7/7, that 7/8, that is day after tomorrow, my lords.
Tomorrow, tomorrow at 2:30? No, tomorrow. Let it come tomorrow.
Please, my lords.
Number yav togoli.
My lords have given a memo wherein the respondent has filed an application for seeking of the amendment of the suit schedule property, my lord. Here it
Fresh or pending, madam?
Dear lord,
Fresh matter or pending?
fresh matter.
Monday
But they
ಆಗ್ಬೋದಲ್ಲ?
have filed after 15 years of the
No,
suit.
it can be on Monday.
I have filed the memo.
Can it be on Monday? It will come on Monday. Yes.
One matter for CRP, preliminary, any date, your lordship can.
Pending matter.
Pending, please. Any date pending.
Pending matters?
Your lordship's writ petition number 2967.
How do I know what is that?
Appearing for respondent in this matter, your
Ah.
lordship, there's an ex parte interim order, stay against my.
Vacating
order.
stay ಹಾಕಿದ್ದೀರಾ? You have filed vacating stay? Give it.
Your lordship, there is 23 matter where there's
Give
a
all pending memos also give.
stay in the trial court execution petition. This court has ordered no precipitative action can be taken. That is why it's pending and stalled. If this honorable court can be pleased to.
Wednesday. Stay vacate application ಇದ್ರೆ ಕೊಡಿ. ಏನಾದ್ರೂ ಇರಲಿ stay vacation application ಇದ್ರೆ ಕೊಡಿ. Vacating stay applications all you give. Fresh matter ಕೊಡಿ. Monday. ಕೊಡಿ. ಎಲ್ಲ fresh matters ಎಲ್ಲ Monday ಕೊಡಿ.
Land acquisition matter.
Withdrawal immediately.
One land acquisition matter, my lord.
ಕೊಡಿ
Fresh
sir.
matter. And also another CPC, my lord.
ಆಯ್ತು ಕೊಡಿ.
2007 matter, my lord.
2007 pending ಇದೆಯಾ ಇನ್ನು? GMCPC.
ಅಲ್ಲ, ಅಲ್ಲಿ 495 2007 OS.
OS ಇಲ್ಲಿ ಯಾವಾಗ?
That has been stayed.
ಇಲ್ಲಿ ಯಾವಾಗಿಂದ?
Amendment application allowed, against which the.
ಆಯ್ತು ಸರಿ ಕೊಡಿ ಬರುತ್ತೆ.
Monday.
Fresh matters Monday.
It's a fresh matter, my lord. CRP matter before the trial court is listed on 12th.
On?
12th month. I'd moved a
I think Monday is 11th.
My lord, I've moved couple of memos.
No problem, give it sir. Monday ಯಾವ್ದು fresh matters ಇಟ್ಕೋಬೇಡಿ ಮೇಡಮ್ ಎಲ್ಲ ಬಂದು. If you have not complied with the office objections, it won't come. If office objections are complied, there is no fresh matter pending in the registry.
I've complied, my lord.
Comply ಆಗಿದ್ರೆ ಎಲ್ಲ ಬರುತ್ತೆ. Even if it is 200 or 250, I have taken it. On Monday, I'll take it.
Once pending matter, my
Give
lord,
it.
for admission.
Pending matter memo ಕೊಟ್ಬಿಡಿ.
With your lordship's indulgence, my lords, the nice highway matter, one of the, vide an interim order, we have filed a vacating stay application.
ಕೊಡಿ.
We did, my lords, a date mechanism be fixed.
Tuesday, vacating stay next Tuesday.
My lords,
Tuesday.
On those designated days, vacating stay will come. Yes.
My lords, I'm-
Tuesday, LA. Monday, all matters. Wednesday, CPC. All those days, vacating stays application will come.
This coming Tuesday.
Tuesday.
My lords, I'm mentioning two fresh writ petitions against gag orders passed by trial court. One in fact is covered by the judgment of my lords.
ಮತ್ತೆ ಯಾವುದು?
Suit for defamation. I'm a party similarly placed. One is I'm covered by the Kudla Rampage judgment.
Ah.
The other is a gag order where I'm not a party. My publication is part of the subject matter of the suit. But I have been receiving emails to take down and the plaintiff therein is also
Concerning what, madam? Same thing, same
concerning the
subject,
same issue, my lord.
same issue.
Concerning-
You're not a party there.
One suit I'm not a party, one suit I am a party.
Not a party, you should, if there is any order against you, you should go to the GM.
My lords, this calls
To
for
stop-
indulgence of this court because
I'm not holding 226 jurisdiction, it's 227.
my lords,
ಅದು ಕೊಡಿ. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ರಲ್ಲ covered ಅಂತ ಅದು
if I
ಕೊಡಿ.
may request for 230, it's covered, my lords. Trial court matter is also today. I'm a similarly placed respondent here.
That's all right. We'll close it following that.
My lords, in the other matter, if I may just take a minute. what
But
has
you should
happened
serve the
is-
complainant.
My lords,
Sorry,
they're on
serve the
caveat.
plaintiff,
My
sorry.
lords, they're on caveat. We've served on email and hard.
Then no problem. You should get the caveat, otherwise tomorrow.
Maybe had it 2:30.
Will be had at 2:30. If the caveator is not present, tomorrow.
My lords,
My
the
lords.
other matter is also a similar matter where in
If
fact,
you are not a party there and there is emails coming, you should go to the GM court.
My lords, may I mention this, my lords? Why 3 orders, this honorable court has directed the trial court to decide my vacating of the temporary injunction.
ಮಾಡಿಲ್ವಾ ಇನ್ನು?
Madi line.
2:30 ಕೊಡಿ.
my lords, pending.
Give it.
On Monday, my lord.
ಅದ್-
I moved the matter to 3
No problem. CRP ಮಂಡೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
tomorrow, my lord. Judgment in post ಆಗಿದೆ.
ಏನಾಗಲ್ಲ ಕೊಡಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಆದಾಗ 711 ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಸರ್? ವಾಟ್ ಇಸ್ ಆಲ್?
7/11 ಸ್ವಾಮಿ, I mean 11th, 8th, Monday.
ನಾನು ಹೇಳಿದ್ದು ಆರ್ಡರ್ 7 ರೂಲ್ 11th ಅಲ್ಲ.
ಅಲ್ಲ, not. The
ಜಡ್ಜ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಆಗೋವರೆಗೂ
RM, without hearing the respondent, in spite of special request that he is not well, the court has hurriedly posted the
ಆಯ್ತು,
matter.
ಅದು ಟುಮಾರೋ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
My lords,
ದಟ್ ಈಸ್ ಟ್ಯೂಸ್ಡೇ.
my lords, pending
ನಾನೇ
matter.
ವಿಲ್ ಗೆಟ್ ಇಟ್ ಮೇಡಮ್, ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕ್ಸಿ ಮೇಡಮ್.
My lords, pending matter.
ಕೊಡಿ ಸರ್, ಪೆಂಡಿಂಗ್ ಅಲ್ಲ. ವೈ ಆರ್ ಯು ಹೋಲ್ಡಿಂಗ್ ಮೆಮೋಸ್? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಅಲ್ಲ.
Pending matter, not.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಅಲ್ಲ. ಡಿಸ್ಪೋಸೇಷನ್ ಮಂಡೇ ಕೊಡಿ.
My lords,
ಇದುವರೆಗೆ ಇಲ್ದೇ ಇರೋ ಥ್ರೆಟ್ ಈಗ ಸಡನ್ ಆಗಿ ಬರುತ್ತೆ.
my lords, LAPD fresh matter, my lord.
ಎಲ್ಲ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಆಲ್ಸೋ ಅದ್ರ ಮೇಲೆ ಬರ್ದ್ಬಿಡಿ. IA ಫಾರ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅನ್ಬಿಟ್ಟು ಕೊಡಿ.
That memo I am moving.
Even if you move 10th memo, no problem. We will have it posted, sir.
My lords,
Beyond limit, I cannot take.
I am
please.
not.
Try to understand. Try to understand. I have completed all the fresh matters yesterday. There is no pending. ಅದರ ಮಾಡ್ತೀನಿ ಒಂದೊಂದಾಗಿ. If you cooperate, I can do it. ನೀವೆಲ್ಲ 10 memo ಅಂದ್ರೆ ನಾನು ಯಾವ್ದು ತಗೊಳಲ್ಲ.
Compromise decree passed by the trial court.
ಆಯ್ತು ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದ್ರೆ ಬರುತ್ತೆ. ಅರೆ ಬರುತ್ತೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಎಷ್ಟು ತಗೊಳಕ್ಕಾಗುತ್ತೆ ಹೇಳಪ್ಪ? ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗಳಿದಾವ? ತಗೋಬಾರ್ದ ಅದನ್ನ? Will do it. Wait. I am also doing it. I'll do it. If you come on me like this, then I will not take anything. ಬೆಳಗ್ಗೆಯಿಂದ ಸಾಯಂಕಾಲದವರೆಗೆ 20 ಮ್ಯಾಟರ್ ತಗೊಂಡು ಕೂತ್ಕೊಂತೀನಿ. ಕೊಡಿ ಬರುತ್ತೆ.
my lords, LAPD fresh matter, my lord.
Wait.
Lord, LAPD fresh matter, my lord.
Give it, sir.
Yesterday they have demolished property, my lord.
Huh?
Threat of acquiring property.
ಎಲ್ಲ ಮಂಡೇ
my lord.
ಥ್ರೆಟ್ ಆಫ್ ಅಕ್ವೈರಿಂಗ್ ಹಂಗೆಲ್ಲ ಥ್ರೆಟ್ ಆಗಲ್ಲ. ಅಕ್ವೈರಿಂಗ್
What dispossession,
Notice
demolished.
not ordered, my lords, pending matter.
Give it, sir. Give it.
2025, my lords.
Give all the memos, whether fresh or pending.
The execution
Give, sir.
proceedings.
Connected matters are listed tomorrow, my lord.
Give it tomorrow, no tax matters.
My lord, date given matters.
No, that the other court has given. I'm posting them all on a different date. Give it.
Execution
My lord,
proceedings are stayed
My lord,
in this
goods are
matter.
perishable in nature, my lord. Despite an order, the goods are.
ಯಾವ್ದು ಅರೆಕನಟ್ ಏನದು? ಕೊಡಿ.
Execution proceedings are stayed before
Tomorrow I
this court.
can't. We'll see.
Execution
Thursday or,
proceedings are
next
stayed, my
week.
lord, by this court. Execution
Vacating stay
proceedings are,
ಆಗಿದ್ದೀರಾ?
vacating is.
ಕೊಡಿ.
Your lordship, age relaxation and the surrogacy act, your lordship.
ನನ್ನ ಹತ್ರ ಯಾಕೆ ಬರುತ್ತೆ?
Your lordship, it was further hearing kept by you.
No, I've released all those surrogacy matters from further hearing. Go to the GM court. Long back
38D
I've done it.
consideration, my lord, 38D consideration. Only for.
ಕೊಡಿ ಸರ್.
case before commercial court, my lord. It was posted for judgment. However, the judge, my lord, sought for some clarification to the plaintiff and directed that there are some lacunas that has to be filled up in the case and the direction for two. They are proceeding with the case, my lord.
Tomorrow.
My lord's notice not ordered.
Fresh ಅದು?
Ejectment suit, my lord.
Fresh matter.
Ejectment suit, my lord's notice is not ordered. GMCPC, my lord's.
Notice is not ordered.
Notice
ಕೊಡಿ
fresh
Monday
matter, my
ಬರುತ್ತೆ.
lords.
My lord, fresh matter, the case is listed day after tomorrow for
Maybe, sir.
orders.
We'll list
It is
only
listed before the commercial court day after
Problem,
tomorrow for
sir.
orders. It
Monday.
may be taken up tomorrow.
Monday.
My lords,
ಅದು ejectment ಅಂತ ಮಾತ್ರ is.
2018 matter, my lords, Muda case, my lords.
Same connected.
Which one?
ಯಾರಿದೆ?
Mysore
It is
Muda.
listed.
First list.
ಆಯ್ತು ಅದು list ತಗೊಳ್ಳಿ madam.
Tomorrow, my lords.
Yeah, tomorrow. We'll see. We'll fix it. Yes. What matter? Income. ಕೊಡಿ. ಕೊಡಿ sir. Fresh ಅಲ್ವಾ? No, all Monday. Yes. Fresh pending sir. Fresh fresh matter Monday ಬರುತ್ತೆ. Urgent ಯಾಕಿದೆ? ex-wife ಅದೇ urgency ಇಲ್ಲ ಬಿಡಿ. No urgency at all. And pending matter. ಮತ್ತೆ ex-wife problem ಕೊಡ್ತಾ ಇದ್ದಾರಾ? ಸೂಟ್ ಅಲ್ಲಿ ಸೇರ್ಕೊಂಡಿದಾರ? ಲೈಫ್ ಅಲ್ಲೇ ಸೇರ್ಕೊಂಡಿದ್ರು, ಸೂಟ್ ಅಲ್ಲಿ ಸೇರ್ಕೊಂಡೇನು? ತರಲೆ ಮಾಡ್ತಿದಾರ? ವಾಟ್ ಯು ಮೀನ್ ತರಲೆ ಮಾಡ್ತಿದ್ದಾರೆ? ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. ತೊಂದ್ರೆ ಕೊಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿ ತರಲೆ ಮಾಡ್ತಿದ್ದಾರೆ ಅಲ್ಲ. ಹಾ ಸರಿ ಆಯ್ತು, ಪರವಾಗಿಲ್ಲ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ?
matter, my lord, execution ನಲ್ಲಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
230.
My lords, fresh matter, my lords, we are seeking
Monday.
withdrawal of the OS matter.
Withdrawal of the old matter.
OS matter, my lords, pending before the learned city civil court, my lords.
Give it. Yes. Monday.
Pending matter, my lord. That my lord,
Pending memo ಕೊಡಿ.
That court has directed to deposit the rent, which is a partition suit, my lord.
ಕೊಡಿ
Tenants
sir.
are vacated now, my lord. In spite of that, my lord, direct.
No problem. Give it.
Need date, my lord.
No date. Yes. Pending matter only seniority. Yes. Next.
Just one, order still number one, hearing to the petitioner.
Rectification of office objections.
My lord, we filed the status report, my lord.
What status report?
This was with regard to providing basic amenities to Arkavati layout, my lord, Chalkare village, my lord. We have.
What is the status report? Do you have a copy of it?
We have, I've received the copy.
Underground
Yes.
drainage, all installed.
Everything is
my lord.
done.
Only asphalting of road is remaining. We have issued the tenders also.
Tenders is what they have stated in the
Means
report and they
first-
want further time. So.
Then we'll
time
close
may
this
be
or keep
fixed.
this?
It may be disposed with the time fixed.
Yes. The petitioner.
Sought for some monetary compensation because the
My
matter
lord,
has been pending for quite
My
some
lord,
time and I
it
have
went
spent
up in
monies.
contempt, my lord. It went up in contempt. Then the order was recalled. Because BWSSB was the one who had to provide underground drainage. We issued order under section 53 of BD Act to complete the work. Then they have completed the work.
How long will you take now to complete the entire?
My lord, only tender is first tender was only one bid was there.
ಆಯ್ತು. You give me a timeline.
My lord, some reasonable.
ಇಲ್ಲರ I
time.
will monitor compensation. will grant.
Reasonable time.
What
Lordship may fix.
reasonable ಅಂದ್ರೆ ಎಷ್ಟು? ಇಲ್ಲರ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ.
ಅಂದ್ರೆ ನಾವು ಬರೀ 6 months. ಅಂದ್ರೆ ಇದು asphalting of roads ಗೆ.
What sir, you may do anything. You give
1
me a
year, my
timeline in which you will.
One year, my lord.
1 year. 1 year ಅಂದ್ರೆ monetary compensation.
6 months.
Through monetary compensation.
My lord, ಅಂದ್ರೆ ನಾವು ಟೆಕ್ನಿಕಲ್
ಏನ್
ಸ್ಕ್ರೂಟಿನಿ
ಮಾಡ್ಬೇಕು?
ಟೆಕ್ನಿಕಲ್
ಅಲ್ಲ ಟೆಂಡರ್ ಯಾವ್ದಕ್ಕೆ ಕರಿಬೇಕು?
ರೋಡ್ಗೆ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
ಉಳಿದೆಲ್ಲ ಮಾಡ್ಬಿಟ್ವಿ ನಾವು.
ಉಳಿದೆಲ್ಲ ಮಾಡಿದೀರಾ? ಈಗ ರೋಡ್ ಟೆಂಡರ್ ಯಾವಾಗ ಕರಿತೀರಾ?
ಟೆಂಡರ್ ಕರೆದಾಯ್ತು. ಈಗ ಸ್ಕ್ರೂಟಿನಿ ಕಮಿಟಿ ಮುಂದೆ
ಯಾವಾಗ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀರಾ?
ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ. ತಾವು ರೀಸನಬಲ್ ಟೈಮ್ ತಮ್ಮ
6 months.
4 months because this matter was disposed of in 20.
ಅವ್ರೇನ್ ಮಾಡಲ್ಲ 4 months. ಮತ್ತೆ ಒಂದು ಹಾಕ್ತಾರೆ ಅಪ್ಲಿಕೇಶನ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ರೋಡ್ ಅಲ್ಲ ಟೈಮ್.
6 months, but some compensation. They're all from economically weaker section, both the petitioners, and they have
So
spent money.
I have not seen because it's in orders. I don't know what's the matter is.
My lord,
ಇಲ್ಲ ಅಂದ್ರೆ
They have depended on private
what's the matter?
tankers
Tell
all
me.
this time.
What's the matter?
My lord, we have been allotted the sites under the EWS scheme.
All right.
And from the date of allotment, basic amenities like water, underground drainage,
ಏನು ಇರ್ಲಿಲ್ವಾ?
electricity and roads were not available. We have continuously petitioned the BDA through the Legal Services Authority.
Ah.
And since they did not take action, we filed this writ petition, my lord.
Hmm.
The writ petition came to be disposed of on 17/8/21 itself, with the direction that they have to provide these amenities within a fixed time. That was
Within what time?
Within 3 months' time. Against this order, my lord, the BDA went up in a review petition where they
Writ
said.
appeal.
No, review petition was
Review
filed.
petition.
Review
Ah.
petition was filed where they said the water and the drainage comes under the jurisdiction of
BWSSB.
BWSSB, and they were not made a party before this order was passed.
Mhm.
The court recalled the order and reopened the case, and I have implemented the BWSSB after the.
What
matter was-
happened after that recall?
After that, there's been no action taken, and now they
This
have
is the
filed-
recalled petition, is it?
Page
Yes,
number,
my lord.
my lord, page number 13 may kindly be seen. Thereafter, page number 16.
Why you don't have any coordination with BWSSB?
My lord, we could not,
Why they did not,
Arkavati layout, my lord, is.
Yaraದ್ರು agli,
subject
how
matter-
can you put this economically weaker section people
My lord, subject
who
matter.
would not have wherewithal to fight all your mighty
My lord,
management?
this entire.
To jeopardy?
Arkavati layout.
Whatever it is, sir.
Is subject matter of.
ಅಲ್ಲ ಸೈಟ್ ಅಲಾಟ್
litigation.
ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನು ಇಲ್ಲದೆ ಅಲಾಟ್ ಮಾಡಿದ್ರಾ?
ಅಲ್ಲ litigation dispute ಬಂದ್ಬಿಟ್ಟು we are facing continuous litigation. Thereafter, my lord, even now also 136 ಅಲ್ಲಿ there is a dispute before Honorable Justice Concession or in committee, and only where we have no dispute we have completed the work. That one also I filed this sketch.
So
my
why
lord.
do you allot sites to these people?
My lord, we allotted the site when there was before that, my lord. Then what happened? Every landowner came before the court, and and it was quashed, and we had to go before several round of litigation. Then, my lord, there is a sketch which I have produced, page number 27, my lord. There I have clearly shown which
You
is,
always have might anta you trouble the poor people.
we didn't want
That's
to,
the
my lord.
whole
In
problem.
fact, after review petition only, our roads underground drain was.
Now how
constructed.
did you do it now?
My lord, BWSS, we issued a direction under section 53 to the BWSSB, my
You
lord.
could not have issued earlier without them being a party?
My lord,
You could have issued?
My lord, that was the difficulty with regard to, even though we had paid their amount, they didn't complete it, my lord. Then, because they were not doing it, we issued direction, my lord. Page number, now we kindly see page number.
Then she is right. They are entitled to
No,
compensation.
my lord, because,
No.
my lord, just kindly see, my lord.
Yes.
Even this order is issued on 1/7.
If I find the state troubling a poor man, definitely I will impose costs.
My
Review
lord,
petition
and,
is allowed
these
only.
two sites, my lord, are not in the disputed area. They have also admitted in the status report.
My lord, page number, page
How many
number 14. may kindly
petitioners?
be seen.
Ibrena?
IPRE. The first petitioner is a supplier in a hotel.
Ah.
Second petitioner is an auto driver. Both are economically weaker section, and that's how they have got these sites allotted to them. And they have been depending on private tankers all this while for water supply. And there's been no drainage facility. The roads have not been asphalted at all. It's been mud.
My lord,
Mud roads
kindly.
are there. And electricity, my instructions are that the transformers have been installed, but electricity supply has not been given till date.
My lord, kindly see page number 10. Order is recall of order.
You
as
forget about the order recalling. I'm only on compensation.
ನಮ್ಗೆ
Monetary compensation.
ನಮ್ಗೆ BWSSB ಕೊಟ್ಟಿದ್ದು 1/3/2025 after 2 years, my lord.
BWSSB ಏನ್ ಕೊಟ್ಟಿದ್ದು?
BWSSB complete ಮಾಡ್ಕೊಟ್ಟಿದ್ದು.
ನಿಮ್ಮ ಕಮ್ಯುನಿಕೇಶನ್ ಯಾವತ್ತು BWSSB ಗೆ?
BWSSB, my lord, 1/7/2021, my lord.
1/7/2021. When did they reply?
Then they completed the work and gave us on 1/3/2025, my lord.
1/3/2025.
Yes, my lord.
ಇದು ಎಂಟೈರ್ ಲೇಔಟ್ ಮಾಡಿದ ಈ ಏರಿಯಾಗ ಮಾತ್ರ?
Entire layout, my lord. We are doing this,
drainage
even
system.
this, including this, together we are doing, my lord. Then, my lord, then thereafter, only if they complete that, we can asphalt the road, my lord. If not, double.
Right, that is all right.
Yes, my lord.
When so the fault lies with the BWSSB.
My lord, 1/1/25, what my learned friend is saying, my lord, after which, my lord, there would be some orders by this court also that we could not work. I'll produce all those documents, my lord, in between what has happened, my lord. Then my lords can decide.
This lackadaisical attitude towards a poor citizen should stop.
Lord, it's not that way, my lord, because it's a BDS layout, my lord. They should instruct us to do it. That, my lord, I'll produce all the documents if there's any.
Yes. This the matter on Monday at 4:30 PM. Will dictate. Definitely will award monetary compensation to be paid by the BWSSB.
My lord, always
Yes.
will oblige the.
4 ವರ್ಷ ಮನೆಗೆ ಅಲಾಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲೇನ್ ಡ್ರೈನೇಜ್ ಇಲ್ಲ, ವಾಟರ್ ಇಲ್ಲ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇಲ್ಲ.
ನಮ್ಮ fault.
ಸುಮ್ನೆ ಫಾರ್ ದಿ ಸೇಕ್ ಆಫ್ ಅಲಾಟಿಂಗ್ ಯು ಅಲಾಟ್.
My lord, ಇದು litigation, even ಇವಾಗ ತಾವು
ಲಿಟಿಗೇಷನ್ ಯಾಕೆ ಕೊಟ್ರಿ ಅವ್ರಿಗೆ? This was not within
No,
litig.
this is not within the litigation area, and the
Allah,
status report
now-
also, they themselves have produced a sketch to show that
No,
these
this is
two
in
sites-
orders. I have not seen the paper, so I'll take it on Monday,
11th, May,
11th.
much,
Monday at 4:30.
4th, much.
Whatever you want to produce, produce. Otherwise, definitely cost. ನೀವು 6,000 square feet ಇರೋ ಮನೆಯವ್ರಿಗೆ ತೊಂದರೆ ಇಲ್ಲ. They can withstand, not these poor people.
This entire layout, same problem.
We'll see, yes.
Number
Next,
2,
No advance.
rectification
No,
of
no,
early
no,
hearing,
no.
what is all this?
No early hearing, no directions.
Ah.
Matter is very simple. This is BTM fourth stage. Our contention is possession has not been taken, compensation has not been tendered. Uchama's case covers
Position
all.
was taken, whereas sites are formed and sites are allotted. My statement I'll detail as I have furnished the details.
ಆಯ್ತು, we'll see. Order select ಬಂದು ಏನಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಟ್ಟು ನೀವೇ ಇಲ್ಲಿ ನೋಡಿ 6 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ನಮ್ದು
ನಿಮ್ದೇನೆ. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಯಾರು ಹಾಕಿರೋದು?
ಅವರು ಹಾಕಿದ್ದು, ಪಿಟಿಷನರ್ ಹಾಕಿದ್ದು.
ನಿಮ್ದ್ರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಕೃಷ್ಣ ಅವರೇ. And what is this early hearing?
No, we are not pressing early hearing.
List the matter, the learned senior counsels Dhananjay Joshi would not press the application seeking early hearing the matter. Therefore, the application seeking early hearing stands rejected. Post the matter in B group on 12th.
Even the second one we will not press on the next day. For
Yeah,
directions or something for disclosure of
IA
utilization.
1 of 2025 to be heard along with the main matter.
ಅದು press ಮಾಡಿ.
ಅಲ್ಲ 12th one.
ಇಲ್ದರೆ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇರುತ್ತದೆ. Yes.
It is taken on 18th or
Why?
also filed the synopsis.
18th ಇಲ್ಲ 19th.
19th.
Compilation of case laws I have given in
Please,
advance.
ಕೊಟ್ಟಿದ್ದೀರಾ?
One cassette ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡ್ತೀನಿ.
2023 ಇದು preliminary hearing ಅಲ್ಲಿ ಹಾಕಿ. List in preliminary hearing.
Great.
number 3,
Non-filing of amended cost title.
I filed, my lords, instead of filing amended cost title, I have filed amended writ petition. I'll file the amended cost title today, my lords.
ಏನ್ interim order ಇದೆಯಾ? Yes, what is the matter? No interim order.
No interim.
My lord, I appear for the KIDB, my lord. Compensation is already released to them. However, 1/3 portion of the compensation was withheld in view of a suit which is pending. Hence, the writ is filed, my lord.
Subject to suit.
My lords, I'll make submissions.
That doesn't suit you?
I'll make submissions in the next.
Already, my lord, 1 crore, more than 1 crore, 60 lakhs has been paid to them, my lord. I am the 1/3 owner. I am the sister, my lord. There is no dispute.
ಏನ್
with
stay
regard to
ಏನಿಲ್ವಲ್ಲ
relationship.
ಇಲ್ಲಿ?
Suit is pending.
I am not subject to the suit, we'll close it.
My lords, on the next date.
Right,
I'll
next
see.
date, list the matter on 19th.
It's okay.
Pendency of this petition will not come in the way of any proceeding before any fora or administrative authorities. Yes.
4,
I filed, my lord, the entire amended petition on 19th itself.
Learned counsel submits needful has been done.
Has been accepted, my lord.
Office to verify, list the matter.
Next
In
12.
first time ಬರ್ತಾರೆ. Yes, Patil. What's the matter?
It's already argued at length.
Argued?
Not before this, not before this.
ತಮ್ಮ ಮುಂದೆ
court,
ಮಾಡಿ.
lords.
Next week ಮಾಡಿ.
Lords, the simple
2008, my lord, land was
No, no,
acquired. Compensation was paid like in the year 2021 after 30
paid
years.
paid under consent.
No,
Now you
Lord.
want to upset that.
No,
You
kindly,
received
that
it
is not
under.
there, my lord.
Which is that
Now
document?
today is not there. I'm not ready.
Today document is not there.
I am not ready, my lord, please.
You are not ready. ಯಾವ page ಅಲ್ಲಿ
Covered by
ಇದೆ
a
document?
Supreme Court judgment.
Next Tuesday, please.
ಏನ್ consent ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
Lords.
Consent ಆದ್ಮೇಲೆ ಅವರು ಮತ್ತೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಳ್ಳಿದ್ದಾರೆ. Kindly see the order sheet 1/4/2025. They made a submission
Page
that
one.
they
ಓದಿಲ್ಲ ಅಂದ್ರೆ ಓದಿಲ್ಲ ಅಂದ್ರೆ
ನಾನು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಹೇಳ್ತೀನಿ.
Page
Next Tuesday.
123. 123.
12th. List on 12th in preliminary hearing.
B group.
No, sir, why sir? ಅವತ್ತು ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ preliminary hearing ಅಲ್ಲೇ ಮುಗಿಸ್ಕೊಂಡು.
ಆಗ್ಬೋದು.
Deeply obliged. Deeply.
ಎಲ್ಲಾರು preliminary hearing ಹಾಕಿ ಅಂತ ಕೇಳದ್ ನೋಡಿದೀನಿ. B group ಹಾಕಿ ಅಂತ ಕೇಳಿದ್ ನೀವೇ. Still number?
5.
Your Lordship, and for
Yes, madam.
and for the petitioner, Your Lordship, I have already taken steps twice for the respondent number 6, Your Lordship.
Who's R6, madam?
Is the one of the allotted.
One of the allotee, Your Lordship. So I may be permitted to take substituted service, Your Lordship. I'm filing an application.
3 times ಆಗಿದ್ಯಾ?
2 times ಆಗಿದೆ, but ನಾನು ಅಡ್ರೆಸ್ ಯಾವ್ದು ಗೊತ್ತಿದೆ ಅದು ಕಳಿಸಿದೀವಿ, Your Lordship. But ಅದನ್ನು ರಾಂಗ್ ಅಡ್ರೆಸ್ ಅಂತ ಬರ್ತದೆ. So I may be permitted to
Yes.
take substitute service. I'm filing an application for this.
The counsel for the petitioner submit steps have been taken twice over to the address that is known and therefore would seek substitute, the service of notice by way of substitute service for the reason so and so is allowed. We take another ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡಿ madam. Madam. Yes. You will get the order. Copy is served on TP Vivekanand. Serve ಮಾಡಿದ್ದೀರಾ? Is generally here. Registry to print the name of TP Vivekanand as appearing for the respondent. Muda ಅಲ್ಲ? Respondent Muda. List on 12th in preliminary hearing.
7 interim order may be
That should be.
7.
For the respondent, I'm sorry, there is some office objection raised on my application seeking for vacating.
Vacating stay.
I had moved, Manoj.
ಎಲ್ಲಿದೆ vacating stay? Yes.
Application ಹಾಕಿದ್ದೀವಿ, some office objections. Sorry, Doctor. By of the interim order, my lords, my auctions have been stayed.
Correct. ಇವ್ರಿಗೆ paper allotment ಕೊಟ್ಟಿದ್ದೀರಾ?
Allotment, there is a sale deed also made in 2013.
Yes, madam.
Correct.
My lords, after 2013, my lords, kindly see, my lords, the first time now they have come back to BDA is in 2025 on 10/7/2025. In between, there is no communication.
ಅದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಡಿ.
Please.
List the matter on 12th in preliminary hearing. Along with the application seeking vacation of the interim order.
Please. And this is the intermittent site. What is being auctioned are all corner sites.
The lodges may kindly see an
Our
extra.
Tuesday, yes.
Please.
Till Tuesday. Get ready. Will not adjourn beyond Tuesday.
I appear for petition on this. My lords, I seek for a passover.
Why you are seeking Passover?
This matter is wherein the lands were acquired in the Banshankri.
See, yes.
Senior is going to be here, my lord. He just held up.
Ready na?
Ready.
Ready.
My lords, I'm ready.
Passover.
Yes.
9.
Yes, Sampath.
Lords, this is an acquisition, my lords, relating to Banshankari 6 stage further extension. My lords, may I just pass on, my lords, some judgments and.
Synopsis ಇದೆಯಾ?
ಮಾಡಿದ್ದೀನಿ. And regarding the extent of properties acquired, what possession was taken and all these aspects, I made a short note, my lords. Substantial development has not taken place. That's the ground, my lords, I pleaded. My lords, may kindly see, my lords, page 1. Here, my lords, a summary with regard to the acquisition of properties falling within Talgatpura I have detailed, my lords.
ಯಾವ್ದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ WP 48790?
My lords, there are several, that is the first.
Come to just Devdas order 21/3/2025.
21/3, my lords.
ಇಲ್ವಾ?
All these, my lords, I have just given a
all these order ಏನಿದೆ ನೋಡಿ. 21/3/2025.
Let's have annexed that copy of the writ petition. That is at page 20.
ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದಾರೋ ಇಲ್ವೋ ಅಂತ ನೋಡಕ್ ಹೇಳಿ. ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, ಅದನ್ನೇ ನಾನು ರಿಟ್ ಅಪೀಲ್ ಕಾಪಿನೂ ಹಾಕಿದ್ದೀನಿ.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸರ್.
ಸರಿ ಹೇಳಿ ಅಷ್ಟೇ.
Request you to please pass over this.
ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಅದ್ರಾಗಲ್ಲ.
Could you please fix the date tomorrow itself? We are ready to take it.
It can't be according to your convenience.
Sorry, my lords, as per.
Let's page 21, my lords, is for first of the writ petitions. That was, my lords, challenge this Banshankari's further extension, my lords. Page 1, my lords. My lords, here, my lords, the acquisition notification that was challenged was the same as that has been challenged in this writ petition, my lords.
What is your claim now?
My lords, they have not taken possession of my land, my lords. They have not developed it.
No possession taken?
No possession taken, my lords. My lords, may kindly see, my lords, there is a sketch that I filed along with the writ petition, my lords. Annexure F.
Yes, who appears the BDA?
It's,
Krishnan.
Annexure F, my lords, page 25 to the writ petition.
Page 25.
25, my lords, annexure F.
ಇದೇನ್ ಕೊಟ್ಟು? ಇದೆ ರಿಟ್ ಪಿಟಿಷನ್?
Sketch is amended writ petition.
ಅದರಲ್ಲಿ ಏನ್ ಪೇಜ್?
25, my lords.
Prayer.
I'm sorry, my lords, page numbers tally ಆಗ್ತದೆ. But it's, the annexed here F is
At the
the,
request of the council appearing for the respondent BDA, as a last chance, list this matter on 12th and preliminary hearing. It is made clear, no further adjournment would be granted in the matter.
Much obliged, my lord.
Interim order idೆಯಾ? Interim order idೆಯಾ?
ಇಲ್ಲ sir.
Yes, next.
10.
Yes, sir.
My lords, may permit me to file this memo.
What is that?
My lords, this is the final draft of the award, which was issued in 2018. I'll only put it in perspective with very 4 facts, my lords.
ಅದು senior ಮುಗಿಸ್ಬಿಡ್ಲಿ ತಾಳಿ.
I was under the impression that he had argued, my lords. I was only to answer whether award is made or
This
not.
was- this matter
My
was
lords have heard
Yes,
it.
yes.
My lords have heard it.
Last time I said
Award is not made. We made a statement that award is made. Then they filed an endorsement saying award is not made, which is right. Now that is why, my lords, in 2004, preliminary notification, 6 is final notification. 2009, first of the draft awards are made, my lords. Draft award.
ಆಮೇಲೆ
And then, my lords, it is processed. This is the final award which is approved. My lords may please.
dated.
2018. This is a common award for the entire extent of land. Please come to page number 23.
General award.
This is general award for vast extents of land commonly made. There is a 23 page number. My lords may have one. I just want to show something, please.
Yes.
Page number 23, internal page, my lords,
Yes.
at serial number 9.
ಅಧಿಸೂಚನೆ ಪ್ರಕಾರ.
Please, my lords. Mogahalli, this is the petitioner's land. Because of the pendency of this writ petition, where there was a status quo order from 2016, the award is not made, is what they are saying. Now, my lords, the rest of the question that needs to be answered is, from 2006 to 2016, when they filed the writ petition, because from there was a restraining order for us to make an award as such. Would that fall under the parameter of reasonable period? Because, my lords, there is no timeline prescribed.
Delay.
There is no timeline prescribed in our statute. The full court judgment, everything says, my lords, that.
Yes, sir. ನೋಡಿದೆ.
7/12/2005, my lord, is the preliminary notification.
Yes.
31/8/2006 is the final notification. These are lands, my lord, it is not within BDA. It is situated in Srirangpatna, Mogahalli, Belugol Hobli. And they don't pass any award, my lord, till date. Last time I made a submission, no award is passed. My learned friend said, no, award is already passed, which is not correct.
No, ಇದರಲ್ಲಿ ಜನರಲ್ ಅವಾರ್ಡ್ ಇದು.
General award ಮಾಡಿ 2018 ನಮಗೆ award ಮಾಡಲಿಲ್ಲ.
ಅದು because of the pendency of this petition.
So, but I filed the petition in 2016.
ಅವಾರ್ಡ್ ಮಾಡಿದ್ರೆ 2018 ಗೆ.
ಅದೇ ಅದಕ್ಕೋಸ್ಕರ
ಇದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಇತ್ತಂತೆ.
ಇದೆ, my lords. My lords may see, there is a status quo.
ಸ್ಟೇಟಸ್ ಕೋ ಇದ್ರೆ ಮತ್ತೆ ಅವಾರ್ಡ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಸ್ಟೇಟಸ್ ಕೋ with regard to this land, they could have asked for vacating of the order and do it, but they did not do it. 2016 till date, they have not even moved the court. They have not, from 2006 onwards till 2016, let us take 2016 is the status quo order also. Nearly 1 decade, they have not done anything.
You're still in possession?
I'm the award ಮಾಡ್ದಲೇ
ಅಲ್ಲ 18 ಅವಾರ್ಡ್ ಈಗ ಇವ್ರದ್ದು ಕೇಸಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅವಾರ್ಡ್.
Because of this petition pendency, we have not done. The draft award only I have shown where there is a specific observation.
ಒಂದು ನಿಮಿಷ. ಡ್ರಾಫ್ಟ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ.
Not draft, my lords, the final award only.
Where is it? Draft award ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Draft award, my lords, in terms
Your
of.
land draft award dated ಏನು?
Dated is 2009, my lords.
Where is the lands of these petitioners in the draft award? It was convenient to put that in the final award, but where is the draft award?
Page number. My lords, this is a memo of the draft award. Draft award ಕೊಟ್ಟಿರಲಿಲ್ಲ ನಾವು.
ಅದರಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ. Page number 3, my lords may have serial number 19. It's a common award made, my lords.
That is 45/P1.
And 2 and 3.
1P and 2 and 3.
And at serial number 37, there is survey number 100. It was there, my lords. However, it was not approved. It was approved later in 2018, but the time of the approval, this writ petition was filed, due to which they have observed that.
Yes, sir.
2009 is the draft award, which they have kept it in their file.
2018 is the final award.
2018, 2016, after I filed the petition, they pass a general award. No, my lord, if they pass an award, my lord, this is another argument in my favor, because if you pass an award, general award, draft award, and keep it in your file and don't do anything, do they really need the land at all? In this regard, my lord, I have produced
Yes,
even 2 judgments on the last occasion.
Illide.
Serial number 2 and 3, my lord, is a case of abandonment. They cannot, no doubt, my lord, this concept of this 2 years is not applicable. That doesn't mean they cannot sit over it for really 10 to 15 years. They cannot sit over it.
KDB, na?
Please, Lords, KD.
KDB. And this land is in Srirangpatna. It is not as if, my lord, near Belagola Hobli. 3 items of land. They are just locking the land and keep it as it is. Keep it as it is. They are only creating a land bank. This is the view taken by Justice Vinit Sharan, my lord, in the case of Parsarthi, in the case of BDA.
Yes.
Lords,
Question,
purport,
Lord, in this judgment, at page 17,
Serial number 2 or 3?
2. At page 18, para 17.
Yes.
I mean, that is page 34, my lord. I'm sorry. Para 17.
Yes, I am there.
Yeah. In the instant case, the facts are very pertinent. Though the preliminary notification was issued under 28.1, on 25.871, declaration and final notification under 28.4 was issued on 23.272. No award had been passed till date, even though
Abandonment.
Yes. There has been no development as because no award has been made. In the circumstance, even without reference to 24, to having regard to the facts which emerge in the present case, we hold that there is abandonment of the acquisition by state government as well as appellants. This third judgment also, my lord, at page 37.
Yes, division bench.
Para 13.
This is Alokara there.
Preliminary notification.
Para?
Para 13 at page 57. Para 12 and 13. They have relied again on Ramchand's case. The first serial number 1, my lord, your lordships are aware that concept of reasonable time in Ramchand's case. Para 12, 13 and
Yes.
14. And 15 also, my lord.
Well, Lords, all these judgments have culminated into a full court judgment. This issue, whether award is made or no, at the Gulbarga High Court, when 2 judgments, please, my Lords. The full court judgment was pleased to hold that.
Full bench.
Full bench, my sincere apologies. Yes. Full bench was pleased to hold, my Lords, that in the absence of there being, in the absence of there being, there being no timeline as such, my Lords, reasonable period should be construed. Reasonable period would be dependent on facts and circumstances of each of the case. And here, my lords, there is 200 acres of acquisition happening. Face by face, they have made the award. So what this petition needs to address, my lords, by the hands of this honorable court is whether this was a phased manner and whether it was reasonable period from 2009 when the draft was filed till 2016.
Even both the judgments are said to be correct here.
Please, my lord, what the full court rather held, my lords, was it would depend on the facts and circumstances of each case and the hold madidru. The reference was repelled rather, saying that we don't need to address this reference as such, but they have dealt with, my lords, to say that these 2 judgments are on a different footing and facts. And what they differentiate
So
is,
we'll decide this also on the facts.
please,
Heard, deserved.
please, deeply obliged. Deeply obliged, my lords.
Yes. Intermodal ideyala, sir?
Ide, my lords. That is why award is not made. Please.
Intermodal subsisting will continue till the disposal of the petition. Yes.
Obliged.
So it's become a habit to ask intermodal idea. ಇವರಂತೂ ಹೇಳಲ್ಲ ಆಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮೂವ್ ಮಾಡ್ತಾರೆ.
IA for amendment of the prayer, my lord. Last occasion, my lordship directed to amend the prayer.
ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, ಇನ್ನು ಮಾಡಬೇಕು. IA ಹಾಕೊಂಡಿದ್ದೇನೆ. IA has to be.
ಎಲ್ಲಿದೆ IA amendment? Yes.
Application may be allotment, I may be permitted to file additional statement.
Learned Counsel for the IA order on IA 2 of 2025. For the reasons indicated in the affidavit accompanying the application, the IA stands allowed the petitioner to file an amended amended petition. Rebut is reserved to the respondent, second respondent, Mudala.
Yes, ma'am.
Muda to file objections to the amended petition as well. List the matter on 2 weeks, Akka? List the matter on 2nd September.
Please.
Next.
Preliminary hearing list ಅಲ್ಲಿ
Intermodal ಇದೆಯಾ?
ಇಲ್ಲ. Preliminary hearing list ಅಲ್ಲಿ.
Preliminary.
Much.
Dispose, ಇಲ್ಲ 2019-18 ಎಲ್ಲ preliminary hearing. 25 ಇದ್ರೆ ಮಾತ್ರ big group ಹಾಕಿರ್ತೀವಿ. Yes.
Since 1981, we are in the possession of the property. We have challenged the final
Murugesh,
notification.
Yes.
But a suit is filed. In the suit, my lord, it has been held that he is not in possession. He files a suit
ಅಲ್ಲ,
against.
he's a subsequent purchaser.
He is a subsequent purchase.
Subsequent purchaser. But in the suit, my lord, suit dismissed on the ground that I am not challenged the notification.
No, when did you purchase, sir?
19, my said it in the year 2008. my lord, 2008.
Notification?
But prior to that, 19.
Preliminary notification.
Notification 1969, my lord. But till day, I am in the possession of the property. And in the suit.
Law is goaded against you.
I'll produce the depositions of the suit, my lords. In the suit, BD officials admitted that they are not taken possession. Only on the ground that I am not challenged the preliminary.
Produce money, but legally difficult.
I'll produce the suit document.
I could do that.
The suit OS is filed, but the injunction suit is, declaration injunction suit is rejected, against which an appeal is filed. RFA is pending. Now, my lord, he files a present writ petition during the pendency.
Subject, you take every order in those proceedings. We'll dispose this subject to outcome of the
suit
proceedings that are pending. If there is any order by the, in the RFA, na?
RFA.
In the RFA, you can, which is that RFA number?
No, RSA 2231 of 2018.
Division bench, na?
Please.
2231 of 2018.
Pending.
Please, ma'am.
The petitioner is before this court seeking the following prayer. Heard sounds. The challenge by the petitioner is to the notification dated 15/7/1971, the final notification issued by the respondent Bangalore Development Authority. The petitioner is the purchaser of the property which has become the subject matter of acquisition on 11/2/2008. Pursuant to the said purchase, the petitioner institutes OS 1757 of 2012, which is now pending before the division bench of this court in RFA 2232 of 2018, seeking to set aside the dismissal of the OS 1757 of 2012. The learned counsel for the petitioner submits that if the grievance of the petitioner be permitted to be urged before the court hearing RFA 2231 of 2018 and make the rights of the petitioner subject to the outcome of the RFA. Since the entire issue is at large before the court division bench hearing RFA 2231 of 2018, I deem it appropriate to dispose the subject petition, reserving liberty to the petitioner to urge all the contentions before the said court.
One aspect. Lord, in this suit, my lord, Lordship need not permit them to urge as by order, because we take up a ground of a maintainability of a suit before the trial court. And
It is dismissed on maintainability, is it?
It is dismissed on maintainability.
Acquisition you challenge before the civil court. Then
Not the acquisition, even for the
It is
possession.
an injunction suit, my
There's
lord.
an observation that they are not in a possession of the property.
let the court decide.
Lord, if your lordship were
Allah,
to keep open.
let him urge all the.
All
Sir,
the
I cannot say division bench should consider or not. I am only saying is at liberty to urge, that's all. Yes. Hinಗ್ ಮಾಡೋಣ, liberty to urge ಇಲ್ಲದು. All the rights of the petitioners would be the outcome of the RFA 2231 of 2008. ಅಷ್ಟು ಸಾಕು. Yes.
Good.
Ordered according.
I'll not argue much on this matter.
Then-
I'm only seeking, my lord, consider the case of the
Yes,
petitioner.
reconsider.
Lord, to reconsider, my lord, it is by the state government which has to do it, my lord. The fact that, my lord, he has earlier suffered an order of challenge to the acquisition, even 27 was negated, the endorsements were
Then
adjudicated.
what reconsideration
Then
now?
for this is, my lord, there are, my lord, the dwelling houses present, and my lord, the opportunity of hearing was not offered. Only on that ground, my lord,
They
I'm
come
before
on
this
the
court.
38D, Lord, let them exercise those powers. 38D is virtually less.
38D at
Yes.
least. I think you
Let them reconsider my case.
their representation, let the
The
reconsider.
representation ಏನಿಲ್ಲ, my lord, but
ಮತ್ತೆ?
ಅಲ್ಲ,
They'll have to
consider
make an
the case.
application under
We'll make an
38D.
application.
Make an application.
Please, let them reconsider, my lord, after giving an opportunity for the petitioners for this reason.
Whether
There's
38D or whatever it is, you reconsider.
There are a lot of dwelling houses, my lord, left. Opportunity is given for them to hear it insofar as the. writ
Dwelling
proceedings are
houses, Lord, always come within 38D.
concerned. ಅಲ್ಲ,
38D. ಅದನ್ನ ನೀವು ಕೊಡಿ application or consider ಮಾಡಿ.
please, my lord, please.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner heard so and so ಮಾಡಿ. ಇದು ಯಾವ್ದು acquisition ಇದು?
I just make one other submission. After, my lord, of filing of the petition, the survey number has been renumbered as 195/2. It was earlier
ಅದು ಕೊಟ್ಟಿರಿ,
195.
yes.
I just-
ಅದು ಅವ್ರು ಕೊಟ್ಟಿರಿ, that's all right.
That is also a dispute, my lord, because in this sale deed which they have produced, it is one survey number 194, which may kindly refer to, my lord, I have taken
part
up.
2 ಆಯ್ತದು.
ಅಲ್ಲ,
So,
195
annexure
ಆಗ್ಬಿಡ್ತು. 194 ಇಂದ 195 ಆಗ್ಬಿಡ್ತು. That is what is in the petition. 194 is the
ಅದು ಅಲ್ಲೇ
sale deed.
ಕೊಟ್ಕೊಳ್ಳಿ.
Please.
We will not put that here. ಅದಲ್ಲೇ ಕೊಡಿ. A notification comes to be issued on 20th July 1978 for the purpose of formation of Hennur Bellary Road first stage. Final notification thereon is issued on 14/3/1985. The pursuant to the said notification, a subsequent notification in subsection 2 of section 16 of the Land Acquisition Act was issued. The learned counsel for the petitioner submits that the said notification was not in accordance with law. The challenge was made on the said ground before this court in coordinate bench of this court in writ petition 4589 of 2020. The writ petition comes to be rejected. The writ petition comes to be disposed by reserving liberty to the petitioner to file a separate petition in the light of the endorsement. Comprehensive petition. New writ petition. The result of the said liberty so granted by the coordinate bench is the subject petition. The learned counsel for the petitioner would submit that the petitioners have houses in the property which has become the subject matter of the acquisition, dwelling houses, and are staying in those houses even as on date, which is disputed by the learned counsel appearing for the respondent.
Not only houses, but there are several structures. It can be mentioned.
Houses and several
There's a
structures.
mosque also, my lord, there.
The learned counsel for the respondent would dispute the position. The learned counsel of the petitioner would now restrict his submission to submission of an application, venting out the grievance of the petitioners to the respondent BDA, and the BDA and the direction to the BDA to consider the same in accordance with law. The learned counsel Murugesh Charati would project the dismissal of the writ petition on the earlier occasion and contend that the petitioners have no right to seek any reconsideration of their claims. Be that as it may, in the light of the restriction of the prayer for consideration of the case of the petitioners on a separate application stroke representation to be submitted by the petitioners, in the light of the fact that several structures are admittedly in the property and the petitioners are living in those, petitioner is living, ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
There's one petition, but now what is
And the legal representatives of the petitioner are residing in the said premises. I deem it appropriate to reserve liberty to these petitioners to submit an application / representation to the respondents, venting out their grievance, to which the BDA shall pass necessary orders strictly in consonance with law. Within an outer limit of 12 weeks, 6 months.
6 months.
Outer limit of 6 months from the date of receipt of the copy of the application stroke representation to the BDA. Till such time, the BDA shall not dispossess these petitioners if they are not already dispossessed.
One request. The lordship has said admittedly residing in the petition.
annexure RL ಅವರೇ ಹೇಳಿದ್ದಾರೆ. There is a note sheet.
ಅದು admittedly ತೆಗೆಯೋಣ ಬಿಡಿ ತೊಂದ್ರೆ.
Earlier on
Because
litigation also
194 was the survey number, they claim 195.
admittedly ತೆಗೆದ್ಬಿಡಿ. are residing at, are said to be residing at the mine.
Oblige. The land of the petitioner, my lord, while widening the road, the petitioner's land was taken. And petitioner has lost about, in one side 10 guntas and another 11
Yes,
guntas
sir.
of land.
My lord, we have not utilized any of the land of the petitioner survey, my lord. It is only that we are carrying out the improvement work as stated in my statement of objection, para number 6, my lord. We are
Where is your land situated? sir?
Survey number 35, 10 guntas of land.
Objections hakidira?
ಹಾಕಿದೀವಿ.
And
We are only
on both sides of the land, petitioner's land is there. And
No, if they are utilizing, they will pay compensation.
they have not been paying, that's what.
Alla, if they are utilizing, they will.
They have utilized, my lord.
How do you, will,
They have formed the road, my lord. See, this is the one, this, my lord.
survey number ಏನು sir ನಿಮ್ದು?
survey number 35, 37, my lord.
1 minute.
My lord,
ಎಲ್ಲಿದೆ ಸರ್ವೆ ನಂಬರ್?
Survey number.
ಏನ್ ಕೊಡಿ ಅದು?
ಇದು road map ತರುತ್ತೆ. Existing road was very narrow, my lord. So what is available for
Your land ಎಲ್ಲಿದೆ?
It is marked, my lord. It is here, my lord. We are only at the edge of his property, and our property which belongs to the state highway. We are making a division, means we are making a road, my lord. We are not utilizing any inch of the land of the petitioners here.
My land is not there now. On account of the formation of road, my
land is gone?
Yes, my lord, land is gone.
Survey may be conducted, my lord, if we are utilizing that survey.
This is the one under Right to Information Act they have given. That Gandesi survey number 35 ಹಾಗೂ 37ರಲ್ಲಿ ರಾಜ ಹೆದ್ದಾರಿ ನಂಬರ್ 7 ಹಾದು ಹೋಗಿದ್ದು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ ಯಾವುದೇ ಭೂ ಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡಿರುವುದಿಲ್ಲ. This is what they say.
We are not utilizing.
That in the said survey number, land has been, the road has been formed. They again.
Where is the formation of road? On which survey number did
We have not formed.
In which survey number did you say?
No, my lord. We have not formed any road in any survey number, my lord. It is only our part of the.
ಅದು your part ಅಂದ್ರೆ ಎಲ್ಲಿ ಅದು?
Next to the survey number 37 and 35, my lord, there is a portion which is left out as a road itself, my lord. That portion we have formed the road.
In the objection statement, they have only stated
Maybe look
no
into,
material is
one-
placed before the court, my lord.
One sketch may be looked into, my lord. Previous road was narrow, my lord. We have removed all those things and we are making up the improvement work in the road, my lord. The yellow portion.
Survey number 37 ಯಾರ್ದು?
37 belongs to the petitioner, my lord.
37
Also
also 35
on both sides of the road.
37, 35 both belong to you.
Yes, my lord. 10 guntas and 11 guntas of land they have taken away for the formation of the road.
Black color is our boundary, my lord. The narrow road was there in that orange, means light reddish color.
ಎಷ್ಟು ಎಕರೆ ಇದು?
Survey number 35, 10 guntas.
35, 10 guntas.
Yes, and survey number 37 bar, total measure 1 acre 2 gunta, out of that 11 guntas has been taken.
We are only barricading.
You produce a Google Earth image
Yes, ma'am.
of pre and post.
Now, maybe
Now-
tomorrow, my lord.
Tomorrow, in Ratri Google Earth ತಗೊಂಬರ್ತೀನಿ.
ಇಲ್ಲ, ನಾನು ಕಲರ್
Yes.
ಪ್ರಿಂಟ್ ಕೊಡಲ್ಲ.
The petitioner, the petitioners, ಒಬ್ರೇನಾ? The petitioner is before the court claiming to be aggrieved by the utilization of the property of the petitioner in survey number 37 and 35, both measuring 11 and 21 guntas respectively, for the purpose of widening of road. It is the contention of the learned counsel for the petitioner that the road that existed prior to the widening of the road is no longer in existence, as the road is formed by the state without issuing any notice to the petitioner nor paying any compensation. The learned counsel, learned HCGP would submit that the petitioner's property or 10 guntas of land or 21 guntas of land on the either side of the road is not even touched, and the road is widened. Utilizing the land belonging to the state and not land belonging to any private property. The respondent, since in the light of the said disputed question, I deem it appropriate to direct ಯಾರೆಲ್ಲ ADLR
ADLR.
ಅವ್ರು ನಿಮ್ ಪರವಾಗೇ ಕೊಡ್ತಾರೆ.
ಅದಕ್ಕೆ Google Earth ನಾನು produce
ADLR to conduct a survey of the property, survey of the road with the help of Google Earth images, which would depict the road or the property that was present prior to the formation of the road and the present position of the property after the formation of the road. The Google Earth images be produced along with the report of survey on the next date of hearing.
My lord, survey of the said survey number, my lord, because road
survey of survey number, survey of 37 and 35. 37 and 35, that is said to be belonging to the petitioner. List the matter. The survey shall be conducted and a report be placed before the court on the next date. List on 22nd.
My lord, one more week, my lord, because it's an holiday.
Holiday?
23rd and
Aitha, list on 2nd September.
Much blessed.
ಮತ್ತೆ ನೀವು ಆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಹೇಳಿಲ್ಲ, ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಹೇಳಿಲ್ಲ. ಯು ಆರ್ ಅ ಸ್ಟೇಟ್, ಯು ಶುಡ್ ಕೋಆರ್ಡಿನೇಟ್ ವಿತ್ ಆಲ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, ಗೆಟ್ ಇಟ್ ಡನ್. ಅದ್ರಲ್ಲಿ ಏನು ಹೇಳಿರಲ್ಲ, BWSSB ಅವ್ರು ನಮ್ಮ ಮಾತು ಕೇಳಲ್ಲ. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್? Yes, next.
I praise time, my lord. Due to some medical reasons, my seniors.
Praise time, grants time. Yes. How much time?
Next week, my lord, 12th or 13th.
Learned counsel for the petitioner seeks time on the score that the arguing counsel is indisposed today. List the matter on 19th.
Landlocked property has been subject matter of the.
Landlocked property. Yes.
Committee has recommended that the same request to be deleted in view of the fact that it's surrounded by the lands which are not subject matter of the acquisition proceedings.
The last set of hearing.
Wants it to become land unlocked property. Yes.
Last time, my lord, the learned counsel for the petitioner submitted that the matter is covered by 2 judgments of the coordinate bench of your lordship.
Correct.
My lord, we have gone through the judgment. My lord, there is a case, my lord, where in Arkavati layout, my lords, the committee was constituted.
ಈಗ landlocked property ಅಂತಂದ್ರೆ ನೀವು ಏನ್ ಮಾಡ್ತೀರಾ ಅದರಲ್ಲಿ?
Committee.
ಅವ್ರು ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
My lords, as per the judgment of this honorable court, once the committee makes a recommendation, BD has to take a decision recommended to the state. Then state has to decide, my lord, whether.
ಈಗ ಏನಾಗಿದೆ?
Now committee has only recommended. The BD
State has not taken a
not
decision.
a decision. The
Where is the recommendation? H.
Now the
103, my lord.
Keshav Narayan committee then.
Yes, please, my lord.
Justice Keshav Narayan. Where is the recommendation here?
Recommendation is at page 103, my lord.
Right, begins at 103.
Yes, my lord.
155.
What is the recommendation ultimately?
Recommendation, the operative portion is at
155.
155, my lord. With respect to the consideration as to this land, my lord would find at page number 150, my lord. Roman 4.
Yes.
Land bearing 89/1 measuring 13 guntas is bounded on east by 87, on the west by 90, north by 1.
This paragraph is your land?
My land is 89/1, my lord. Last 2 lines, thus, this small piece of land measuring 13 guntas only is surrounded on 3 sides by unacquired lands. There is no development activity carried on by the BDA in any of the lands adjacent to this land. It's also an isolated pocket. For the easy convenience, my lord, this is the sketch.
ಆಯ್ತು, recommendation ಮಾಡಿದ್ದಾರೆ already. What is the state doing?
Now Now the order was passed by this honorable court already in this regard, my lord. The order dated 13/2/2025 may be kindly perused in this petition. 13/2/2025. ಅಲ್ಲ ಈ ಆರ್ಡರ್
13/2/2025. Pass a
Last-
resolution as the case may be upon the recommendation. What is the resolution you have? BDA.
My lord, we are awaiting the report for the entire village, my lord. We have to wait for the entire village.
No.
The report
What
has
happens to this direction within 4
Lord,
weeks from today?
from, my lord, the entire scheme, my lord.
That's
is
all
that-
right. What happens to this direction?
My lord, we'll have to act upon this recommendation, my lord, and take a decision on whether we'll have to let go of the land or not, my lord, and then
Sir,
make a recommendation to the state.
There is an order passed by the court, by the coordinate bench in this petition. Have you seen that?
My lord, at that point of time, my lord, multiple matters.
Wait, whatever, sir. There is an order that is 13/2/2025. Pending consideration of the claims and counterclaims, respondent BDA shall pass appropriate order resolution as the case would upon recommendation of so and so. Thereafter, the state shall pass orders within 4 weeks thereafter. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
May I submit this, my lord? As on that date, lordship may kindly see, multiple matters were connected with this
What
petition.
is that you have done in this? I am asking, plain and simple.
I just submitted, my lord. On that day, my lords, on 13/2/25, multiple matters were connected along
Not
with this
multiple,
petition.
my lord.
I just. This
I'll get back to you,
recommendation, my lord,
Radha.
this matter pertained, this order pertained to, my lord, matter in WP number 15096 of 2024, my lord, where we have gone ahead and made a recommendation to the state in that matter saying that the land is required for litigation, acquisition. And then, my lord, the state was directed, my lord, what will you do about the recommendation? Take a decision and let the honorable court know. In this matter, my lord, since the committee is yet to make its recommendation for the entire village, we have to await the report for the entire village, my lord. The
You have
reason
told
is this,
the
my lord.
court.
The survey number, my
You
lord,
should have told the coordinate bench.
it pertained in that particular petition on that day, my lord.
ಇದ್ರಲ್ಲೂ ಆರ್ಡರ್ ಇದೆಯಾ ಇಲ್ವಾ? What is this
Connect
question?
ಆಯ್ತಲ್ಲ, ಅದಕ್ಕಾಗಿ ಬಂತು ಸ್ವಾಮಿ ಆರ್ಡರ್.
ಅದಕ್ಕಾಗಿ ಬಂದಿದ್ದೀರಿ, ಏನ್ ಮಾಡಿದ್ದೀರಾ ಇದು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ?
Now, my lord, I am required to wait for the report of the entire village. The reason, my lord, is this. May I submit this, my lord?
Have you said so while passing this, or while the coordinate bench passed the order?
Lord, it did not, my lord, at that point of time, my lord, matter because it was for a different village, Kempapura village. Lord, the reason is this, my lord. I am required, my lord, to see, my lord, if
ಈಗ
the
ಇದ್ರಲ್ಲಿ
acquisition, my lord.
ಇದು ಕಂಪ್ಲೈ ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
We'll have to consider the recommendation. My lord. We'll consider it. We'll consider.
You have to.
2 weeks time, I kindly be granted.
This
my lord.
court on the coordinate bench of this court on 13/2/2025 had passed the following order. 4 weeks time was granted from 13/2/2025 for the BDA to pass a resolution concerning the subject land on the recommendation of the Justice Keshav Narayan Committee. And thereafter the state was directed to pass appropriate orders within 4 weeks. The 4 weeks are long gone. The BDA is yet to pass any order. Therefore, finally 2 weeks time is granted to comply with the order dated 13/2/2025, failing which adverse inference would be drawn against the BDA.
My lord, if my lord may kindly appreciate this. If my lord, if I'm required to wait for the report for the entire village, my lord, I cannot come.
ಅದನ್ನೇ ಹೇಳಿ, whatever you want to
Please,
say,
my
you say.
May
Yes.
make one submission.
You can't just ignore the orders and be quiet.
In fact, as per the decision of the dishonorable court, once the fact-finding committee recommends, then the BDA cannot sit over the judgment of.
No, that is why this, if that finding is rendered, it would impact so many cases.
Yes, my lord.
So we'll render it carefully. Yes. 13th, list on 29th. Yes.
Pleasure.
Serial number 17, Lord, the lordships have directed me to secure the records from the BMTF. Lordship may accommodate me by a week's time.
BMTF ಹತ್ರ ಇದೆ ಅಂತ ಹೇಳಿ.
Direction ಇಲ್ಲ. There is no such direction.
Last time, your lordships have passed a detailed order saying that without looking into those documents, no decision.
ಅದೇ ರಿಮೈನಿಂಗ್ 13 ಸೇಲ್ ಡೀಡ್ಸ್. ಇದು DL ಜಗದೀಶ್ ಅವರು.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, we contend that there is a grant in our favor. Now they have passed an award also in our favor.
ಅದೇನೋ ಫೋರ್ಜರಿ ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಫೋರ್ಜ್ಡ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ, ಫೋರ್ಡ್ ಅಂತ ಯಾರು ಹೇಳೇ ಇಲ್ವಲ್ಲ. BMTF ಕೊಟ್ಟಿದೀವಿ ಅಂತಾರೆ. BMTF has not.
BMTF in the records, ಅದಕ್ಕೆ
ಏನು ನಮ್ಮ ಮೇಲೆ ಏನು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ. And I have produced in my rejoinder, I have produced the grant records also.
Those
Kindly see the
initiation of
rejoinder.
the, I'm informed.
Yes, sir.
Rejoinder, ತಾವು rejoinder ನೋಡಿದ್ರೆ
Rejoinder page.
At page 5 is the grant register record. It's a certificate copy we have produced. Annexure J, page 5 of the rejoinder. This is the grant register Hanumaya, who is the husband of the present petitioner. Then in the next page, my lord, that is at page annexure K, is the record of rights. Then annexure L is the mutation records.
ಎಲ್ಲ ಇವ್ರ ಹೆಸರಲ್ಲೇ ಇದೆ.
ಇಲ್ಲ, ಅದೇ allegation. Last time your lordship, I read out to your lordships in the statement of objection. The allegation is that the revenue authorities, in connivance with the revenue authorities, the documents are created.
If you don't get it by the next week, we will allow the petition.
Well, one more submission, my lord. They have asked to file an affidavit that they have not executed sale deed after the complaint is filed. They have filed an affidavit. My lord. They have filed a wrong affidavit. I don't want to say false affidavit. They have filed a wrong affidavit because they say after the complaint is filed, we have not registered anta ಹೇಳ್ತಾರೆ. Whereas the complaint is dated 17/9/2019.
ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದು ಆಮೇಲೆ
ಆಮೇಲೆ ನಮಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಸೆಂಬರ್ 19. Sale deed is registered on 12/12/2019.
Where is the affidavit?
Lord, their affidavit, filed by one Umesh. Affidavit filed on.
ಇಲ್ಲಿದೆ. Has not allotted or executed
Now
sale deeds
kindly
in.
see, my lord, in the statement of objection, page.
What we meant to say is, my lord, after this complaint has come, we have not taken any decision.
PDA
That is what.
ಇಲ್ಲ ಅದು ಏನ್ ವೇಗ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀರಾ, ಯಾರಿಗೂ ಗೊತ್ತಾಗ್ಬಾರ್ದು ಏನ್ ಮಾಡಿದ್ದೀರಾ ನೀವು.
My apologies.
What is this?
My
page 60.
Pursuant to the directions of this court, the respondent, additional land acquisition officer 1 Umesh J has filed an affidavit. A perusal at the affidavit would clearly indicate that it is so vague as vagueness could be. There is neither a date indicated as to when they stopped allotting or executing sale deeds, nor have they done after receipt of the complaint. After the said affidavit, an order is passed by this court on 22/7/2025, which reads as follows. The learned counsel Murgesh Charati seeks a week's time, yet again to comply with the order dated 22/7/2025. The learned senior counsel, Shri Ashok Harnalli, submits that all the documents that are necessary, all the grant documents and the subsequent to grant documents are all in the name of the husband of the petitioner. Therefore, the BDA cannot now say that that there is fraud played and declined to register the sale deeds as sought in the prayer. The learned senior counsel will further submit that if the records are with BMTF, no proceedings are instituted by the BMTF as on today, as the petitioner has not received any notice. In the light of those submissions, if the order dated 22/7/2025 would not be complied by the next date, the court would be left with no option to allow the petition. List the matter on 19th.
Please.
Yes.
Number 18.
For the petitioner, my lord. But I seek a week's adjournment to file my rejoinder, my lord.
25 alva.
Request.
Learned counsel for the
14th, my lord.
petitioner seeks a week's time to file rejoinder statement to the statement of objection so filed. List the matter on 19th.
Grateful.
19.
Interim order. Interim order continue ಮಾಡಿ.
So in 2007, my lord, the KIDB acquires 1 acre 12 guntas of land. To date, my lord, compensation is not paid.
Yes, sir.
Suits are pending, several suits.
Suits are pending. Instituted by whom?
Other parties where the petitions of parties there. My submission is that, my lord, to put a quietus The plaintiff has not made a party here.
Who is not made a party?
Plaintiff who had filed a suit.
Who is the plaintiff there?
Lord, the children of my vendor, I purchased a property in 1957.
1957.
Acquisition is in 2007. Suits are filed in 2017 and 21. After the acquisition is concluded. But that will not,
No, this should stop because suits are being filed after compensation
Therefore,
determined.
my lord,
but the
Position.
AIDB cannot take shelter under the, some suit filed 10 years after the acquisition has taken place.
May I make a submission?
ಯಾವಾಗ ಕೊಡ್ತೀರಾ
May I make
compensation?
a submission? my lord? To avoid all this.
No, I will not direct plaintiff to be made a party. at all.
No, we will
Sir,
permit it.
ಒಂದ್ ನಿಮಿಷ. ಯಾರ್ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡಿದ್ರಿ ನೀವು?
Your land.
ಇವ್ರ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅಕ್ವೈರ್ ಮಾಡಿದ್ದೀಗ?
Uoma ಅಂತ ತೋರಿಸೋದು.
ಉಮಮ್ಮ?
Uoma the plaintiff.
ಉಮಮ್ಮ plaintiff ಬಿಡಿ. How did you come in possession of this property?
1957. I produced page number, my lord, 18 to 24 is the sale deed. Mutation, my lord, is page 25.
Did you purchase this property?
On 22/4/1957.
You're in possession since then?
Yes. I produced the mutation.
Yes, sir. When do you release, sir?
Or else will depart for civil court. my lord.
Huh?
Where suit is pending, we can depart the entire amount. Where let them take. my lord.
ಈಗ 50 ವರ್ಷ ಆದ್ಮೇಲೆ somebody will crop up and say it is their land.
Always, my lord, because if they were made a party, my lord, it's fine. If they are not made a party, my lord, difficulty is that, my lord, because we have to bring to notice on the court that.
ಟೋಟಲ್ ಏನಿದೆ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ಸ್ ಇದೆಯಾ?
Injection.
ಇಲ್ಲ ಏನು
ಮತ್ತೆ
Injections ಇದೆಯಾ? Injection ಇಲ್ವಾ ಅಂತ. Injection ಇಲ್ವಾ ಅಂತ.
ಮತ್ತೆ ಯಾವ ವರ್ಷದ ಸೂಟ್?
2021.
2021.
21.
ವೈ ಕಾಂಪನ್ಸೇಷನ್ ರಿಲೀಸ್ ಮಾಡಕ್ಕೇನು? ವೈ ಆರ್ ಇಂಜಂಕ್ಷನ್ ಇದೆಯಾ? ಲ್ಯಾಂಡ್ ಯುಟಿಲೈಸ್ ಮಾಡಕ್ಕಾಗತ್ತೆ, ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡಕ್ಕಾಗತ್ತೆ, ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಇರೋದೆಲ್ಲ ಬರುತ್ತೆ.
Because, my lord,
When do you release, sir?
from filing the suits.
When do you release compensation? Will now write something.
Madam,
Because ಎಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ ಡಿಟರ್ಮಿನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸೂಟ್ಸ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಆಗುತ್ತೆ.
awards ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ.
ಅವಾರ್ಡ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
ಪ್ರೈಸ್ ಅಡ್ವೈಸರಿ ಕಮಿಟಿ ಮೇಲೆ ಡಿಟರ್ಮಿನ್ ಕನ್ಸೆಂಟ್ ಮೇಲೆ ಅಮೌಂಟ್ಸ್ ಆಗಿದೆ ಅಷ್ಟೇ 21 ಲಕ್ಷ.
ಅವಾರ್ಡ್ ಆಗಿಲ್ವಾ?
ಅವಾರ್ಡ್ ಆಗಿಲ್ಲ. ಅದರಿಂದ ದಟ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್. ಅವಾರ್ಡ್ ಅಗ್ರೀಡ್ my lord, we are depart for civil court.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಸರ್.
Now, if they are agreed, we can depart for reference civil court, my lord. The entire amount, otherwise you have to pass award, then reference has to be sent, it will delay their interest. And they can invest in the FD, my lord, in the civil
ಅವಾರ್ಡ್
court.
ಆಗಿಲ್ಲ ಇನ್ನು.
18 years, 2007 acquisition, possession taken 2008 February.
Award ಆಗಿಲ್ಲ.
ನಿಮ್ದು ಮಾತ್ರನ ಯಾರ್ದು ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
ನಮ್ದು ಮಾತ್ರ.
ಅಲ್ಲ ಬೇರೆಯವ್ರದ್ದು ಎಲ್ಲ
ಯಾವ್ದು ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾಕೆ ಅವಾರ್ಡ್ ಮಾಡಲ್ಲ 18 ಇಯರ್ಸ್ ಆದ್ರೂ?
ಅದರಲ್ಲಿ ಕೆಲವು ಕನ್ಸೆಂಟ್ ಮೇಲೆ ಜಾಸ್ತಿ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.
ನಿಮಗೆ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ರೆ ಅಕ್ವಿಸಿಷನ್ ಸರಿ ಹೋಗೋದು.
ಕನ್ಸೆಂಟ್ ಮೇಲೆ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.
You will take ages to pass awards. ನಿಮಿಷ 2007 final acquisition, final notification, right? 2007. Till today award is not passed. So we are in 2025. 18 years. Our land ಹೋಯ್ತು. ಅಲ್ಲ land ಹೋಯ್ತು.
ಲ್ಯಾಂಡ್ ಹೋಯ್ತು, ಅಕ್ವಿಷನ್ ಚಾಲು ಮಾಡಿಲ್ಲ. ಜಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು ಜಸ್ಟ್ ಲೆಸರ್ ಟೈಮ್ ವೆದರ್ ಆಲ್ ದಿ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಅವಾರ್ಡ್ಸ್ ಆರ್ ಪಾಸ್ ಆರ್ ನಾಟ್, ಆರ್ ಎಲ್ಸ್ ವಿ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್.
No, how is it that you, of course, you will be compensated with interest later, interest and other solatium and other things. But how is it that you take away the land of these people? Don't pass award for 20 years, 25 years.
Under the act, my lord,
There are no limitation under the act.
not that, my lord.
ಅದಕ್ಕೆ
It is a departure class, my lord. Under the act, my position will be taken first, then awards will pass.
ಹೌದು ಸರ್, how long?
I too understand, my lord.
How long, sir?
Yes, my lord, I too understand. In the case of land losers, we must say that it will be settled at the earliest. There is no doubt in that, my lord.
Then what, sir?
That there are 4 or 3 suits are filed in respect of these properties. 3 are already disposed. Another suit is pending. That's the.
They will go on filing suits.
Therefore, my lord, we have no option except to depart.
ಎಲ್ಲಿ ರೆಸ್ಟೋರೆಂಟ್ ಆರ್ಡರ್ ಇದೆಯಾ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ರೆಸ್ಟೋರೆಂಟ್ ಆರ್ಡರ್ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ದಾರೆ ವೈ ಆರ್ ಯು? ಓ ಇದೇನು ಹೋಲಿಯರ್ ದೆನ್ ದಿ ಲಿಟಿಗಂಟ್ ತರ ಏನಿದೆ?
Then, my lord, we will take action.
No, see, this advantage will be taken even if there is no restraint order, you have not released compensation, pass award. There are many cases. If there is an order saying don't release compensation,
Restraint order.
restraint order idre, you are justified in saying. What is justification here?
There is no justification.
18 ವರ್ಷ ಒಬ್ರು ಲ್ಯಾಂಡ್ ಯುಟಿಲೈಸ್ ಮಾಡಿ ತಗೊಂಡು ಆಗೋಗಿದೆ. ಲ್ಯಾಂಡ್ ಇಲ್ಲ ಅವ್ರ ಹತ್ರ, ಕಾಂಪನ್ಸೇಷನ್ ಇಲ್ಲ, ಏನಿಲ್ಲ.
Suppose ಈ ತರ ಕೊಟ್ರೆ ಸೂಟ್ ಇದಾಗ ಕೊಟ್ರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ.
ಏನ್
ಇದಾಗ
suppose?
ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಕೊಡ್ತಾರೆ.
ಸಪೋಸ್ ಸೂಟ್ ಅಲ್ಲಿ ಆತರ ಸಪೋಸ್ ಸೂಟ್ ಇದ್ರೆ ರೆಸ್ಟ್ರೆಂಟ್ ಆರ್ಡರ್ ಇರ್ತಾ ಇತ್ತಲ್ಲಿ. 5 ವರ್ಷದಿಂದ ಅಲ್ಲೇನ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಇದು ಸೆಲ್ಫ್ ರೆಸ್ಟ್ರೆಂಟ್. ಯಾರಿಗೆ ಬೇಕು ಅವು ಕೊಟ್ಬಿಡ್ತೀರಾ ಕಾಂಪನ್ಸೇಷನ್ ಎಲ್ಲ. ಇದು ಯಾವ್ದು ಬೇಡ ಇದನ್ನ ಇಟ್ಕೊಳ್ಳೋದು. ಈಗ ಯಾವ ನೆಕ್ಸ್ಟ್ ಐ ಟೇಕ್ ಇಟ್ ಆನ್ 19th. If nothing comes about, then we'll pass an order. Yes, issue a direction to pass the award.
Or else release the amount, that's all.
That's what we'll see, yes.
Right.
List the matter on 19th in preliminary hearing. The petitioner is before, last bariri adna, heard so and so. The petitioner is before this court seeking a direction to pass an award and fix compensation of the land acquired. The petitioner is in possession of the property pursuant to a sale deed of the year 1957. 40 years thereafter, the land is sought to be acquired by issuance of a preliminary notification in 2007. Finally, avaga.
2007 is final notification, 2211.
Election general, iವರು ರೈಟ್ ಬರೋದು 16 ಅಲ್ಲಿ. ಏಸು ಮುಂದೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ 16 ಅಲ್ಲ ಇವರು
Sorry.
16
RTC ಅಲ್ಲಿ 1 ಎಕರೆ ಅಂತ ಇತ್ತು, that was corrected to 1 acre 12 guntas. Not my right.
It's all right. So and so. The final notification is issued in the year 2007 and it transpires even after 18 years of the issuance of the final notification and taking possession of the lands of the petitioners, the land losers have not got compensation. They have, as no award is passed. The learned counsel P.V. Chandrasekhar representing the board, would
On behalf of others.
representing
Adarsham Limika.
so and so representing the board would seek to contend that that a civil suit is pending and there is a claim on the said property. Therefore, the compensation is not released or award is not passed. Award is not passed, compensation is not released. The suit is instituted in the year 2021, said to be by the grandchildren of the vendor of the petitioner, sale deed of which was executed in the year 1957.
suits for earlier 2 more suits.
Adu dismiss agide.
That's also stated by the
All right, yes. The identical suits were filed claiming right over the property, which have all been dismissed except one suit now.
That is not stated.
In that light,
that is not disclosed in the petition.
all right. In that light, the respondent would submit that there is no warrant to pass an award or compensation. Admittedly, in the suit of the year 2021, upon which the respondent is now wanting to take refuge, has not so and so. There is no restraint order passed, restraining the respondent from passing an award or releasing compensation in favor of the land losers. Since the suit is pending on their own volition, the respondents have not passed the award, which on the face of it is illegal, as the land of these petitioners, as observed herein above, is taken possession of 18 years ago, and after 18 years the petitioners have no land nor compensation for the said land. Therefore, instructions be sought and submissions be made by the 19th, failing which this court would be constrained to pass an order as sought for. Pass an order in terms of the prayer sought for. Next.
Right.
20.
Lord, I beg to appear for the first respondent, national project director.
Project director?
Yes, Lord, I appear for the project director.
Lords, on the last date of hearing, Lords.
The 3 dates, Lord, I just
Order and Lords.
Yes, there was an order, Lord, to produce a document.
Original records
Lords, ನೋಡಿತ order ಮಾಡಿದಿರಿ last.
Lord, my friend will be a little kind with me, Lord. I'm not provision with Kannada, Lord. My friend will be a little kind with me. Lord, may I give your Lordship 4 dates, Lord, just 4 dates, and then I'll take a Lordship to the writ petition.
Notice ಕೊಟ್ಟಿಲ್ಲ.
Their petition.
Their petition, my lord. They have filed a petition, my lord. They have filed an application, my lord, before the deputy commissioner. Thereafter, that application, after the issuings of the notice, National Highway has appeared on 28/9/2022, my lord. Thereafter, at page number 17, my lord.
proceedings ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
17, page number
34
17.
ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂತ ಅವರ ಕಂಟೆಂಟ್.
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಲ್ಲಿದ್ದೀರಾ.
Annexure B may kindly be seen.
ಅದು ಇದನ್ನು ಅಲ್ಲ, ಟೇಕ್ ದಿಸ್ ಕಂಟೆನ್ಷನ್ ದೇರ್.
ಇದರಲ್ಲಿ ಅವರು ಹಿಯರಿಂಗ್ ಮಾಡಿಲ್ಲ, ಏನು ಇಲ್ಲ.
ಅದೇ ದಿಸ್
34 ಅಂತಂದ್ರೆ ಈಗ ನಾವು this order came to be passed on, my lords.
3/1/2024.
24/1/2024. Limitation ಬರುತ್ತೆ. Now I can understand if they hear me and pass orders.
Issued a notice, my lord, which was received in the month of February itself, my lord, by them.
February itself, which February?
February of 2020.
Millard, may I give the dates?
1 minute, sir.
Sorry, sir.
You are on VC, please wait.
Yes, yes.
February 2024 ಅಂತಂದ್ರೆ ಆರ್ಡರ್ ಆಗಿರೋದು 3/1/2024ಕ್ಕೆ. Order sheet.
I have sent a register post. Yes. Register post is sent, my lord. It is there in the flag.
When is it sent?
Sorry. First flag, my lord.
That's the red flag. Yes. 3/2/2024.
Yes.
Notice ಕಳಿಸಿರೋದು.
Notice ಅಲ್ಲ, ಅದು communication of the order, my lord.
Order. Correct. ಅದಕ್ಕೆ ಮುಂಚೆ ಕೊಟ್ಟಿದ್ದ ನೋಟಿಸ್ ಅಲ್ಲಿ ಇದೆ.
In there, notice ಇದೆ.
Which flag is that?
Notice ಅಲ್ಲ, notice ಕೊಟ್ಟ ಮೇಲೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
For reconsideration by the deputy commissioner for enhancement.
Sir, this was proceeding under 3G5. That is for enhancement of compensation. Correct? Illi 28/9/2022, there is one proceeding.
Yes.
All right. The call on 8/11/2022. What happened on 8/11/2022? Nothing has happened.
They did not appear before the learned arbitrator.
Where is it?
8/11.
Where is it?
Not the recording. As
Then
on
we
8/11.
go by the records, not by statements of counsels who represent the authorities. Can't you record something here? Were you having a siesta when the proceedings were going on? On 8/11/2022, what has happened?
Nothing has happened.
Nothing has happened.
Thank you, sir.
Next date is award, order 3/1/2024. And with all fairness, you have communicated the award.
6
and justifying it now here.
26/10/2023. And thereafter 3/1/2024.
26/10/2023 ಏನಾಯ್ತು sir?
Order passed, my lord, it is there.
Impugned order passed. Where have you heard him, sir? ಈಗ 34 ಅಲ್ಲಿ ಫಸ್ಟ್ 34 ಹಾಕಿದ ತಕ್ಷಣ ಫಸ್ಟ್ ಡಿಫೆನ್ಸ್ ವಿಲ್ ಬಿ ಲಿಮಿಟೇಷನ್. It is beyond limitation, so not entertained. Very convenient for the national highway na idu to contend all this.
You will give an opportunity, my lord. A date may be fixed, my lord. Let them
We'll set aside this
May I
order.
give-
Yes, sir. What is your justification?
Yes, Lord, I just tell your lordship, Lord, what is
Yes,
the petition, Lord. There are 4 dates. Your lordship will see, Lord, on 33 he filed the claim petition. Lord, he was given a
33 of
notice
which
of 2022, my lord, that year. I understand that date. I am not very sure, but I understand on 33/2022 he filed the claim petition.
All right.
The notice was given to both. Lord, notice was given to him on 17/9/2022.
All right. 17?
To appear 17/9/2022. To appear on 28/9/2022.
Correct.
We both of us appeared. Both, Millard, both the petitioner and the respondent appeared on 28/9/2022.
All right. It was
Correct,
adjourned to 8/11/22.
Millard, 8/11 he did not appear.
No,
He
it was
did not
adjourned on to that date.
No, it was adjourned to 8/11, but he did not
Correct.
appear on 8/11.
No
Correct.
problem.
Yes. Yes, therefore, Millard,
where is the proceeding of 8/11?
Millard, it was adjourned on 8/11.
Where is the proceeding of the deputy commissioner on
On the date.
8/11?
Millard, that he does not say in the petition. W Lord, kindly have the
You
petition.
forget about the petition, sir. I have the
Millard,
original
page
records with
5.
me here. Where is the proceeding of 8/11 before the deputy commissioner? How can you justify this action? And what was he doing?
Millard, my
8/11?
submission. There was a hearing.
What is the proceeding on 8/11? Nothing.
Blank. Next date is
And
written.
next date is order.
Yes, next date, there is a signature of the LAO present of the National Highway, my lord.
When,
at the-
sir? When?
28/9.
8 or
ಅದು 28/9/2022 ಸರ್.
2022.
ಅದು ಕಟ್ಟಾಗಿದೆ.
211
ಅದು strike off
211 ಹೊಡೆದಾಕಿದ್ದೀರಾ ಅಲ್ಲೇ.
ಅಲ್ಲ 811 it might be 811 itself.
ಇಲ್ಲ
ಆಯ್ತು, take it as 811 only, sir. What is that you did on 811?
That,
Blank paper?
Blank.
Is this the way deputy commissioner functions? Particularly dealing with compensation of land losers?
We will give an opportunity of oral hearing also, my lord, but their petition is that the
Petition is that there is no opportunity, no notice at all given.
notice is given.
ಅಲ್ಲ, ಯಾವ ಆರ್ಡರ್ ಮಾಡಕ್ ಮುಂಚೆ. Who is this deputy commissioner?
Previously, this might be a new one.
This is how arbitration is done by the deputy commissioner.
Yes.
And 34 petitions are dismissed because of 120 days.
Notice has to be, but the order was communicated.
Very fair, sir, very fair. Order is communicated to him. ಯಾವಾಗ communicate ಮಾಡಿದ್ರಿ? 3/2/2024. ಅದು RPI ನಿಮಗೆ ಬಂತ ಅದು?
ಇಲ್ಲ.
ಅಲ್ಲ, acknowledgement is here.
Receipt acknowledgement ಎಲ್ಲಿದೆ?
At blue color flag is there.
Recipient ಯಾರ ತಗೊಂಡಿದ್ದಾರೆ?
Our advocate. Our advocate.
ನಿಮ್ದು ಮತ್ತೆ?
ಇಲ್ಲ, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು
ತಗೊಳ್ಳಿ.
Wakalat is also there.
sent to advocate. This was sent to advocate, not to the party.
He has not informed you? ನೀವೇನಾ?
ಮಂಗಳೂರಿಗೆ ಹೋಗಲ್ಲ, ಇಲ್ಲಿ ಮಾತ್ರ.
Yes, the petitioner is before this court calling in question an order of the deputy commissioner, arbitrator / deputy commissioner disposing the matter. ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Dismissing the application.
Dismissing the application filed by the petitioner, the land loser, seeking enhancement of compensation. Heard so and so. Facts in brief, Germain, are as follows. On 2/2/2002, notification on 26/8/2020, the respondent National Highway Authority of India issues a notification for acquisition of land for the purpose of widening of National Highway 169. The property of the petitioner also fell within the ambit of such widening of the road. The land of the petitioner was thus acquired and the road widened, and compensation determined for such acquisition. The petitioner then files an application under section 3-G(5) of the National Highways Act 1956 before the third respondent deputy commissioner cum arbitrator on 30/3/2022. Notice is issued to the petitioner on 17/9/2022, and after issuance of notice, the petitioner appears before the deputy commissioner on 28/9/2022. The appearance is recorded. The matter was then posted to 8/11/2022, and after 8/11/2022, it is the allegation of the petitioner that there was no notice about any proceeding, and the deputy commissioner rejects the application seeking enhancement of the compensation. The communication of the said rejection of the application, so the rejection of the application comes about on 24/1/2024. This is said to be communicated to the petitioner on 3/2/2024, which the petitioner has not received, as the notice of the order was sent to the advocate representing the petitioner before the deputy commissioner and not to the petitioner himself. Therefore, the petitioner is not even aware of what has happened. It is only later, the averment in the petition is that it is only later the petitioner comes to know that the application seeking enhancement of compensation has been rejected by the deputy commissioner and therefore files the subject petition. The learned counsel appearing for the petitioner Rajshekar would contend that the order sheet is the certified copy of the order sheet is secured and is placed as annexure. The order sheet would not reveal any proceeding that has happened. Therefore, there is neither notice to the petitioner of the proceedings before the deputy commissioner, nor the order of the deputy commissioner is communicated to the petitioner. Therefore, he would submit that there is blatant violation of principles of natural justice. The learned counsel for the respondent, what's his name? Huh? So and so, appearing for the respondent National Highway Authority would seek to justify the order on the ground that the petitioners did have notice. Even otherwise, it is his submission that the writ petition is not maintainable, and therefore not maintainable, as the petitioner has to file a petition under section 34 of the Arbitration and Conciliation Act, and the petition should not be entertained. He would even otherwise submit that the petitioners did not appear on 8/11/2022. Therefore, the proceedings stood closed. The learned counsel for the petitioner would now join issue to contend that if the court would direct filing of a 34 petition, limitation of 120 days would kick in and the petition would not even become entertainable. And therefore, in the light of the fact that there was no proceeding worth the name held by the arbitrator, the petitioner cannot be driven to a remedy under 34 only to be dismissed on the ground of limitation. I have given my so and so. The aforenarrated facts link in the chain of events and the dates are all a matter of record. It is not in dispute that the land of the petitioner stood acquired by the National Highway Authority of India for the purpose of widening of NH 169. The 169, the compensation was determined at a particular enhancement was determined, which the petitioner sought for enhancement under section 3G5 of the Act before the third respondent, deputy commissioner, and the arbitrator. The application was filed before the deputy commissioner on 30/3/2022. What happens thereon is found in the records, original records. The records would reveal the following. There is only one order sheet maintained by the office of the deputy commissioner with regard to the entire proceeding. The said order sheet depicts that notice was issued on the application was filed on 30/3/2022. Notice was issued on the application on 17/9/2022, and both the parties were present before the deputy commissioner on 28/9/2022. The matter was directed to be listed on 8/11/2022. On 8/11/2022, there is no proceeding recorded. The paper is blank. The next proceeding is on 3/1/2024. That is 23/1/2024, the date on which the order is passed by the impugned order is passed, which is impugned in the subject petition. Therefore, on the face of it, therefore, this court directed production of original records maintained before the deputy commissioner concerning the issue. The records are produced. The records would reveal nothing more than what is handed over to the petitioner as certified copies. They are the same. The only other document that is found in the original record is the communication of the impugned order to the advocate representing the petitioner, which is on 3/2/2024. The said order, the learned counsel for the petitioner submits that the said order was not did not reach the doors of the petitioner at all. In the light of the said submissions, whether this court would permit the petitioner to would reject the petition, directing the petitioner to avail the remedy of filing a petition under section 34, the answer would be an unequivocal and emphatic quote unquote no, for the reason that the order of the deputy commissioner is on the face of it arbitrary, and such arbitrariness arbitrariness on the foundation of violation of principles of natural justice would not lead to accept the submission of the Council for the National Highways to drive the petitioner to a petition under section 34 of the Arbitration and Conciliation Act. It is convenient for the respondent National Highways to contend that section 34 should be availed of by the petitioner only to go before the 34 proceeding and contend that it is beyond limitation. Therefore, the Deputy Commissioner acting in an arbitrary manner, the order must be obliterated. The obliteration of the order would only lead to the application being revived before the Deputy Commissioner, and the Deputy Commissioner directed to afford an opportunity of hearing to the respondent, to the petitioner all over again, right from its inception, and pass necessary orders in accordance with law within an outer limit of 3 months from the date of receipt of the copy of this order. For the aforesaid reasons, the following order allowed, quashed. The application is restored on the file of the Deputy Commissioner. The Deputy Commissioner shall now hear the petitioner or hear the parties to the list and pass necessary orders within 12 weeks from the date of receipt of the copy of the order.
To appear before the Deputy Commissioner, my lords, one date may be fixed. To appear before the Deputy Commissioner.
Since all the parties are now represented, I deem it appropriate to direct the parties to appear before the Deputy Commissioner on the 20th of August at 2:30 p.m. The proceedings shall conclude within 12 weeks from 20th of August 2025 in consonance with law, bearing in mind the observations made in the course of the order.
ಅಲ್ಲಿ 3 ಗಂಟೆ ಕೂತ್ಕೊಳ್ತಾರೆ. DC will sit at 3 o'clock.
3 o'clock.
Great.
Cost impose ಮಾಡೋಣ ಸ್ವಲ್ಪ. They are playing with the lives of these land losers, knowing full well that 34 bars them beyond 120 days. This is the advantage you are taking. Dumped. Correct. ಅದಕ್ಕೆ ಡಂಪ್ಡ್ ಬಂಡಲ್ ಅಂದ್ರೆ ಬರೀ ಬಂಡಲ್ ರಿಂಗ್ ಮಾಡ್ತಾ ಇರೋದ? This is not the way, sir. Whether it is 1 gunta of land or 100 gunta, 40 guntas of land, it is the same. They have to appear and ಕೊಟ್ರೆ ನೋಟಿಸ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಹೌದು ಸರ್, ನೀವು ಯಾವತ್ತು ನೆಕ್ಸ್ಟ್ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಪ್ರೊಸೀಡಿಂಗ್ ಡ್ರಾ ಮಾಡಿ. 2 ಲೈನ್ ಬರೆಯೋದು ಕಷ್ಟನಾ? ಇಂಟರೆಸ್ಟೆಡ್ ಮ್ಯಾಟ್ರಸ್ ಅಲ್ಲಿ 10 ಪೇಜ್ ಬರೀತೀರಾ?
ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಸೆಟ್ಟಿಂಗ್ ಇಲ್ಲ, ನಿಮಗೆ ನೋಟಿಸ್ ಕಳಿಸ್ತೀವಿ ಹೋಗಿ ಅಂತ ಕಳಿಸ್ಬಿಡ್ತಾರೆ, ಮತ್ತೆ ನೋಟಿಸ್ ಬರಲ್ಲ ಏನು ಇಲ್ಲ.
Yes.
21.
In this case,
Shriram Karanth layout agreement holder my lord seeks compensation post notification.
Entitled to compensation. Suit ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಹಾಕಿಲ್ಲ. Agreement of sale holder. Similar matter, my lord, W1630 of 21 lordships has taken a view in the matter. Not
Copy ಬಂದಿಲ್ವಾ? ಬಂದಿದೆ.
Order produced on 21/7/25.
Correct. I have released it.
It's released, man. It's reported also. 11630 of 21.
ಅದ್ರಲ್ಲಿ suit pending ಇದೆ. ಅದ್ರಲ್ಲಿ suit pending ಇತ್ತು. Even then I have said agreement of sale, unregistered agreement of sale ಏನ್ లేదు.
ಅಲ್ಲಲ್ಲ, I am entitled for compensation. If they dispute, then they may have to refer to section 30-31 of the Land Acquisition Act. I have a right to object.
You purchased it your own peril. ಅದು agreement. Not even a sale.
Alla, if they dispute, my lord, you lost my kindness. If they dispute, my lord, that may have to be referred to the, my lord, civil court under section 30 and 31 of the Land Acquisition Act. Let them.
Unregistered or registered?
Unregistered.
Annexures E, I have submitted represent. Let them consider my
latest Supreme Court judgments. Unregistered agreement of sale in acquisition cases will have no value. Justice Pardiwala.
Acquisition I was not aware.
Adra acquisition dene adunu.
Alla, ಇದು acquisition ಸರಿ, but ಇದು Shriram Karanth layout.
Post
sale, yes.
Post notification.
ಎಷ್ಟು ಪೇ? What is the consideration?
My lord, 50 lakhs.
Property?
30.
ಎಷ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿತ್ತು?
40 lakhs, 30 guntas.
ಇಲ್ಲ, ಎಷ್ಟು ಟೋಟಲ್ ಕನ್ಸಿಡರೇಷನ್ ಏನು?
92.25 lakhs, out of which 40 lakhs is paid in cash.
ಕ್ಯಾಶ್ ಇರ್ಲಿ
50 lakhs by
ಆಮೇಲೆ
Check also is there.
ಕಾಂಪನ್ಸೇಷನ್ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಡಲ್ವಲ್ಲ ಸರ್? ಕಾಂಪನ್ಸೇಷನ್ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಡಲ್ಲ.
ಅಲ್ಲ ಕೊಟ್ರೆ ತಗೋತೀವಿ ಬಟ್
ಅಯ್ಯೋ ಕೊಟ್ರಿ ಏನ್ ಬೇಕಾದ್ರೆ ತಗೊಂತೀವಿ, ಬೇರೆ ಮಾತು. ಬಟ್ ಕಾಂಪನ್ಸೇಷನ್ ಕ್ಯಾಶ್
anyway, my lord, I am entitled for the compensation.
ನೋ. ಯಾಕೆ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹಾಕ್ಲಿಲ್ಲ?
ಅದು ಅಕ್ವೈರ್ ಆದ್ಮೇಲೆ ಸ್ಪೆಸಿಫಿಕ್ ಹಾಕಕ್ ಬರೋದಿಲ್ಲ.
ಅಕ್ವಿಸಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಯಾವಾಗಿಂದ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಯಾವಾಗಿಂದ?
ಅಗ್ರಿಮೆಂಟ್
16. ಅಕ್ವಿಸಿಷನ್ ಇಸ್ 18.
8.
ಅಲ್ಲ ಅದೇನಾಯ್ತು
Turamkar ಅಂತ.
ಓ 2006, 2008 to 18 ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್. 2016 you purchased.
16.
ಅದೇನಾಗಿದೆ ಇಲ್ಲೆಲ್ಲ ಸೆಟ್ ಅಸೈಡ್ ಆಗೋಯ್ತಲ್ಲ.
ಸೆಟ್ ಅಸೈಡ್ ಆಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮತ್ತೆ ರಿವೈವ್ ಆಗಿದೆ. That's how Millard. Otherwise they would not have purchased. That is the problem.
ಈ ಕ್ಯಾಶ್ ಕೊಟ್ಟಿರೋದು ಹೋಯ್ತು.
ಅಲ್ಲ they can't deny. even ₹1 ಚೆಕ್ ಹೋದ್ರು ಕೂಡ they can't deny. Cash ಬೇಕಾದ್ರೆ they can deny. But agreement cannot be denied. Agreement cannot be denied.
ರಿಕವರಿ ಆಫ್ ಮನಿಗೆ ಹಾಕಿ.
ಅಲ್ಲ ಸರಿ, that is ಅದು ನಾವು ದುಡ್ಡೇ ಕೇಳ್ತಾ ಇರೋದು, ಬೇರೆ ಏನಿಲ್ಲ ಇದು.
ಅಲ್ಲ ಅವ್ರ ಹತ್ರ ಕೇಳಿ, ಬಿಡಿಎ ಹತ್ರ ಕೇಳಿ.
ಅಲ್ಲ ಬಿಡಿ ದುಡ್ಡು ಅವ್ರು ಕೊಟ್ಬಿಟ್ರೆ ನಮ್ದು ಹೋಗುತ್ತಲ್ಲ.
ಬಿಡಿಎ ಯಾಕೆ ಅವ್ರೇನ್ ತಗೊಂಡಿಲ್ಲ ನಿಮ್ ದುಡ್ಡು?
ಲ್ಯಾಂಡ್ ತಗೊಂಡಿದಾರಲ್ಲ.
ಎಲ್ಲ ಲ್ಯಾಂಡ್ ನಿಮ್ಗೆ ಓದೇ ಇಲ್ವಲ್ಲ ಇನ್ನು?
ಅಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಆದ್ರೆ
ಅವ್ರನ್ನ ಕೇಳಿ.
ಪಾರ್ಟ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
ವಿತ್ whom you entered agreement, file recovery of money from him.
ಈಗ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ, but they have not taken so far compensation also. Showing full annexure DEC, I have produced the award.
ಈಗ ಅವ್ರು ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡಿಲ್ಲ
ಅವರು.
ಈಗ ಗೊತ್ತಾದ್ರೆ ಅವ್ರು ಹೋಗ್ತೀವಿ.
Annexure, let them consider by represent annexure millet page 24.
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿ ಇಲ್ಲಿ ಮಾಡಿ, ಅವಾಗ ಅವ್ರು ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ. ಅದಕ್ಕೆ ಪಾರ್ಟಿ ಮಾಡಿ.
ಅಲ್ಲ Millard, you flash my kindly say, ನಮ್ ಪೋರ್ಷನ್ ಮಾತ್ರ we are asking. I am not that remaining extent let them take. ಅದೇ ನನ್ನ ಪ್ರೇಯರ್ ಅದೇ.
ಲ್ಯಾಂಡ್ ಓನರ್ ಪಾರ್ಟಿ ಮಾಡಿ ನೋಡೋಣ. Well, let's resolve it here.
17 ಗೆ ಅದನ್ನ ಆಗ್ಲೇ ಹೇಳಿದ್ರು. They sought time on 17 saying that they will make landowners.
ಬೇಕಿಲ್ಲ ಅಂತಂದ್ರೆ ಯಾಕಂದ್ರೆ because if there is a dispute, they have to refer to.
ನಿಮಗೆ ಬೇಕು ಅಂದ್ರೆ ಮಾಡಿ. Learned counsel for the petitioner seeks 2 more weeks time to comply with the order dated 1/7/2025. List the matter on 19th.
Not as the last chance, a week's time kindly be granted to them.
ನಿಮ್ ಇದ್ರಲ್ಲ
ಸೇಲ್ ಡೀಡ್ ಆಗ್ಬೇಕಾಯ್ತು ಅಂತ ಅಲ್ಲ, ವರ್ಡ್ ವಿತ್ ದಿ ಆಫೀಸರ್.
Learned counsel
only one.
ನಾನು ಟೈಮ್ ಕೊಡೋದು ಅವ್ರ ಕಂಟೆಂಪ್ಟ್ ಹಾಕೋದು ಯಾಕೆ? If they do it, they do it. Yes.
1 week.
Counsel B. Vachan seeks a week's time to secure instructions with regard to the prior of the petitioner to do the needful. List the matter on 19th as a last chance. In the event nothing would come about by then, this court would be constrained to allow the petition.
23.
Lords, 23, I am appearing for the petition in this matter, Lords.
People responded.
ತುಂಬಾ ಮ್ಯಾಟರ್ ಇದೆ.
Lords, this is a very small issue, Lords.
ಅಲ್ಲ ಅದಾಯ್ತು.
And here the
ತುಂಬಾ
question.
ಮ್ಯಾಟರ್ ಇದೆ ಇವತ್ತು.
ಇಲ್ಲ ಇವತ್ತು ಅದೇ ಧಾರವಾಡದ ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟರ್ ಇದ್ದಿದ್ರಿಂದ ಇಲ್ಲ ತಾವು 2:30
ಇರೋದು ಅವಾಗ್ಲೇ ನೀವು.
It's a very small issue, my lords. But here the larger perspective with which your lordships may have to view this matter is, Lord, should the officers be held personally responsible for the kind of mischief which they are playing? But just 4 dates I will give for your lordships consideration. Lord, survey number 128/8B1, Lords, which was ported by indicating certain portions of the property as a B Kharab, was challenged before the competent authority, who set aside the orders and directed a repody on 28/2/2020. This date is very important. 28/2/2020. 1/9/2020 the land 1/9/20 the acquisition takes place. After the orders passed by the competent authority, the acquisition in which
unmute.
My apologies, Lord. Lord, 708 square meters of the first petitioner and 425 square meters of the second petitioner is acquired. 708 and 425. But now what happens is I give a representation to these people saying that what you are actually passing an award is for 324 square meters out of 708 square meters. And for the second petitioner, you have not paid any money for the land acquired, but you are only giving compensation for the building. So therefore, you please consider in the teeth of the orders passed by the deputy commissioner. But then what happens is very important. Let's kindly have a look at page number 38.
38.
Yes.
Yes.
Notes the project director requests the competent authority in the special land acquisition officer to look into the matter in the teeth of the representations that there is a short payment in terms of the land, not in terms of the amount, but it is in terms of the land. Let's kindly now have a look at Annexure H, page 39. What is the decision which is taken, my lords, by the special LABO?
39 is it?
Please, my lords, page 39.
29.
39, my lords, Annexure H, page 39.
Yes.
Lords, now he decides, if your lords were to see, the lords, I just read this entire page, my lords. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಕಾಣಿಸಿರುವ ಅರ್ಜಿದಾರರುಗಳಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸುವುದರಿಂದ ನೀವುಗಳು ಮಾಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊನ್ಸೋ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 75ಕ್ಕೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಭೂಸ್ವಾಧೀನಾದ ವಿಸ್ತೀರ್ಣದ ಸಂಶಯ ವ್ಯಕ್ತಪಡಿಸಿ ಮೇಲಾಧಿಕಾರಿಗಳ ಪುನರ್ ಸರ್ವೆ ಮಾಡಿಸಿಕೊಡಬೇಕೆಂದು ಕೋರುವುದು ಸರಿಯಷ್ಟೇ. ಈ ಬಗ್ಗೆ ಕಚೇರಿಯಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಭೂಮಾಪಕರು ಭೂಸ್ವಾಧೀನತೆಯ ಬಗ್ಗೆ ತಯಾರಿಸಿದ ನಕ್ಷೆ ಮತ್ತು ವಿಸ್ತೀರ್ಣ ಕ್ರಮಬದ್ಧವಾಗಿರುತ್ತದೆ. ಈ ಮೊದಲು ಸರ್ವೆ ಇಲಾಖೆಯು ಆಕಾರ ಬಂದ ಪ್ರಕಾರ ಮಾಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್
ರವಿಶಂಕರ್ ಸರ್, ಮಧ್ಯಾಹ್ನ ಕೋರ್ಟ್ಗೆ ಬರ್ತೀರಾ?
2:30 I'll be before your lords.
ಬನ್ನಿ. ಎಸ್, ಪಾಸ್ ಓವರ್.
Immediately, please, my lords. Sorry.
ಬನ್ನಿ.
Please.
May I request for a passover, my lord, subject to your lordships and senior council's convenience?
24.
Yes, this was last.
Yes, sir. Yeah, why pass over?
I had engaged the services of Mr. Senior Counsel, Mr. Dhyan Chinnappa. He is held up on his legs in another court. Subject to your lordship.
We have interim order there.
There is some urgency, my lord, from our end.
Today urgency, ನೀವೇ pass over.
My lord, he is held up, my lord. Subject to your lord.
Passed over to 12th.
My lord,
interim order
my lord, then I'll argue. There is some urgency.
What?
Your lordships had taken note, my lord, by virtue of the strength of the interim order, possession was being interfered with by the petitioner.
What is the interim order granted?
Not to make any allotment, my lord.
Shall remain subject to the allotment.
That was the original order.
Original order, ಆಮೇಲೆ shall not.
When service was pending.
Sir.
Precipitate the matter. My submission to your lordship sees, my lord, that there is a sale deed in favor of my lord, Srimati. Please come to my lord, page 16.
16.
First, my lord, allotment. My lords get that at my lord running page 15.
One moment, sir. 15.
15, my lord, as on 23/2/2016, there's an allotment in favor of my lord, Srimati Mary Jayashree.
20.
ಮೇಲ್ಗಡೆ ಬರುತ್ತಲ್ಲ 23/2 ಮೇಲ್ಗಡೆ 15 ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ ಸರ್.
Sorry, my lord, sir.
Page 15. Yes, sir.
23/2/2016.
Yes.
That was, my lord, allotment in favor of Mary Jayashree. Then, my lord, there's a sale deed executed at page 16. Please come to, my lord, page 22.
Page 16.
16.
Yes.
Sale deed, registered sale deed, my lord, of 2016.
Yes.
Please come to, my lord, page 22.
Now, one moment. Just a moment, sir. Now, the BDA allots this property in favor of Mary Jayashree.
Correct.
Oh, petitioner yaru?
Petitioner is, my lord,
Purchaser?
I am a purchaser, my lord, from, there is a gift in favor of our
All right.
daughter.
23/2/2016 is this sale?
Yes, ma'am.
Sorry, allotment.
Allotment.
Allotment ಆದ ಮೇಲೆ?
Sale deed.
By the BDA?
Correct.
Yes, in favor of Mary Jayashree.
Jayashree.
Ah,
Then,
next,
my lord, please come to page 22.
20?
2.
Ah.
Schedule. There are 6 bits of land.
Yes,
My lord, first one is 1/2 into 8.30 into
correct.
20. Adu.
Adu ನಿಮ್ಮದಾ?
Adu nam.
ಅಲ್ಲ, all 6 are yours?
No.
Only
the first
this.
one. I'll tell you, Lord, is why. Please come to my lord. She sells it. She gifts it in favor of her daughter. Please come to my lord, page 29.
No, this particular serial number
my lord,
1.
Yes. Page 29.
Mary
Till
Jayashree.
ತಮಗೆ 37 ಬಂದ್ರೆ your lordships will get the schedule.
Yes,
Same extent, same this thing.
gift deed.
Gift deed. Please come to my lord the schedule at the bottom. 1, 2, 3.
1, 2, yes.
1/2 into 830
Yes,
meters
yes.
into so on so.
Same, 101.76 square meters.
Correct.
Yes.
Then my lord, Kantha is made in favor of
Daughter.
Reba Patrick, that person my lord Dhoni.
And Reba Patrick sells it to
Sells
you.
it in my favor, my lord, at page 41.
Now what's the problem?
Now, my lord, what has happened is, he, my lord, has encroached upon, my lord, this property. Therefore, my lord, a
Who?
suit has been, this lady,
Which
Vandana.
is this?
The respondent before your lord, second
One
respondent,
moment. This Kane Vandana.
Vandana. She, my lord, on an earlier occasion, filed a writ petition. Please come to my lord, running page. Page 97 ಗೆ ತಾವು ಬಂದ್ರೆ and my lord, can I persuade your lordships?
Vandana. Yes.
Vandana. Please come to my lord, page 98. That's more important. What is she asking?
You were a respondent there.
Mary Joyce, my lord, is a
Mary
respondent.
Jayashree is the
Correct.
respondent.
This is dismissed. But then more important is, please come to my lord, page 98. What is she, my lord?
What's the allotment made?
Allotment letter is page 15.
Yes, sir.
This was dismissed.
Contiguous lands.
Huh?
Under allotment of contiguous.
One ನಿಮಿಷ.
Crash, my lord, the allotment letter number 23/2/2016 at annexure.
All right, yes. ಆಮೇಲೆ writ appeal.
Writ appeal dismissed. And in the writ appeal, if your lordships come to my lord, paragraph 3 at page 104. For specific cases,
yes,
you have allotted it to the Mary Joyce, Jayashree. Please come to para 3, my lord, last 3 lines.
Yes.
Instead of considering the application of the appellants, BD allotted the site in question, second respondent, he submitted the site in question is adjacent to the property of the appellants and therefore had sought allotment, etc., etc. Ultimately, my lord, even the writ appeal is dismissed. Please come to my lord, page 110. 110. I'm sorry, I had prepared a note, but then when they copy ಮಾಡಿದೆ.
Yes, yes.
I would normally, my lord, make more copies.
Yes, that's what.
ನಾನು ಇವತ್ತು ಅದು preliminary hearing ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಎಲ್ಲಿ
ಅವ್ರ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ.
No, I have no problem at all. ನಾನು I have to apologize to your lordship.
No problem.
ಅದನ್ನ
Yes,
note ಎಲ್ಲ ಮಾಡ್ಕೊಟ್ಬಿಡ್ತಾ ಇದೆ.
Yes.
Now, my lord, what has happened is, she has encroached upon my property and put up a building. Therefore, my lord, I filed a civil suit. Please come to my lord, running page 56. OS number 5524 of 2024. If my lords come to my lord, the prayer at page 62, declare that I am the absolute
Suit
owner.
for injunction or declaration?
Correct, my lord. Injunction, declaration and possession. And mandate injunction to demolish, my lord, whatever building that she has constructed.
Why have you sought recovery of possession?
Because, my lord, she has encroached and then put up a building, compound wall. ನಾನು ಅಲ್ಲಿ ಹೋದ್ರೆ ಅದು ಇನ್ನೊಂದು ಪೊಲೀಸು ಅದು ಇದು ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ.
Correct, but recovery of possession ಅಂದ್ರೆ she has encroached upon.
Correct. And my lord, she admits that she has encroached upon it. Please come to my lord, page. ಎಲ್ಲಿದೆ ಅದು ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳಿದಾರಲ್ರಿ. 1 minute, my lord, I'll tell you, lordship. Please come to my lord. Page 66 bani. She seeks an allotment from the BDA and my lord says that she has encroached. Please come to my lord, the bottom. ಇದರಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು ನಿವೇಶನದ ಸಂಖ್ಯೆ ಹಂಚಿಕೆ ಮಾಡಿದ ಸದರಿ ಸರ್ವೆ ನಂಬರ್
ಸೇರಿಕೊಂಡರೆ ಮಾತ್ರ ನನ್ನ ನಿವೇಶವು 4060 ಆಗುತ್ತೆ. ಆದ್ದರಿಂದ ನಾನು ಅದನ್ನು ಒತ್ತುವರಿ ಮಾಡಿ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುತ್ತೇನೆ.
ಅದನ್ನ ನನಗೆ ಅಲಾಟ್ ಮಾಡಿ. Writ dismissed, writ appeal dismissed, and suit is pending. In the meanwhile, my lord, the BDA is quietly, my lord, seeking to allot it, and we have challenged that, my lord.
Vandana.
Please come to, my lord, the note sheet at 85. Adaralli, please come to, my lord, 94. Bottom 79, serial number 79 1. ಪ್ರಾಧಿಕಾರ ಆರ್ಥಿಕ ಹಿತಾಸಕ್ತಿಗಳನ್ನು ಅವರ ಹಿತಾಸಕ್ತಿ ಆರ್ಥಿಕ ಹಿತಾಸಕ್ತಿ ಪರಿಗಣಿಸಿ
ನಿವೇಶನ ಪ್ರಾಧಿಕಾರ ಸ್ವತ್ತನ್ನು
all that we have sought for, my lord, in this case, my lord, we have given 3 representations, no reply by the BDA. Ultimately, my lord, they are wanting to allot it. Therefore, my lord, we have filed this writ petition. I am not, my lord, wanting to, my lord, go and, my lord, demolish anything. My suit is there. I will, my lord, abide by it. But let not, my lord, the BDA allot it, because what will happen is, once she gets an allotment, again, my lord, she will produce it. BDA, my lord, is a party there. Whole thing, my lord, is there.
Yes, sir.
The entire case before your lordship says the property belongs to the petitioner, and therefore, my lord, that cannot be allotted to her. But in support of that, 2 judgments, my lord, of the
Judgment bidi sir, facts ಮೇಲೆ ಬನ್ನಿ. Your judgments between the parties.
pointed out to so much that we have challenged the allotment. But could your lordship kindly have a statement of objection? But admitted case which is not presented before your lordship says the petitioner admits that the property does not belong to him. He makes an application to the BDA which is not disclosed before your lordship to allot
marginal land ಇದು.
Marginal land. He seeks allotment of the very same land, makes an application to the BDA. Please allot it to me since my land is contiguous to this marginal land. I have made an application, my lord, saying that this land is contiguous to my land. Please allot it to me. Annexure R1.
Both of you are fighting for the marginal land.
Marginal land, and BDA conducts a survey. In my statement of objection, my lord, I have produced the maps to show that BDA says that this land belongs to BDA. This is not the property which was allotted to Mary Jayashree, and this was not the property which is subsequently purchased by the present writ petitioner. And therefore, if this is
What's the extent of land, marginal land? Yes.
Today I am seeking for 600 and odd square feet, on which I have produced photographs to show that the entrance to my scheduled property is standing over that. Along with my statement of objection, I have produced the photograph.
That is not the land allotted to the petitioner.
Not at all. Not at all, and that's precisely what I have placed. May I just point out, ultimately I can claim it is mine, petitioner will say it is there. Now, my lord, I have produced the map and the sketch, my lord, by the BDA to show, my lord, that this is not the land that is belonging to them. That would your lordship, my lord, kindly turn to the entire notice which I have produced. Annexure R1, my lord, is the application made by the present petitioner seeking for allotment. Request to allot marginal land abutting site number, survey number 20, site number 24/1. Now, my lord, next page number 15. Now, my lord, page number 15 and page number 16. 16 is his written application saying, please process my site allotted by BDA to revenue site encroacher. Even before your lordship, my lord, it is not demonstrated that the site purchased by him is approved by BDA, that layout plan was formed, and after formation of the layout plan, demarcated land is what he has purchased. There is no layout plan, my lord, to show that this was purchased by him. Now, my lord, what he does is, he wants to stall my application, thereby process his application. My lord, and page number 20.
Please direct both the application be not, my lord, processed. Let the suit, because BDA is a party, direct, my lord, the suit to be disposed of within 6 months.
Let him finish. Let him finish.
That's all.
Adena.
Ashte.
Ultimately,
I mean, ultimately, my lord, justice must be done for both parties. That's all I would say, my lord.
ಈಗ marginal land ಯಾರಿಗೂ allot ಮಾಡಬೇಕು.
Marginal land is disposal of the suit and ಹೇಳ್ತಾರೆ. But they have not sought any consideration of their application at all. But my application is being processed and that is being sought. Ultimately, if the lordship were to say it will disposal of the suit. But even otherwise, my lord, even if the land is allotted, my allotment will be subject to the result of the suit. Ultimately, if the civil court was to declare that the land is there.
ಅಲ್ಲಿ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಆಮೇಲೆ ತಲೆನೋವು.
ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಈಗ ಮೊನ್ನೆ ಇದೆ ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋಗ್ರಾಫ್
ಸೂಟ್ ಯಾವ ವರ್ಷದ್ದು?
2025.
25 ಇದೆ.
Like all that I'm saying, even if allotment is made, I'm just assuming an allotment is made either in their favor or in my favor. It will be subject to the outcome. Today, my case before this.
It's subject to the outcome, that is all we'll do.
2024 suit.
24 suit.
24 suit.
I'm sorry, 24. Subject to the outcome.
Subject to the outcome of what? Any allotment? Any allotment or your allotment?
No.
Any allotment. That will do.
My lord, my submission would be, suit itself be directed to be disposed of, my lord. Thereafter, my lord, whoever, my lord, gets an allotment, BDA is a party there. Please look at it. I'll tell you, lords, is why.
He withdrew the application
No.
before the civil court. He filed an application before the
For
civil
what?
court for the same prayer.
What prayer?
For the prayer that it should not be allotted. I filed my
I
application.
will pass that order.
Any allotment made may be subject.
Yes. Nimden, sir. No, I will only travel on the periphery. Will not go deep into it. For disposal, periphery is enough. Yes. The,
My lord.
yes,
Permitted, my
you
lord.
need not. Yes. The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Uday Holla appearing for the petitioner and counsel Prithvish representing the second respondent and the counsel B. Vachan representing the BDA. The issue in the list revolves around allotment of the marginal land which is said to be contiguous to both the petitioner and the second respondent. A little history to the claim of possession of the petitioner on the is to be narrated, though albeit on the periphery. The petitioner, the BDA, is said to have allotted the land in favor of the vendor of the petitioner, one Mary Jayashri,
Vendor's mother, my lord.
a vendor's mother of the petitioner, one Mary Jayashri on 23/6/2016, and a sale deed is executed by the BDA. As the allotment was of several parcels of land, the allotment of the petitioner, allotment made to the mother of the vendor of the petitioner is as follows. On the mark madam, yes, page 22 alli. All other documents are now in place, were in place of the mother of the vendor of the petitioner. The mother of the vendor gifts the property in favor of the vendor of the petitioner on 4th March 2017. The gift deed results in the daughter becoming the owner of the property. The daughter then executes a sale deed in favor of the present petitioner. Then begins the problem. The land that abuts the property was claimed by both the petitioner and the respondent. The second respondent approaches this court in writ petition 35146-35147 of 2016.
May I speak? It's not the same land, my lord. Both are different lands.
Different lands, huh?
It's not
Yes.
what, this what.
Lands that are contiguous and party, different, yes, that I'll correct. The second respondent approaches this court, calling in question the allotment letter dated 23/2/2016. The allotment was not only in favor of the mother of the vendor of the petitioner, but it contained other allotments as well. But the writ petition comes to be dismissed. Writ appeal against the said order comes to be dismissed. After dismissal of the two, it transpires that transpires on interference by the second respondent. The petitioner institutes a suit in OS
5524 of 2024.
suit in OS 5524 of 2024, seeking declaration, possession, recovery of possession, and several other reliefs.
Mandatory injunction.
Huh?
Mandatory injunction.
Mandatory injunction. The said suit is pending adjudication. All the parties to the present list are parties in this suit. Therefore, the learned counsel for the petitioner, learned senior counsel for the petitioner submits that the allotment should not be made in anybody's favor, as steps are being taken by the BDA to allot the allot the land sought in favor of the second respondent herein. The learned counsel Prithvish, appearing for the second respondent, would, in an attempt to steer clear the controversy, takes this court through the documents appended to the statement of objections. It is his submission that the petitioner himself has made representations to allot marginal land abutting site number 24/1. Therefore, the two are different lands. Be those submissions as they are. The counsels for the parties would now submit that the suit is pending with the aforesaid prayers. The allotment of the land be made subject to the outcome of the suit. That would suffice for the present. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the BDA not to allot the property, allot the land that is sought either to the petitioner or to the second respondent herein, and take the process of allotment only after the decision that would be arrived at in the civil suit. The civil suit is of the year 2014, therefore 2024. Therefore, it would therefore to direct the civil or to infuse finality into the civil suit would not be appropriate. But however, I deem it appropriate to observe that the concerned court shall endeavor to expeditiously dispose the civil suit as it would lay the controversy to rest. In that light, the following order: the writ petition stands disposed. The allotment of land that is the subject matter of the present list shall await the decision of civil suit in OS so and so mail so and so. Await decision. The BDA is directed not to process the allotment of the land either to the petitioner or to the second respondent. Ordered accordingly.
25.
I seek indulgence of the court to permit me to appear online.
Yes, sir. You can appear, sir.
That kindly see, my lord. This is a writ petition filed by the residents of Classic County Site Owners and Residents Welfare Association, seeking direction to BDA to pay the electricity charges, maintain the roads, drainages, and to act as a local authority.
Yes,
Our is a BDA approved layout.
My lord, sir. My lord,
I have heard, Sitaram Rao, sir. I have heard you. I will hear the respondent.
My lord,
Yes, sir. What's
page
the-
number 20BC, my lord. Page number 20C.
20?
Builder executed the relinquishment deed. Kindly see page number 20, third paragraph. Page number 20, third
Correct.
paragraph.
Further agreed the first
Is
party to
further
maintain the
agreed by
private
the first
layout till it
party
is handed over to the local body.
to maintain the private layout till it is handed over to the local body. So it is undertaken is given by the builder that he would manage the layout, he would maintain the layout. And if my lords have a look at the provision in the statute under section 28A of BD Act, my lords, the liability to maintain section 28A of BD Act.
28A.
Yes. It shall be incumbent on the authority to make a reasonable and adequate provision by any means or measures which it is lawfully competent to use or take for following matters, namely: A, the maintenance, keeping in repair, lightening and cleaning of the streets formed by the authority. Kindly mark this. till such streets are vested in the corporation. So these are the layouts which are not been formed by the authority. This is the street, my lord. This is the layout which is formed by a builder. And in addition to that, my lords, which I want to bring to my lord's notice with regard to the levy of tax on the lands and building, section 28B. My lords,
28B.
28B, my lords, 28B.
Yes.
No, notwithstanding anything contained in this act, kindly mark this. The authority may levy tax on the lands or the buildings or on both, situated with its jurisdiction hereinafter referred to as the property tax, at the same rates at which the tax is levied by the corporation within its jurisdiction. So the section 28B is an independent provision, which is not controlled by section 28A. So my respectful submission is that, my lords, one thing is that when the builder himself has executed relinquishment deed with an undertaking that he would maintain the streets, my lords, liability cannot be imposed on the BDA. Therefore, my lords, the request of the petitioners was turned down by giving an endorsement, my lords, by quoting this, the contents of the relinquishment deed. My lords would find it at page number, annexure, M, page number, page number 61, if I am wrong, not wrong, my lords, page 62, annexure M. And in addition to that, my lords, I'm being told that even they are not paid the electricity bills also to the.
That is there.
Yes.
We'll come to him later.
Yes, yes.
Yes.
Annexure M, my lords, their request has been turned down by quoting the recitals in the relinquishment deed. Annexure M, page number 62.
Yes.
My lords, now, my lords, we have not filed our statement of objection, my lords. Now I'm being told that we have not taken any steps to hand over the layout to the corporation. It is in the process. That's what I have secured instruction.
Yes, sir.
My lords, the builder, my lords, the builder also is made as a party in the writ petition. That is respondent number 4.
He has not appeared.
He has not appeared. He has not appeared.
Notice ಆಗಿಲ್ಲ. R4 notice ಆದಂಗಿಲ್ಲ. Yes, sir.
I felt the moment.
Milords, Bescom lawyer may not be heard because it is a fact that BDA has failed to pay the electricity charges. Consequently, after 17 years, electricity has been disconnected to the layout.
17 years.
17 ವರ್ಷದಿಂದ ಇತ್ತು ಕರೆಂಟು.
17 ವರ್ಷ ಇತ್ತು, ಈಗ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಕೊಟ್ಟರು, ಬಿಡಿಎದವರು ನಾವು ಕೊಡಲ್ಲ ಅಂತಾರೆ. ಡೆವಲಪರ್ ಐ ಹ್ಯಾವ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ದಿ ಲೇಔಟ್. I am not required to pay anta. My submissions may be taken now. My learned friend relies upon the relinquishment deed, a standard format which the BDA will impose on every developer. It has been done without reference to the amendment made and orders of this
amendment. What amendment, sir?
Allah, BDA Act amend ಆಗಿ 28 B and C ಮಾಡಿದ್ರು.
ಅದನ್ನೇ ಓದಿದ್ದೀಗ ಅವರು.
This honorable court in WP 4394 of 1988 directed the BDA to refund the property tax which they have been collecting.
Which is that judgment, sir?
WP 4394 of 1988. I will just speak about the history.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಇದು ಆಕ್ಟ್ ಅಲ್ಲಿ ಆ ಪುಸ್ತಕದಲ್ಲೇ ಇದೆ. ಆಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು 223 of 1992 ಅಂತ BDA. The division bench confirmed the order and directed BDA to refund the tax because you are not acting as a local authority. Then matter was carried to the Honorable Supreme Court. Supreme Court confirmed and directed them to refund the tax because they are acting as local authority. Thereafter, because the assembly was not in session, ordinance was brought in 1991. Thereafter, act was made. Amendment by clauses were introduced by inducting 28A. I will read. It is the duty to maintain. Our hair splitting interpretation, unfair interpretation was made while reading 28A, duty to maintain streets. It shall be incumbent on the authority to make reasonable and adequate provision by any reason, measures which it lawfully competent to use or take the following matters, namely maintenance, keeping in repair, lighting, cleansing of the streets formed by the authority till such streets are vested in the corporation. However, it is next to formed by the authority.
One moment.
My layout is also
They have
formed
not
by
yet handed over to the corporation. Yavaga.
corporation ಕೊಡೋರ್ಗು ಅವ್ರ ಜವಾಬ್ದಾರಿ. What my learned friend gave an impetus was formed by
Till
the
then it
authority.
is BDA.
No, we are not maintaining
No, one
it.
nimsha.
Builder has to maintain it because
No,
these are
builder
streets
anta
which are not
ಎಲ್ಲೂ
being
ಇಲ್ಲ.
formed by the authority.
It shall be incumbent authority with reasonable provision, any means, measures lawfully.
It is a street which is maintained by, it is not a formed by authority, it's formed by a builder.
Streets formed by authority till such streets are handed over.
ಅಲ್ಲ
It's formed by a builder.
ಅಂದ್ರೆ ಸಿವಿಲ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಯಾರು ಅಂತಲ್ಲ, ಲೇಔಟ್ ಅಪ್ರೂವ್ ಮಾಡಿದವರು ಅವರು. ಸೈಟ್ಗಳನ್ನ ಬೈಫರ್ಕೇಶನ್ ಮಾಡಿ ಸಿವಿಕ್ ಕಮ್ಯುನಿಟೀಸ್ ಮಾಡಿ 17% ಇವರು ಸೂಪರ್ವಿಷನ್ ಚಾರ್ಜ್ ತಗೋತಾರೆ. ಆಮೇಲೆ ಸೈಟ್ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ ಇಂಡಿವಿಜುವಲ್ ಸೈಟ್ಸ್. ರಿಜಿಸ್ಟರ್ ಆದ್ಮೇಲೆ ನಾವು ಇಟ್ ಈಸ್ ಲೋಕಲ್ ಅಥಾರಿಟಿ ಈಸ್ BDA. ದೇ ಆರ್ ಬೌಂಡ್ ಟು ಮೇಂಟೈನ್. ಯಾವನೋ ಡೆವಲಪರ್ ಡೆವಲಪ್ ಮಾಡಿ ಹೊರಟೋದ್ರೆ ಇವರು ಸುಮ್ಮನೆ ಇರಬೇಕಾಗಿತ್ತು. ದೇ ರಿಜಿಸ್ಟರ್ ಖಾತಾ. ನಾವು ಕೈಂಡ್ಲಿ ಕಮ್ ಬ್ಯಾಕ್ ಟು ದಿ annexures which I have produced. ಅವರು ಯಾವ್ದೋ ಫಾರ್ಮ್ಯಾಟ್ ನ ರಿಲಿಂಕ್ಮೆಂಟ್ ಡೀಡ್ ಬರ್ಸ್ಕೊಂಡು ಪಬ್ಲಿಕ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿನೇ ಇಲ್ಲದೆ ಇದ್ರೆ, ಪಾರ್ಕ್ಗಳು ತಗೊಂಡಿದ್ದಾರೆ, ರೋಡ್ ಇವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದೆ, ಬೀದಿ ಜೀಪ್ಗಳು ಇವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದೆ. ವಾಟ್ ಇಸ್ ದಿ ಮೀನಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡಿಂಗ್ ಓವರ್ ಮೇಡಮ್? Annexure C is the one of the sale deeds which I have produced for my last kind reference. BDA approved layout. Then revenue layout alla. Kindly see Annexure D in page 41. If they are not local authority, can they issue khata? They have no business to issue khata. It is the duty of the local authority. In page 41, my lord.
Yes, sir. So
Then,
the property is still vested with the BDA till it is
BDA.
handed over to the corporation.
ಹ್ಯಾಂಡ್ ಓವರ್ ಆಗಿದೆ, ವೆಸ್ಟ್ ಆಗೋಗಿದೆ. ಈಗ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ದಿ ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ವಿಚ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೈಟ್ ನಾಟ್ ಹ್ಯಾವ್ ಅಬ್ಸರ್ವ್ ಆಲ್ ದೀಸ್ ಡೇಸ್ ಬಿಕಾಸ್ ಕಾರ್ಪೊರೇಷನ್ ಅವರು ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ಬೆಗ್ಗರ್ ಸೆಸ್ ತಗೋತಾರೆ. ಇವರು ಹೊಸದು ಆಕ್ಟ್ ಅಲ್ಲೇ ಇಲ್ಲದೆ ಇರೋದು ಮಾಡಿದ್ದಾರೆ. ಇನ್ ಪೇಜ್ 57 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಟೇಕನ್ ಮೇಡಮ್.
Yes, Sachin.
ಅಲ್ಲಿ ಕೆಳಗಡೆ ತಾವು ನೋಡ್ಬೇಕು ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ 7260.
I have not yet filed my counter. I'll file a
ಅಲ್ಲ,
formal.
let him read this.
ಈಗ electricity restore ಮಾಡಿರಿ. We will decide who has to pay. Let the people not be in darkness. Right?
My lord, amount
ಆಯ್ತು, ಅಮೌಂಟ್
41 lakhs.
1 second ಮೇಡಮ್. ಅಲ್ಲ, ಇದು ತಾವು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬೇಕು ಅಂತ.
ಅಲ್ಲ, ಅವ್ರು ಇನ್ನೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ. I wants to file objections.
ಅಲ್ಲ, ಇದು ನಾವು ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲ್ಲ. ನಾನು ಪ್ರಾಪರ್ಟಿ
ನೀವಲ್ಲ ಸರ್, ಅವ್ರು
ಪ್ರಾಪರ್ಟಿ ಏನ್ ಕಟ್ಟಲ್ವೋ ಪ್ರತಿ ಸೈಟ್ ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಯಾರನ್ನ ಏನ್ ಮೇಂಟೈನ್ ಮಾಡಕ್?
ಯಾರು ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ತಗೊಂಡ್ರದು?
BDA.
ಎಲ್ಲಿ, ವೇರ್ ಡು ಐ ಗೆಟ್ ದಟ್?
ಇನ್ ಪೇಜ್ 57 ನಮ್ ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ಎಷ್ಟು ಕಟ್ತೀವಿ BBMPಗೆ ಅಷ್ಟಕ್ಕಿಂತ 4% ತಗೋತಾರೆ ಇವರು.
ಮೇಂಟೆನೆನ್ಸ್ ಫೀ 1800 rupees.
This is a tax.
ಸರ್ಟಿಫೈಡ್
Arrears maintenance
ಇನ್
fee.
ಪೇಜ್ 61 2400 4060
ಟ್ಯಾಕ್ಸ್ ಯಾರು ಟ್ಯಾಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ರು ನಿಮ್ಗೆ? ಏನ್ ಟ್ಯಾಕ್ಸ್ ಇದು?
Property tax.
ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ರಿಸೀಟ್, ಅದ್ರಲ್ಲಿ ಕಾಂಪೋನೆಂಟ್ಸ್ ನೋಡಿ ಇಲ್ಲಿ.
That's right. My lords,
Fee is not a tax, sir.
My lords,
ಆಕ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು ಪ್ರಾವಿಷನ್.
Fee is only quid pro quo. You give service, you take it. Tax is imposition.
my lords, everything
Tax is
comes,
an impost. This is not. Yes,
everything comes under section 28B.
that we will see. Yes.
ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ತಗೋಬೇಕು ಅಂತ ಅಲ್ಲಿಲ್ಲ. ಕಾರ್ಪೊರೇಷನ್ ಅವ್ರು ಎಷ್ಟು ತಗೋತಾರೆ ಅಷ್ಟೇ ತಗೋಬೇಕು ಅಂತಿದೆ. ಕಾರ್ಪೊರೇಷನ್ ಮೇಂಟೆನೆನ್ಸ್ ಫೀಸ್ ತಗೊಳ್ಳಲ್ಲ, ಕೊಡೋ ಟ್ಯಾಕ್ಸ್ಗೆ ಅವ್ರು ಕಸ ತೆಗಿತಾರೆ, ಬೀದಿ ದೀಪ ಹಾಕ್ತಾರೆ, ಟಾರ್ ರೋಡು ಹಾಕ್ತಾರೆ.
My lords, I'll file my counter. My lords may issue notice to the builder also. He is the culprit, my lords, for which he has.
ಅವ್ರಿಗೇನ್ ಸಂಬಂಧ? ಖಾತೆ ಮಾಡಿ ಟ್ಯಾಕ್ಸ್ ತಗೊಂಡ್ರವ್ರು ನೀವು.
Builder he is not me.
He has relinquished everything to you.
My lords, subject to that, my
Hard,
lords.
nothing subject to.
Subject.
17 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ? 17 years ಯಾಕೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ? ಅವಾಗ ಬಿಲ್ಡರ್ ನೆನಪು ಬರ್ಲಿಲ್ವಾ? You can wake up from slumber anytime and trouble these people? Yes, sir.
You are going by this only relinquishment.
Going by what? 17 years you're sleeping.
Sir,
And suddenly wake up and take away electricity and everything to these people. How do they live?
Electricity is not taken away.
ಅಲ್ಲ, taken away. ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ದುಡ್ಡು ಯಾರು ಕಟ್ಟಬೇಕು? ಇಲ್ಲಿವರೆಗೆ ಯಾರು ಪೇ ಮಾಡ್ತಾ ಇದ್ರು? 17 years ಯಾರು ಪೇ ಮಾಡಿದ್ದಾರೆ?
Nobody paid.
ಯಾರು ಪೇ ಮಾಡಿಲ್ವಾ?
41 lakhs, 27,000 and.
ಯಾರು ಪೇ ಮಾಡಿಲ್ವಾ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಚಾರ್ಜಸ್? ಎಸ್ ಸೀತಾರಾಮ್ ಸರ್?
Relinquishment deed was executed on 4/8/2011.
Correct. ಈಗ nobody has paid, is it? Electricity charges?
ಅಲ್ಲ, ನಮಗ್ ಗೊತ್ತಿಲ್ಲ, ಇವರು ಬಿಡಿಎದವ್ರು ಕಟ್ಟಿರ್ಬೋದು.
ಅಲ್ಲ, ನಿಮ್ ಮನೇಲಿ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆಯೋ ಇಲ್ವೋ?
ಇಲ್ಲ.
ಇಲ್ಲಿವರೆಗೆ ಯಾಕೆ ಮುಂಚೆಯಿಂದ 10 ವರ್ಷದಿಂದ ಇಲ್ವಾ?
ಇದೆ ಕರೆ. ಬೀದಿ ದೀಪ
ಅವಾಗ ಯಾರಿಗೆ ಪೇ ಮಾಡ್ತಾ ಇದ್ರಿ? Who was paying it?
3 ದಿನ ಮುಂಚೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತು.
No, that's all right. Who was paying it for the last 14 years?
ಈ ರಿಟ್ ಹಾಕಿದ್ದೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್.
Who was paying it for the last 14 years?
ಅಲ್ಲ, maybe
ಅಲ್ಲ, ಇಲ್ಲ, ಯಾರು? Your residents association, you should know who was paying.
ಅಲ್ಲ, I think nobody has paid, madam.
Nobody has paid. Then you will not get electricity.
ಅಲ್ಲ, ನಾವು
You deposit 50 electricity charge. Sir, electricity charges is on usage. You have used it. So pay. Mikit we will see about roads and other things.
ಅಲ್ಲ, 1 yearಗೆ ನಮ್ಮ ಸೈಟ್ಗಳ ಹತ್ರ ಬಿಲ್ಡಿಂಗ್ ನವರ ಹತ್ರ ಡೆವಲಪರ್ 1 year ಮೇಂಟೆನೆನ್ಸ್ ತಗೊಂಡಿದ್ರು, ಅವ್ರು ಕಟ್ಟಿರ್ಬೋದು.
1 year ಅಲ್ಲ, 14 ವರ್ಷದಿಂದ ಯಾರು ಪೇ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ you are not entitled to get electricity.
ಅಲ್ಲ, ನಾವು citizen, my lord, I am a taxpayer.
You are taxpayer, electricity payer ಆಗಿ.
ಅಲ್ಲ, ಮೇಂಟೆನೆನ್ಸ್ ಚಾರ್ಜ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
ಮೇಂಟೆನೆನ್ಸ್ ಚಾರ್ಜ್ ಕೊಟ್ಟು ಯಾರಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಬಿಡಿಎಗೆ.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಮೇಂಟೆನೆನ್ಸ್, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ is covered under maintenance.
ಹೌದು.
ನೋ
ಸ್ವಾಮಿ, ರಸ್ತೆ, ಪಾರ್ಕು, ಬೀದಿ ದೀಪ, ಕಸ ತೆಗೆಯೋದು.
ಯಾಕಂದ್ರೆ ಆಯ್ತು ಎಲ್ಲ ನೋ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್ ವಿಲ್ ಪೇ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಚಾರ್ಜಸ್.
ಅಲ್ಲ, ನೋ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್, ಅಲ್ಲಿ ರೆಸಿಡೆಂಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ಗೆ
I will grant an interim order subject to 50% deposit.
ಅಲ್ಲ,
you want it, or I'll pass an order on merits, no problem. Insofar as the maintenance of street lights and other things, will take it. ಮನೆ ಲೈಟ್ ಗೂ ಬಿಡಿಯನ್ನೇ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ?
ಮನೆಗಲ್ಲ ಸ್ವಾಮಿ,
ಮತ್ತೆ
ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ಮಾತ್ರ ಕೇಳ್ತಾ ಇರೋದು.
ಈಗ ಮನೆಯಲ್ಲಿ ಲೈಟ್ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ.
ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ಮಾತ್ರನಾ?
ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದ್ದಕ್ಕೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ರಿಟ್ ಹಾಕಿದ್ ನಾವು.
ಈಗ 41 lakhs ಯಾವ್ದ್ರದ್ದು ಇರೋದು ಅರಿಯರ್ಸ್?
2000.
ಡೇಟ್ ಅಲ್ಲ ಸರ್, ಯಾವ್ದ್ರದ್ದು ಅರಿಯರ್ಸ್?
Street light.
ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ದೇನಾ?
ಅಷ್ಟೇ.
ಆಲ್ ರೈಟ್. ರೆಸ್ಟೋರ್ ಸ್ಟ್ರೀಟ್ ಲೈಟ್ಸ್. ಪೇಮೆಂಟ್ ಬರುತ್ತೆ, ಯಾರು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀವಿ ಆಮೇಲೆ. ಎಸ್, ರೆಸ್ಟೋರ್. ದಿ ಪೆಟಿಷನರ್ is before this court calling in question the action of the respondent BESCOM and the BDA, one in not making one enacting contrary to section 28A of the act, and the other disconnecting the electricity that was supplied to the street lights in the petitioner Allotment. The learned counsel V.C. Sitaram Rao submits that the street lights have been abruptly disconnected on the score that there are huge arrears by the association, allegedly by the association. The learned counsel would submit that maintenance of street light, roads and others in the layout till it is handed over to the local authority is the responsibility of the BDA. The learned counsel for the BDA, B.S. Sachin, submits that the relinquishment deed in which the relinquishment happens from the hands of the developer to the hands of the BDA clearly indicates that the maintenance will be by the developer till it is handed over to the local body. The issue is who should maintain the streets and the upkeep of the property till it is handed over to the local body. Admittedly, the BDA is in the process of handing it over to the local body. Therefore, it is now in the hands of the BDA. The learned counsel B.S. Sachin would submit that the relinquishment deed was executed in the year 2018, and therefore the developer ought to have taken care of the property.
2011.
2011. Therefore, the developer ought to have taken care of the property. For the last close to 14 years, the BDA has kept quiet without pointing a finger at the developer. Now, wake up from slumber and contend that the developer has to take care of the property when the demand for electricity charges comes about from the BESCOM. The petitioner members of the Allotment complex are now caught in the crossfire between the BESCOM and the BDA. Therefore, subject to further orders at the hands of this court, the electricity that is now disconnected by the BESCOM shall be restored, lest untoward incidents would come about in the apartment, in the Allotment, due to lack of electricity. In the layout due to lack of electricity pending, which shall however be subject to the result of the petition. Both the respondents shall now file their statement of objections within the next 1 week. List the matter on 19th, next 10 days. List the matter on 19th. Objections, if any, by then. Yes. ಇವತ್ತು ಕೊಡಿ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಆಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡೋಣ. ನಿಮಗೆ you are worried about payment. 19th will decide who has to pay. All right.
May I request for issuance of notice to respond number?
What will you do?
We'll take up.
I would have issued definitely. ನೀವು 2012 ಅಲ್ಲಿ ಇದನ್ನ ಮಾಡಿದ್ರೆ, not in 2025.
Yes.
ಅದು ಅವ್ರು 41 ಲಕ್ಷ ಬಿಲ್ ಕೊಟ್ಟ ತಕ್ಷಣ BDA wakes up now. Yes.
26.
Prepare for petitioner, my lord. Issue involved in this petition is no more res integra, my lord.
Matter is covered by the order of the coordinate bench. My lord would get at page number. Annexure F2, my lord, page number 79. There are series of orders. Only preliminary notification is issued. Final notification has not been issued.
We'll close it.
Please, my lord.
The petitioner is before this court seeking the following prayer, heard so and so. The learned counsel for the petitioner submits that the issue in the list stands answered by the judgment rendered by the coordinate bench in so and so, page 79, madam. The learned counsel for the respondent is not in a position to dispute the position of law as is laid down by the coordinate bench, which by itself was following the earlier orders passed by the other coordinate benches. In that light, the petition deserves to succeed. The same order. Next.
27.
Yes, sir.
Got about 142 acres of land. Was acquired and acquisition is completed about during 1999, 96, 97 itself. Compensation have also been dispersed. Then my lord, out of multi number of landowners, only few landowners have made a claim before the reference court, and that was pending all along. Now, my lord, the large number of landowners never made any reference. They sought for any reference. They accepted the compensation at that point of time. Now, my lord, in 2014, 1/1/2014, new Land Acquisition Act came and earlier enactment was repealed. By virtue of the repeal, on the date when the act came to be repealed, my lord, no interest is accrued in favor of rest of the landowners. Those are not before the civil court. Now, my lord, the reference court at the instance of few landowners now passed an award and enhanced the compensation. Now, taking advantage of that, my lord, the landowners, certain landowners sought for a reference, and now an award was passed on 148, page 100, annexure M, awarding compensation in par with the compensation awarded or enhanced by the civil court. In the context, my lord, a question which I have raised in the writ petition is, when a right is not, any interest is not accrued as on the date of repeal, insofar as these farmer landowners are concerned, would they entitled to approach the authority into section 28 capital A of the repealed act is concerned? My lord, my submission according to me, my lord, there is one judgment of the apex court, my lord, can I cite? Whole matter is founded on that. May kindly see.
First time ಬರ್ತಾ First time ಬರ್ತಾ
First time ಬರ್ತಾ The government is taken notice, rest of the landowners are not yet notified.
Government notice ಆಗಿಲ್ಲ.
The government advocate is asked to take notice.
List for preliminary hearing ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. Learned, heard the learned senior counsel M.R. Rajagopal appearing for the petitioner. The learned HCGP. ಎಲ್ಲಿದೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬರೀ ಎಲ್ಲಾರು ಸೇರಿದಾರೆ ಇಲ್ಲಿ
ಒಂದು 64 ಜನ ಜಾಸ್ತಿ
ಎಲ್ಲರಿಗೂ ಏಜ್ ಆಫ್ 74 ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಎಲ್ಲಿದ್ದಾರೆ ಸರ್?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಮೈ ಲಾರ್ಡ್
ಓಹ್ ಇಲ್ಲೇ ಎಸ್ ಸಿದ್ಧಾರ್ಥ್ ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ ಇಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್.
ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ
1 2 3 learned HCGP emergent notice to the remaining respondents returnable by 4 weeks bit on code. Returnable by the 9th September. List on 9th.
Start for an interim.
Water interim order.
Award is passed. Now they wanted to enforce it. It would comes about 9-10 crores, my lord. My lord, I can cite a judgment whether it would be. They kindly see this, my lord.
Not to disperse the award to those claimants, then not difficult. No, sir.
Now the institution is required to deposit. But I may kindly go to para 31 of the judgment for a moment. At page 650. Would you allow this?
I am there, sir. Yes.
The principles of statutory interpretation 14 section so and so. The distinction between what is and what is not a right reserved by the provisions of section 6 of the General Process Act is often one great fineness. What is unaffected by the repeal by a statute is a right acquired or accrued under the accrued it, and not a mere hope of expectation of the liberty to apply for acquiring a right. A distinction is drawn between a legal proceedings for enforcing a right acquired or accrued and the legal proceedings for acquisition of a right. The former is saved, whereas the latter is not.
No, one moment. When was the reference sought for by the
reference
private?
is sought for in 2000, in between 2000 to 2002, which was
2002
pending. 2000 to 2002. Reference was pending. That was decided after. But no landowners have sought for reference in par with the other applicants are concerned. Now those persons who are not sought for reference, could they have the benefit of 28 capital A or not?
Now who has sought benefit of 28A?
They are not made as a parties because they only few farmers, only 6 or 7 landowners.
Now the institution will be required to pay?
Yes, the award is passed against us. Even my lord, in that process.
No, whether it should be under, now the reference civil court decides in 2020. Award passed by the civil court on reference in 2018, 19, 20. Correct.
Now your question is, my lord, those landowners' right is preserved by virtue of repealing of the enactment, particularly section 6.
We'll see, let him file your objections. First time Bharta, let him file his objections. What interim order you have sought?
Interim order, my lord, that order annexure M has to be stayed, my lord.
For 2/4/2025.
Yes,
That is the award?
annexure M, page 148. There also there is an error. No inquiry is conducted. What the compensation enhanced by the civil court in respect of X, uniformly it is enhanced to everyone. Law doesn't say so.
That is the purport of 28A.
Also 28A, what it says is.
Enquiry should be conducted.
Yeah, correct. Enquiry should be conducted. Market value to be determined on the basis of fertility of the land.
You file your objections. Yes, I heard the learned HCGP is directed to accept notice sold or returnable by status quo que the compensation award ಆಗಿದೆಯಲ್ಲ ಈಗ?
ಆಗಿದೆ. Annexure M, page 148.
The order impugned shall remain state till the next date. List on 9th September.
Great.
Yes, next.
28.
Vacating interim order. Yes, Ajay Kumar.
Please. Petitioner's counsel, my lord. Challenge, my lord, is this. We own property in survey number 11/3. Vide contents, my lord, that we have enforced property in 11/1, and therefore they have initiated proceedings under section 33 of the BDA. Lords may take the statement of objections filed by the BDA. Just put 2 points, my lord. Lords may kindly come to the layout plan at annexure R6, my lord. I'm sorry, my lord, I don't have the page number, so I just refer to 27, my lord.
Page
32. R6. R6. 27, my lord, I believe it's 27.
R6. One moment.
27. Page number miss agide. I apologize.
R6.
The page number akila, but
27. 27.
27. 11/3 is not acquired.
11/3 not acquired.
This is not acquired. They contain, my lord, we have enclosed upon site bearing 1918.
1918 ಎಲ್ಲಿ ಬರುತ್ತೆ?
1918.
18 that is ಪಕ್ಕದಲ್ಲಿ.
My lords may see site number 1925, the last site in the same number. And the site below me 2112. Now my lord, take the sketch that they have prepared, my lord, stating that how the encroachment has taken place at page 32. My lords may see 1925, the last site, my lord, which I mentioned. What was a quadrilateral site, my lord, has now been become a rectangle site.
1925,
the last site. Layout plan alli quadrilateral ಇದೆ. It's almost a triangle site. Now that has been made into a rectangle site. Thereby pushing all the sites to the west. It is on this ground they contend, my lord, that we have encroached upon this. Now, my lords may see 2122. 2122, my lord, according to the layout plan, is the survey number 11/1. But according to the sketch, my lord, they have encroached upon 11/3. Whether they should say, my lord, the layout plan is wrong or the sketch is wrong.
My lords, the question is whether the property in question, my lords, is in 11/1 or not, my lords.
2 points.
My lords, I'm willing, my lords, I'm very much willing, if this court is also directed, my lords, to conduct the survey, my lords, by the ADLR to find out the boundaries of 11/3. That would sort out the matter.
Yes. The petitioner is before this court.
Yes, one other point, my lord, I just point out. The proceedings that are initiated, my lord, under section 33. 33 is for violation of section 32. Section 32, my lord, where
So first we'll get the survey, then decide. The petitioner is before this court seeking the following prayer. Owing to the statement of the petitioner, an interim order was granted. The respondent BDA has filed its application seeking vacation of the interim order. The issue is with regard to encroachment of the property belonging to the BDA or the BDA altering the plan altogether, which depicts an encroachment pursuant to the said alteration. The sketch is produced by the BDA themselves as annexure R6 and R8. The learned counsel Abhinay Vaiti takes this court to the sketch to demonstrate that it is the changed plan that projects as if there is an encroachment Survey number 11/3 was never subject matter of acquisition. The learned counsel for the respondent submits that whether the property would fall within survey number 11/1 or 11/3 is what is required to be answered. In that light, I deem it appropriate to direct the Assistant Director of Land Records of the jurisdiction to conduct a survey in the presence of the BDA and the petitioner both, and file a report of such survey before this court on the next date. The survey shall be conducted on the 19th August at 11 a.m. No separate notice need be issued to the petitioner. Issued to the petitioner. It is his responsibility to be present at the place and time of survey. The learned HCGP shall communicate to the Assistant Director of Land Records to comply with the order by as directed. The report of such survey be placed before this court by the next date. Interim order subsisting shall continue till the next date of hearing.
One request, my lord. Could the ADLR be directed to measure the site of 1925 as per the layout sketch? My lord?
Question is only 11/3, my lord. They can't expand the scope.
11/3 or 11/1?
That's all. Whole contention is, my lord, 1925 has been enlarged, thereby pushing all the sites this side.
My lords, they are not on the
My
question.
lord, I don't understand why they are objecting for 1925.
ನಿಮ್ದು 11/1 ಅಲ್ಲಿ ಇದೆ ಅಲ್ವಾ? 11/3 ನಿಮ್ದು.
11/3.
11/3 measure ಮಾಡಿ.
Please.
Yes. ADLR along with the assistance of the surveyor of the BDA.
Please.
Yes. Please.
As per the layout plan, not my clarifying, because what they are doing, my lord, they are not relying on the layout plan.
My lords, they have to go by the
We'll
boundaries
see.
of the
Yes.
survey number.
ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡ. 22nd. ಅಲ್ಲ ಸಾರಿ 20 ಯಾವತ್ತು ಹೇಳಿದೆ? ಲಿಸ್ಟ್ ಆನ್ 23rd. Yes.
Please.
Madam, 23rd ಅಲ್ಲ. What is the next?
29.
ಯಾವತ್ತು ಹಾಕಿ? 29th. Yes.
My lords, in this case, writ of mandamus, the petitioner of.
Yes, Krishna.
My lord, annexure R11, my lord, page 38. This is the covered by judgment, your lordship, the division bench judgment. And the last time your lordship directed us to produce the Google map, whether they have constructed the earlier to the.
Correct. Produce ಮಾಡಿದ್ದೀರಾ ಈಗ?
ಹೌದು. Annexure, my lord, annexure R4, page 31. This is from October 2017, my lord, ಅಲ್ಲಿ ರೆಡ್ ಅಲ್ಲಿ ಪಿಂಕ್ ಪಿನ್ ಇದು ಮಾಡಿದೆ ಸರ್.
ಅದರಲ್ಲಿ ಏನು ಇಲ್ವಾ?
ಅಲ್ಲಿ ಅದು ಖಾಲಿ ಆವಾಗ.
There is a AC sheet shed, my lord.
This is October 17, 2017, it was vacant, my lord. And January, next document, January 18th, my lord, it is also vacant by that time, that red pin. And April also, my lord, the portion was vacant. And October 2018, they started commencement of the the structure was started. Next, the R7, my lord.
13/4/2019 ಗೆ ಸ್ವಲ್ಪ ಸ್ಟ್ರಕ್ಚರ್ ಬಂದಿದೆ.
April 19 ಗೆ it was.
My lords, in the year 2000, much prior.
Google Earth will not lie, sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಅದು ತಾವು annexure R4 ಅಲ್ಲಿ ಗಮನಿಸಬೇಕು. There is the AC sheet shed house. Prior to that, there was the electrical connection. May kindly peruse, I have produced the electrical connection provided to the scheduled property.
Yes, sir.
Much prior to the ತಾವು ಗಮನಿಸಬೇಕು. Annexure, may kindly, one moment kindly.
We have ourselves division bench ಅಲ್ಲಿ ಇದೆ ಬರ್ದಿರೋದು.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. Annexure C1 may kindly peruse at page number 36, my lords. Page number service certificate.
Precisely why Google Earth images are sought.
ಅಲ್ಲ Google images are correct, my lord. But ಇದರಲ್ಲಿ AC sheet shed house ನಾನು ಪರ್ಚೇಸ್ ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲಿಂದನೂ ಇದೆ.
ಅದಕ್ಕೂ ಎವಿಡೆನ್ಸ್ ಆಗ್ಬೇಕು ಅಂದ್ಬಿಟ್ಟು. ಆಮೇಲೆ yes.
So therefore my request to the honorable, they have demarked my property in a portion without following a due process of law.
No due process. It is construction post final notification.
My lords, no, my lord, kindly peruse the annexure C1 for a kind moment. Annexure C1.
Anything else, sir?
My lords, annexure C1 at page number 36.
Division bench is clearly held, sir.
But they have not, my lords, in the division bench order, it is clearly directed by this honorable court to give instruction regarding the order passed by this honorable court. But they never ever till today, they never.
ಇವಾಗ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದೆ, ಮನೆಗೆ
ಅಲ್ಲ
ತಂದು
ಸ್ವಾಮಿ,
ಕೊಡ್ಬೇಕಾಗಿತ್ತಾ?
ಈ ಆರ್ಡರ್ ಬಗ್ಗೆ, ಯಾವ್ದ್ರ ಬಗ್ಗೆ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಬಗ್ಗೆ, in the order itself it is clearly mentioned at page number.
Oh, no, nothing.
May kindly peruse that page number 46 of their paper book, my lord. Page number 46.
Yes, sir.
It would be the duty of the VDA to communicate this order to all the 310 cases that is projected by the learned advocate general. My lords, they
ಈಗ
are
ಆಯ್ತಲ್ಲ,
not,
ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿದೆ, ಏನ್ ಮಾಡ್ತೀರಾ? ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ, at least ನಮ್ಗೆ
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಹೇಳಿ? ಈ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? 3 ತಿಂಗಳು ಟೈಮ್.
ಅಲ್ಲ, ಯಾಕೆಂತಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರೆ ನಮ್ಗೆ ಯಾವ್ದೇ ರೀತಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ನೋಟಿಸ್ ಕೊಡದೆ ಏಕಾಏಕಿ
ಅದು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಡಿಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಏಕಾಏಕಿ ಅಲ್ವಲ್ಲ, ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿರೋದೇ ಆಫ್ಟರ್ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್.
ಅಲ್ಲ, ಬಿಫೋರ್ ದಟ್ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಆಗಸ್ಟ್ 2018 ಗಿಂತ ಮೊದಲು ಏನ್ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಕನೆಕ್ಷನ್ಸ್ ಬಿಲ್ಡಿಂಗ್ ಇರುತ್ತೆ, ದಟ್ ಇಸ್ ಟು ಬಿ ರಿಲೀಸ್ಡ್ ಫ್ರಮ್ ದ ಅಕ್ವಿಸಿಷನ್ ಅಂತ ಇರುತ್ತೆ. ಅಲ್ಲ, JCC ಕಮಿಟಿಯಲ್ಲಿ
JCC ಕಮಿಟಿಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ, ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಕನ್ಸಿಡರ್ಡ್, ಮೈ ಲಾರ್ಡ್. ಸೊ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಟು ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್, ಅದ್ ಏನ್ ಪೋರ್ಷನ್ ಹೋಗುತ್ತೆ ಅದನ್ನ ಏನ್ ಪ್ರಾಪರ್ ಮ್ಯಾನರ್ ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ತಗೊಳ್ತಾರ ತಗೊಳ್ಳಿ.
Compensation are entitled to. It's not in accordance with law, they will take it over. But construction has come up after acquisition. Google it.
Necessary orders may be pardoned. Liberty may be given to the petitioner.
You have to acquire the land in manner known to law, whatever scheme is there.
No, it is acquired, my lord.
Already acquired. Sir,
Already
you say
acquired.
compensation will be paid.
That is entitled.
Liberty may be given to the petitioner to exercise his rights to get compensation.
Oh, yeah, you have undoubtedly you have, sir. Yes. Then we'll restrict it to that. ಎಲ್ಲ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡೋದ್ ಬೇಕಾ? ಮಾಡ್ತೀನಿ.
ತಮಗ್ ಬಿಟ್ಟು
ಹಂಗ್ ಬಿಟ್ಟಿದ್ದ, ಹಂಗಾರ ಮಾಡ್ತೀನಿ. We'll pass orders at 2:30. ಮುಗಿಸ್ಬಿಡಿ ಮೇಡಮ್.
30.
Your Lordship, this is regarding the rejection of my change of land use application, Your Lordship.
Why? You're hungry?
Sorry.
You're hungry?
No.
Then why ಸ್ವಲ್ಪ ಜಾಸ್ತಿ?
This is with regard to the rejection of my change of land use application by the BDA, Your Lordship. You'll find that particular endorsement at Annexure A.
Yes, Vijay Kumar.
The order at Annexure Q, my lord, says.
Directly covers the matter, Your Lordship. The coordinate bench's order directly covers the
Page.
Page 81.
81, Your Lordship.
81. Last time I marked it.
Please.
We'll close it. The petitioner is before this court, 109 now, all right. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that identical issues have been considered and ordered by coordinate benches of this court. He would seek to place reliance upon the judgment rendered by the coordinate bench in page 81. The coordinate bench is held as follows. You quote para 2 in the order. In the light of the learned counsel, Ajay Kumar is not in a position to dispute the position as is considered by the coordinate bench. In that light, the petitioner deserves to succeed and become entitled to the same order that is passed by the coordinate bench, ordered accordingly.
Application may be
ಅಲ್ಲಿ
considered
ಏನ್ ಹೇಳಿದ್ದಾರೆ?
3 months.
Same.
Same, yes.
3 months.
Same order.
Great, Your Lordship.
Please. Great.
Matter pertains to Nadaprabhu Kempegowda layout matter.
Nadaprabhu
Kempegowda.
ನಾಡಪ್ರಭು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
Please, my lord.
ಎಲ್ಲಿ ಯಾರದ್ದು? ವಸಂತ ಯಾರಿದ್ದಾರೆ? ವಸಂತ್, ನಾಡಪ್ರಭು ಟೈಮ್ ಬೇಕಾ ಇಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ? ಜಡ್ಮೆಂಟ್ ಯಾವ್ದು ಕೊಡಿ. Counsel Vasant is directed to accept notice for the respondents for 1 HCGP, 2, 3 and 4, 2 and 3 Vasant. Same order, madam. Illide.
How to take precipitative?
Huh?
How to take any precipitative steps? In that order, my lord, the last page.
Not paid?
How to take any precipitative
I accuse Madi, sir. What is all
Take
this?
any course of action.
That is the same order, yes. If you whisper to yourself, hell kedatte.
32.
General award covered.
Literally, my lord.
Page 29. You ಬೇಕಾದಷ್ಟು. Page 61. 61, same order.
Same one.
Yes, supposed. Go to the second list. Madhyana 2:30 second list on.
Lordship, developed land.
Huh?
Developed land.
They want
Developed
they
land
want
better.
Milord developed land in view of Milord the monetary compensation. Same as Milord the page number 61.
Page 61, same order.
Same one.
Same one.
My lord, apologies for giving memo, my lord, there is urgency.
Wait, no, madam. Why? What's the urgency?
Yesterday, I filed given memo, my lord, but WP number ಇದ್ದಿದ್ದಿಲ್ಲ. ಅದಕ್ಕೆ
ಈಗ WP ನಂಬರ್ ಇದೆಯಾ?
WP number ಇದೆ.
ಯಾವಾಗ ಬೇಕು?
ನಾಳೆನೇ ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂಡ ಇದೆ.
ಆಯ್ತು.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದು ತರಿಸಿ ಮೇಡಮ್. End of the list. Yesterday moved the matter, right?
Yes.
Posted? ಅನ್ವಲ್ಲ ಬೆಳಗ್ಗೆ ಇದ್ರಲ್ಲಿ Monday not possible. On 13th perhaps. 13th. For the respondent, very fair. Interim order may be extended. Yes, yes. Yes. Second list.
List number 3, pronouncement.
Pronouncement.
Pronouncement of order.
And for the respondent, look at.
Bill number 1.
Dismissed. Interim order of any kind subsisting shall stand dissolved.
Great.
Bill number 2.
Allowed in part. The impugned order dated 8/10/2024 passed by so and so stands set aside. The matter is remitted back to the concerned court to consider the application filed under section 245 of the CRPC afresh in the light of the orders passed by the coordinate bench super. You ಕೇಳಿದ್ದು ಅದೇ. Yes. Yes.
Number 3.
Allowed. ಇದೆಲ್ಲ ಮರ್ತೆ ಹೋಗ್ಬಿಟ್ಟಿತ್ತು. Allowed question.
4.
Back to B report consider matter. Allowed in part, matter is remitted back to the hands of the concerned court to pass necessary orders bearing in mind the observations made in the course of the order within 4 weeks from the date of receipt of the copy of the order. The issuance of process dated 4/7/2024 stands quashed.
5.
Writ petition is allowed. The order dated 15/2/2025 and so stands quashed. The concerned court is directed to take this suit to its logical conclusion as the matter was reserved for its order at the time when IA 1 of 2024 was filed and render its judgment at an outer limit of 4 weeks from the date of receipt of the copy of this order.
Number 2. Number 1.
Offenses are non-compliance of office objection. ಅದೇನು? What's the matter? Husband? What kind of interim order in a dissolution?
She appears before the court the last when they see page 130. She appears before the family court on 31/5/2024. She files an application seeking appointment of an advocate. Not the advocate was appointed, and the matter was referred to mediation very same day. Not right immediately next day in the hour, she goes and files this record. 1/6/2024 the FIR. After some time, my lord, she files a petition for review. Thereafter, my lord, filed immediately after she received the notice.
Yes, madam. Allegations against? Two and ಇರೋದೇ 3 ಜನ ಇಲ್ಲಿ. 3 ನಾಲ್ಕ ಮೂರ ಯಾರ್ಯಾರು? Heard the learned counsel appearing for the petitioner and the learned HCGP. The emergent notice to the complainant. First, office objections overruled anta ಮಾಡಿ ಮಾಡಿ. Emergent notice to the complainant, returnable by the 12th of September. The petitioner is the husband. The first petitioner is the husband to mother-in-law, to Mill, Sil, Bill of the second respondent complainant. The allegation against the petitioners are the ones punishable under section 498A, 323, 504, 506 of the IPC. Pursuant to the registration of the crime, the police conduct investigation and file a charge sheet. In the charge sheet against these petitioners, the allegations are as follows. Page 63, marked portion. A perusal at the allegations so made against the husband or other members of the family would clearly indicate that they are absolutely vague, bald against the other members of the family. Insofar as the husband is concerned, the day-to-day skirmishes that happen in the family between the husband and the wife is projected to become a crime for offense punishable under section 498A of the IPC. If further proceedings are permitted to continue against these petitioners, notwithstanding the fact of what is alleged against them being vague and bald, without any particular act attributable to any of the persons, would run foul of the judgment of the apex court in the case of Achin Gupta versus so-and-so, 2024 SSC online SC page 759. Therefore, there shall be an interim order of stay of further proceedings qua these petitioners till the next date of hearing. Yes, list on 12th September. Next. Oh, Friday, madam, sorry, 12th alla. 1 minute. We'll take it on 16th September. Yes, next.
Number 2.
Idu. Where's the file? Your phone is the file or file is the phone? Get the file. That I will do, sir. Avrigenu helta idini.
Lord, I am appearing, Lord.
Yes.
Please, Lord.
We'll take it Friday. Friday illa. Monday. List on Tuesday. At the request of the council appearing for the ಹೆಸರು ತೋರಿಸಿಲ್ವಾ? Learned counsel KB K Swami undertakes to enter appearance for the respondents 2 to 4 registry to print the name of so and so as appearing for respondents 2 to 4 in both these cases. There's a serial number 2 and 3, 2 to 4. List the matter on Tuesday. Yes. Interim order subsisting would continue till the next date of hearing. I heard the learned senior counsel Hasmat Pasha and Thakput Amal. Yes, next.
Obliged.
4.
Post immediately after service of notice upon the second respondent having deposited the amount. Could you, madam? ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಾ? ಪಿಕೆಟ್ ಮಾಡುವ? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಬೇಡವಾ? ಅದ ಸದ್ಯಕ್ಕೆ this court, owing to the submissions made by the counsel for the petitioner, had passed the following order on 7/7/2025. The interim order was granted subject to deposit of rupees 4 lakhs within a period of 4 weeks. 4 weeks has passed by. Not a rupee of deposit has come about. In that light, the interim order stands vacated, reserving liberty to the petitioner to seek its restoration once the deposit is made. Yes.
5,
ನಟರಾಜ್ ಬಳ್ಳಾಡ್ರೆ ಇದು ನಿಮ್ದೆ
same.
ಅದರಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಇಲ್ವಾ? ಸೇಮ್ ಆರ್ಡರ್, ಎಸ್.
6,
Yesterday's matter. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಬರ್ಲಿ ಜಗದೀಶ್ ಬರ್ಲಿ. ಪಾಸ್ ಓವರ್.
7,
ಮೇಂಟೈನಬಿಲಿಟಿ ಏನು?
Lord, what has happened in this matter is very strangely.
ಅಲ್ಲ ಏನೋ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ
ಅಲ್ಲ, injunction, ex parte injunction that is granted by the trial court, ಅದ್ರ ಮೇಲೆ WP ಬರತ್ತಾ ಇಲ್ವಾ?
ಬರುತ್ತೆ. ನಾನು ಧರ್ಮಸ್ಥಳ ಕೇಸಲ್ಲಿ
ಅದೇ ಮಾಡಿದ್ದೀರಾ? ಏನಾಗಿದೆ ಅಂದ್ರೆ, there is a suit for bare injunction. My lord, I am the owner of the suit property, my lord. I have got an injunction against defendant number 1 and anybody claiming through him in OS number 379 of 2025.
OS number
379 of 25. Your lordship would kindly take annexure G at page 113. 113.
One moment.
113 is the order sheet, my lord. In some other connection, this matter, that matter had come before your lordships, that's why.
I think in the GM roster that
yes,
police.
Correct.
Yes,
So, my lord, your lordship sees Tulip Enterprises, my lord. There's an interim order that is granted, your lordship would get. Please 116. The court hereby issues an ex parte interim ad interim order of a temporary injunction against the defendants or any other person claiming through them from restraining them from interference.
General injunction order.
So what has happened is that injunction order is served, everything is done, there's no difficulty about
This
it.
suit is still pending?
No, this is another suit that is filed by the son of defendant number 1.
Which is this suit?
Yes. This suit is still pending.
This 379 is still.
379 is pending.
All right.
And the interim order continues to be in force.
All right.
My lord, there was disobedience, therefore I came up, my lord, in GMCPC as far as police is concerned. Now, as between the defendant number 1 in that suit and myself, my lord, there is some settlement that is being proposed and some part payments are being made. Now, this son of the first defendant, my lord, who is the plaintiff in the other suit, your lordship would kindly take.
Which is the other suit?
2545 of 2025. That suit, my lord, your lordship will get at annexure K, page 131. Page 131 is the other suit.
All right.
132, your lordship would see. He files it against his father, who is defendant number 1.
All right. Yes.
The majority shareholder, the defendant number 1, my lord, is the chairman of the plaintiff company, and the son, my lord, is the managing director of that company. He claims that there is an agreement between the first defendant and the company, and your lordship would kindly take that agreement. The agreement is at annexure M, page 156.
Now what has happened in this?
Just have a look at it for a minute.
Page
156 is the so-called agreement. He himself is an agreement holder. Who? Defendant number 1. He enters into said to have entered into an agreement with his son company. Please look at 160, para 14. Possession is not delivered. Possession of the scheduled property shall be delivered to the second party at the time of execution of the deed of sale. Aure possession tagondilla. Now you please look at, my lord, the interim order that is granted, annexure N at page 162.
In this suit.
In this suit. Plaint ಅವರು ನಾವು possession ಇಲ್ಲಿದ್ದೀವಿ ಅಂತ ಹೇಳೋದಿಲ್ಲ. IA ನಲ್ಲೂ ಹೇಳಲ್ಲ. He just files an IA. Please look at 162, about 8 lines from the bottom of the page. Secondly ಅಂತ ಹೇಳ್ತಾರೆ. 162 is the order sheet in that suit.
Yes.
Secondly, and the 8 lines from the bottom of the page.
Secondly, yes.
The plaintiff contends that the defendants are interfering with his peaceful possession and enjoyment of the said property.
Where is the possession delivered? Where is the possession delivered?
No. He is more loyal than the king.
Possession is still with the father.
Possession is not with the father.
Then what is the agreement between the two? then?
Possession is with the plaintiff.
The
There was
plaintiff
only an
here,
agreement
yes.
of sale with the father. That agreement also I have produced. But anyway, this gentleman is not in possession.
Yes.
This company is not in possession. How does he get to this conclusion that the possession is delivered as far as the plaintiff is concerned? And your lordship sees, he goes on to say prima facie case, this, that, everything. And then if your lordship turns to 163, middle of the page, after the word order in capitals,
Yes.
2, in any manner either directly or indirectly interfering with the plaintiff's possession, peaceful possession and enjoyment of the social property, otherwise
The
obstruct.
claim in the plaint is on the strength of the agreement that you just now took this court.
Yes. And please bear with me, my lord, in the IA that is filed for injunction to not to interfere with possession, there is no averment that they have been put in possession. How did the judge, my lord, become so carried away by this and granted this injunction is wrong. Therefore, all that I am saying is, my
We
lord,
heard the learned senior counsel G.L. Vishwanath appearing for the petitioner. The petitioner,
office objection, your lordship, I just made.
office objections overruled, yes. The petitioner is defendant number 5. The petitioner himself, the petitioner company institutes a suit in OS 379 of 2025, in which the second respondent is the defendant. The concerned court grants an interim order of injunction not to interfere with the possession of the plaintiff therein. The order of injunction reads as follows. Page 116, 117. When things stood thus, the learned senior counsel submits that there are talks of settlement happening between the present petitioner and the second respondent. The second respondent is the father of the representative of the first respondent, who is the managing director of the first respondent company.
Is the father of the managing director, your lordship may say.
Father of the managing director.
Managing director.
Father of the managing director of the company, i.e. the first respondent. The tussle between the two, the further claim of the first respondent plaintiff is that there is an agreement of sale entered into between the company and the second respondent.
156.
The agreement of sale is appended to the petition. The agreement of sale indicates that the possession of the property would be delivered only after execution of the sale deed. Where do I get that?
160.
Clause?
Para 14.
Clause 14. The deed of sale admittedly is not executed. The first
He's
respondent.
an agreement holder of an agreement.
The deed of sale is yet to be executed. The agreement holder of an agreement to sale, as quoted here and above, institutes the subject suit in OS 2545 of 2025, claim 2025, wherein the concerned court grants an interim order, interim injunction, which reads as follows, marked portion 162, 163. Ostensibly, the strength on which the suit is preferred by the first respondent is on an agreement of sale. The interim order granted is, interim injunction granted is that the plaintiff's peaceful possession should not be disturbed, while the agreement of sale nowhere hands over possession to the hands of the plaintiff. Therefore, him not.
Averment in the plaint or IA.
The learned senior counsel would add that there is neither an averment in the plaint that they are in possession of the property. Even otherwise, the interim order that was operating in 379 of 2025 is still in subsistence, where no person claiming through the defendant also, no person claiming through the defendant is also injuncted. The petitioner is claiming, admittedly claiming through one of the defendants therein, that too on a strength of an agreement to sell which does not deliver possession. In that light, there shall be an interim order of stay of the order impugned in the subject petition. petitioner shall serve on the council who, ಬೇರೆಯವ್ರು ಯಾರು?
Representing the caveator. Caveator is first.
ಕೇವಿಯೇಟರ್ ಇದಾರ ಈಗ?
ಇದಾರೆ.
ಮತ್ ಬಂದೇ ಇಲ್ಲ?
ಬಂದಿಲ್ಲ ಅಷ್ಟೇ. ಸರ್ವ್ ಆಗಿದೆ.
230 ಮೂವ್ ಮಾಡಿದ್ದಲ್ಲ ಅಲ್ಲ ಇದು?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಬರ್ಬೇಡಿ. No representation behalf the caveat.
ಶುಕ್ರವಾರ ಫೈಲ್.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದಿ. ಮಾಡಿ.
Yes.
Dispensation entry ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Senior counsel ಮಾಡಿ no representation behalf the caveat. Yes. Siddharth.
Please, not P&SC proceedings where we are the two sole surviving legal heirs of one late Annapurna, my lord. During the subsistence, my lord, in fact, there's, my lord, I had asked for succession certificate. It is a letter of administration which is then subsequently given. Thereafter, my lord, because Saroja, that is one of the other co-petitioners with me, my sister, she's a spinster. She was unwell, my lord. I was permitted by the Honorable Trial Court.
Letter of administration problem.
Ashte, my lord. So I'm only asking for, because both of us are the only sole surviving legal heirs. So now, my lord, Annapurna was a spinster.
This has some ramification if a law is laid down. So tomorrow we'll take it. You have not given me anything.
My lord.
You have not given me any other judgment or other.
Lord, it's not
we'll
because
see.
it's quite
it has ramifications.
Because both of us were adjudicated already as the.
It has wide ramification, all the pending things of the kind.
Please, but anyway, tomorrow I'll point out, please. Please.
Otherwise, I have it with me, that is why.
Please, please.
9.
Both. ಇದು ಅಷ್ಟೇ 9 ನಿಮ್ದು ಅಷ್ಟೇ ನಾಳೆ
10.
ನಿಮ್ದು ಅದೇ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲ ಕೊಡಿ ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಬಿಡ್ರಿ ನಾಳೆ ಹಾಕ್ತೀನಿ. ಎಸ್
My lords, kindly pass out the matter, my lords. And for respondent number 1.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1. ಧ್ಯಾನ್ ಚಿನ್ನಪ್ಪ ಇಸ್ ನಾಟ್ ವೆಲ್ ಅಂದ್ರೆ?
Nalla, Chintan Chinnappa.
Oh, sorry. Pass over ಯಾಕೆ? Pass over. He is here anyway.
My lords, so we are also ready, my lords, kindly pass over. He's held up in other courts. That's
I'll take it about 4 o'clock.
Yes, my lords.
Yes, next.
11.
11, my lord, is that KSRTC we had sought extension, my lord, for a period of 6 years on parity with what was given in Shimoga. I'm told, my lord, now Shimoga bus stand ali, the petitioner here.
Bus stand ali.
Oh, the bus stand ali. The commercial space was.
This is bus stand commercial space.
Correct.
Yes, yes.
The KSRTC is the answering respondent.
Why did you?
In fact,
ನೀವು ಇದ್ದೀರಾ?
ಇಲ್ಲ, if the copy was served, my lords, I'm told, I think Mr. P.D. Surana was requested to appear. As instructed by lordships, we served copies on Renuka Madam. But now our apprehension is this, my lords. When we had sought for extension.
Where are those other extension orders?
Kindly see Shimoga, my lords, will find at page 62.
62.
It's 62.
Extended concession agreement.
Yes, my lords. Made on 15.
Initially, ಎಷ್ಟು ವರ್ಷ?
That, my lords, will find at page 64. Original concession agreement has come into existence between first and second party on 27/6/2012. This was
ನಿಮ್ದು ಎಲ್ಲಿದು?
This is Mysore Road. On the way to Mysore, the orchard would have seen on the left-hand side.
Oh.
That's just before that.
No, this is Shimogadal 27/6/2012.
Correct, no.
ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಅದು?
Up to 2025 it was.
25 or 24?
24, sorry. Then now it's up to 2030.
Where do I get that?
I'll just point it out. Where is it, Shamil? Extension to 62. Page 62 itself.
62?
62 itself. Yellow. No, it's not.
30 ಅಂತ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ?
I'll just point it out. Wait, if he wants to see Shimoga, show me something else. Page 81. 81.
Annexure G.
ಇಲ್ಲ.
ಅಲ್ಲೂ ಇಲ್ಲ.
ಅದು ಇಲ್ಲ. I'm so sorry. 1 second.
No problem.
I'll just point.
ಇದು ತುಂಬಾ ಐಪ್ಯಾಡ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆದ್ರೆ ಇದೇ ಆಗೋದು.
That's true. That's true.
Yes.
Very true. But there's one document pursuant to this.
No, you show me anywhere that it is
it's
extended now.
Yes,
That's all.
It is done. Document number 1 in that memo. Showing this document.
Extend your to 2511, this is Shumaga, is it?
Same Shimoga.
Then why is it not done in your case?
Same thing. We asked for parity in terms of this. In fact, I'm told that even in Mysore it was done up to 2013. But that document.
Heard the learned senior counsel, Vikram Holigold, appearing for the petitioner. The petitioner calls in question a tender notification issued on 17/7/2025, putting the subject in shop either.
The premises.
Subject commercial premises to tender. The petitioner is allotted a premises in Mysore bus stand.
Yes,
In Mysore Road Satellite Bus Station. A retail space on 23/5/2013. The license agreement was to be in subsistence up to for a period of 12 years, which would expire in the year 2025. 22/5/2025. The petitioner submits a representation seeking extension of license for a period of 6 more years, as the KSRTC has done in every other division. The learned senior counsel, as an illustration, places on record a extension agreement, extension order, extending the tenure from 26/11/2024 to 25/11/2030, which would be 6 years in the said case. The petitioner is said to have sought the same benefit from the hands of the respondent KSRTC, denial of which and putting the same place for tender has driven the petitioner to this court. In the light of the KSRTC themselves extending in an identical circumstance for a period of 6 years, I deem it appropriate to grant an interim order of stay as is prayed for till the next date of hearing. Therefore, the petitioner shall not be evicted from the premises or his business till the next date, lest the matter on 12th September. Huh?
The payment, of course.
Without payment.
Number 12.
That the injunction suit is filed. The lease is up to 2047.
Now no student should be troubled. That's the only concern.
No, demolition, page 122.
Demolish ಮಾಡಕ್ಕೆ ಹೇಳಿದಾರ?
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮಾಡ್ಬಿಟ್ಟಿದಾರ.
Front side. Page 122, my lords. JCB plus entrance.
JCB plus entrance.
Alla, JCB in the entrance.
JCB in the entrance.
Then next page is fully demolished. Main gate. And defendant is the sister of lessor. Lessors have filed an FIR.
Why? What is the problem between the two?
They wanted a share in the property. It is for
Property alla, fees.
11 lakhs I am paying rent. If
Fees
they want any right, Palat, they will have to file a suit.
Idu brother and sister. Huh? Heard the learned senior counsel V. Lakshminarayan appearing for the petitioner. The petitioner is before this court on the score that the concerned court has only issued notice in an application and order 39 rule 1 and 2 of the CPC and not granted injunction as was required, as was sought for. The learned senior counsel submits that the petitioner is a license holder or a petitioner is a tenant/lessee from the hands of the second defendant.
We have not implemented the lessors.
Okay.
Because we have no grievance. Now the
Who are the defendants?
They are the sister of the lessor.
ಎಲ್ಲ ಬ್ರದರ್ಸ್ ಇದಾರೆ, ಸಿಸ್ಟರ್ ಯಾರು? ರಾಜೇಶು, ಹರೀಶು, ಸಿಸ್ಟರ್
Sister Maklu.
ಸಿಸ್ಟರ್ ಮಕ್ಕಳು.
Yashodamma is the sister.
So, ಬಿಡಿ. So, the learned senior counsel submits that about 400 students are studying in the institution run after obtaining the same on lease, and the lease of which is in subsistence up to 2028. The learned
2047, 30 years.
2047 na? KIDB lease ಇದ್ದಂಗಿದೆ. Yes. 2047, yes. The learned senior counsel would further take this court through the documents appended to the petition to demonstrate the students studying and the property being damaged by the act of the respondents. A crime also is registered against the respondents by the petitioners.
By the lessors. By the lessor.
The crime is registered by the lessors against the present defendants in crime number 925 of 2025. Sorry, 295 of 2025. In that light, owing to the fact that children studying in the institution would be put to jeopardy, I deem it appropriate to grant the temporary injunction as was sought for before the concerned court till the next date of hearing. The petitioner shall serve on the counsel representing the defendants all represent agilla.
Innu madilla.
The
Notice order.
the defendant shall be served by way of hand summons, and an acknowledgement of such service be filed before this court on or before the 18th of August. List the matter on 3rd September. There shall be an interim injunction till the next date. Injunction as was sought for before the concerned court till the next date. Yes, admission. HDFC. Bani.
My lords, the sole objection that is taken by them, which was pointed out on the last date, is that there is a separate article in the Limitation Act on possession, my lords, 12 years. That, my lords, will see that it is, you expressly uses the words based on title. Only if they can claim, only if they can establish title. Present suit, my lords, prayer A is a declaration on perfection of title. So they themselves are not sure and have sought declaration of title. Therefore, that objection goes. My lords, two judgments I filed on the previous date.
Yes,
my
sir.
lords would be well aware of the Central Bank of India, my lords, to say that DRT does not have.
Heard both of you. No time to reserve now. We'll post it on next Friday for dictation. Kodi adu kotbidi.
That's only to point out the on coming Friday. May I take a minute's time, my lords?
No minutes, sir. Over. Yes, anta
Lords, it's only that, my lords, when I was submitting repeatedly, I was interrupted. I don't know, my lords. whether-
Repeatedly who interrupted you, sir? Why?
My lords, may recall on that date, I was not even completing a sentence before my learned. My lords, only on 7 rule 11, my lords, only on limitation. They have- Lords, in fact, one submission I.
Surana sir. ಅದೇನು ಅದ್ರಲ್ಲಿ ನೀವೇ ಅಪೇರ್ ಆಗ್ತೀರಂತೆ? ಹಾ, ಇಲ್ಲೇ ಇದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಆರ್ಡರ್, ಬಟ್ ಏನಾದ್ರು ಇದ್ರೆ ಯು ಕ್ಯಾನ್ ಸಬ್ಮಿಟ್ ಆನ್ ದಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಶಿವಮೊಗ್ಗಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ, ಮೈಸೂರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ, ಇದ್ರಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
There in the agreement, I couldn't point it out, page 65.
ಆಯ್ತು, ವಿಲ್ ಸಿ. ಏನ್ 4 ವಾರ ಏನಾಗಲ್ಲ, ವಿಲ್ ಸಿ. ವಿಲ್ ಪೋಸ್ಟೆಡ್ ಇಟ್ ಆನ್ 12th. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೊತ್ತಿಗೆ. 12th ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಸ್, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡಿ.
May then, my lords,
Next post it on 14th, madam.
may then, my lords, just make one submission, my lords. My lords, I had stated on the previous date that they have misled this honorable court and tried to, my lords, whatever limitation was not available.
ನೀವು ಮಿಸ್ಲೆಡ್ ಅಂದ ತಕ್ಷಣ ಅವ್ರು ಮತ್ತೆ ಶುರು
ಅದಕ್ಕೆ ನಾನು ಉತ್ತರ ಕೊಟ್ಟಿದ್ದೆ. My lords, please, just one submission, my lords. My lords, I had stated that was the case, my lords, that a dead cause of action they tried to revive on the shoulders of this honorable court. With due respect, my lords, I would make a further submission, my lords. Even if so, what right was not available to them under law, they cannot misuse or cite an order of this honorable court in order to sustain that. And based on that, my lords, my 7 rule 11 stands. 2021 cause of action is has died, my lords. 23 is, and those judgments, my lords, Central Bank of India, my lords, available.
Both will consider. Yes.
My lords, it ಕೊಟ್ಟಿದ್ದೀನಿ sir last week. Citation ಕೊಟ್ಟಿದ್ದೀನಿ. May I just point out the relevant paras, my lords? I'll take less than a minute.
ಬರ್ದ್ ಕೊಡಿ.
Very well, my lords. I'll do that. I
Kate,
just
do you have
endorse
the
it on the.
printout?
I've already filed it, my lords. I'll endorse
Yes,
it on the memo.
indicate the paragraphs and.
Certainly, I'll do some. Yes.
Yes.
Grateful.
ಅಕ್ಟೋಬರ್ ಬೇಕಾ? ಸೆಪ್ಟೆಂಬರ್ಗೆ ಹಾಕಿದ್ದೀನಿ. ಟೈಮೇ ಇಲ್ಲ ಸರ್. ಇವಾಗ 4 ವಾರ ಬಿಸ್ನೆಸ್ ಮಾಡಿದ್ರೆ ಏನಾಗಲ್ಲ ಬಿಡಿ. ಎಸ್. We'll post it on 12th. 12th ಬೇಕಾದ್ರೆ ಆಗಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ 3rd ಸೆಪ್ಟೆಂಬರ್ ಅಷ್ಟೇ. 1 ವಾರ ಮುಂಚೆ 3rd ಸೆಪ್ಟೆಂಬರ್. ಆಲ್ ರೈಟ್. ಎಸ್. ಸೇಮ್ ಇದು ಮೇಡಮ್. ಸೀಲ್ ನಂಬರ್ 11 ಸೀಲ್ ನಂಬರ್ 11 ಅಸಲ್ಲ. ಸೀಲ್ ನಂಬರ್ 11. ಎಸ್. ಅದೇ ವಿಕ್ರಮ್ ಹುಳಿಗೋಳ್ ಸರ್ ಅಪೇರ್ ಅದಲ್ಲ ಅದು. Delete the name of HR Renuka and print the name of PD Surana. Yes.
14.
Suit is barred under section 118 of Karnataka Cooperative Societies Act.
There. Next 22nd. ಈಗಲೇ ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದೆ ರಿಸರ್ವ್ ಮಾಡಿ.
The case of the plaintiff is that he has not been given possession after auction sale. And this is a
7
matter
rule
which is
11,
arising under Karnataka Cooperative Societies Act. There is a bar which is contemplated under section 18 of Karnataka Cooperative Societies Act.
ಇಂಟರ್ ಮಾಡ್ರ್ ಇದೆಯಲ್ಲ?
There is no dispute. This is a fresh matter.
Fresh matter. Yes, madam.
So, Your Lordship, they have taken the contention of section 101B clause 2, Your Lordship, and also 118. It doesn't give any remedy to regarding the purchase, Your Lordship. It gives remedy to the cooperative society and also the
We'll
judgment.
consider it. We'll post it on 12th September.
Your
List the
Lordship, a shorter date may be
List the
given.
matter on 12th September.
Your
In
Lordship,
the light
because-
of the issue regarding jurisdiction projected, further proceedings before the concerned court shall remain stayed till the next date. 12th will take. Get ready on 12th.
Been going on from decades, Your Lordship. 2003, the auction was held, Your Lordship. And since then, they have been trying to evade.
Who are you?
I'm the purchaser, Your Lordship.
Auction purchaser.
Yes, Your Lordship.
From whom?
From the society only. So when they had.
When
kept
did you
the-
purchase?
2003, Your Lordship. And we filed this possession suit in the year 2019. And later.
2019, why? You,
Because, Your Lordship,
you
they
have
were.
purchased and you are in possession.
Yes, Your Lordship, we have got the sale certificate also.
Then what happened later?
Later, Your Lordship, they kept filing a bunch of litigations and all got dismissed. And later we filed the suit for possession in the year 2019. So after that, they went ahead, they filed their written statement, they even gave evidence, even did the final arguments. And the argument stage, they filed the application stating that the suit is not maintainable, Your Lordship.
List the matter on 22nd in preliminary hearing.
Very
What's the
good.
next date there?
7th is the judgment, Your Lordship.
Posted for judgment day after tomorrow.
Why did you keep quiet all these years?
My lords, I have-
2019 ಇಂದ 25 ವರೆಗೂ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
But the trial court has rejected my.
When did you file the application?
It's at later
January,
stage.
Your
There is no
When,
doubt.
when did you file the application?
Application was filed on,
This year, January.
Wait,
that is on 15/1/2025.
suit is of the year 2019.
Correct,
You led evidence, everything.
correct.
Why did you file it in 2025?
My lords, if trial court has rejected my application on the ground that your application is belated,
I will,
then
I
there is
will,
no
I will
difficulty on-
reject, I will reject it on that ground.
If that is the situation, madam, now the finding says, trial court finding says that the civil court has got jurisdiction. That is my difficulty now. My lords, I'll put it in this way.
I
If
will
a trial
not,
court-
we will expunge all the directions and say it is filed after leading evidence and everything. 711 was not even
My
entertainable.
lords, if that is the situation, my lords, if trial court rejected my application on the ground that your application is belated, I am out. I have no case. In any event,
No,
now the
I will
difficulty
now,
is that.
I will set aside
Yes.
that order and say, permit the court to pass orders.
My lords, now.
711 application was not even entertainable, sir. After everything.
Yes,
ಎಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ 711 last resort and 26/9 application ಅದು.
that's right, my lord.
Yes, sir, it is rejection of a plaint.
Correct.
Then
My lords, it's a pure question of jurisdiction.
what question of
lords, in
jurisdiction
order
that
to
you can
protect
raise
the-
it even after the judgment antana?
My lords, I'll put it in this way. Now
Yeah,
trial
right,
court.
2019 in the, what is the problem? And auction purchaser, what is the problem? Who are you?
My lords, my lords, what had happened
Who
was.
are you, sir?
My lords, I am the owner of the property,
Borrower.
borrower. My case is that I have repaid the money and everything is solved. Thereafter I have
Why
sold.
should the auction purchaser suffer because of both of you?
No.
Then?
No, what the case of the plaintiff is that though the sales certificate has been issued, the bank has refused to hand over the possession is their case.
No, your lordship.
My lords, what the
Anyway,
section-
let the court pass the order. We will not permit rejection of the plaint on
My
that
lords,
score,
let
nor
the co-
stay the proceedings, no.
Yes, my lord.
List the matter on, ಯಾವತ್ತಿದೆ judgment ಗೆ?
ನಾಡಿದಿಗಿದೆ.
ಮಾಡ್ಲಿ ಬಿಡಿ.
My lords, ಅವ್ರು ಮಾಡ್ಲಿ ತೊಂದ್ರೆ ಏನಿಲ್ಲ. My lords, put it in this. My lords,
ಆಮೇಲೆ
one
appeal.
request. Now, my lords, my application is rejected on the ground, on the merits, saying that civil court has got jurisdiction to entertain the matter. My lords, my
That-
doors are
you-
closed now.
You challenge that in an appeal. That's a good
But
ground
see,
for
that
you.
is the
That's a good
observation.
ground for you to file an appeal
Which order, my lords?
against the final judgment.
Well, a final judgment, there is no occasion for the trial court to decide the question of jurisdiction because the question of jurisdiction has been already been decided by the trial court saying that civil court has got jurisdiction.
Civil
There
court
is-
has no jurisdiction.
I'm sorry, civil court has got jurisdiction to entertain the suit.
Then why
is
did you file
finding.
the 711 petition?
Well, I filed 711 application. That
ಸುಮ್ನೆ
is-
ಹಾಕಿದ್ದ?
If the
ಇನ್ನೆಂತ?
trial court has rejected my application saying that your application is belated, my lords is right.
You
in
trial
saying-
court leaves, sir, you leave the reason.
Right.
You forget the reason. The trial court order reasoning may be wrong, the conclusion is correct.
Correct,
All right?
correct.
So I will hold the conclusion to be right, the reason to be wrong. We will dismiss the petition. Let the court pass the order, all these grounds you take in the appeal filed against the judgment. ನಾಳೆ judgment ಇದೆ, ಇವತ್ತು ನೀವು 711 ಹಾಕೊಂಡಿರ.
Stay of case.
ಹಾ?
I'm aware of it, legal position. My lords may
ಅದು
say.
ಏನ್ 26/9 application court commissioner appointment ತರ 711 ಆಗ್ತಾ ಇದೆ.
Alla,
At the
what
end.
the, my lords, it can be filed at any stage of the proceedings.
ಅದೇ, that any stage is the problem.
But at
That is interpreted also, not after leading evidence,
Yes, yes.
doing everything. And at the end filing 711 application.
That's correct.
Alva? So dismissed.
My lords may dismiss my appeal, revision petition.
So 12th ಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ನಲ್ಲ, but for her insistence.
My lords, my lords may say that, my lords, I request my lord to
Ah.
say that, my lords, saying that the observation,
Hmm.
while rejecting application, the observation made by the trial court holding that civil court has got jurisdiction, should not come in the way.
Come in the way of what?
Well, so what happens is that now the matter is posted for judgment.
Correct.
Correct.
It will
Now,
pass its
at the
judgment.
time of passing a judgment, my lords, the civil court has already made up its mind and recorded.
Jurisdiction ವಿಷಯವಾಗಿ it has made up its mind,
Correct.
not on anything
Now,
else.
at the time of rendering the judgment, there will not be issues.
I will
regarding
only
the-
say 711 application Borolla, all these submissions can be urged in an appeal if you want to file after the final order is passed.
Yes, yes.
We will
Great,
dismiss it.
great.
Heard the learned counsel appearing for the petitioner and the respondent so and so. The petitioner is the defendant, is before this court calling in question an order of the concerned court rejecting an application filed by the petitioner under Order 7, Rule 11 of the CPC seeking rejection of the plaint. After arguing the matter at length, the learned counsel for the petitioner, allowing madi, so and so. The application itself comes to be filed on 15/1/2025, 6 years after the institution of the suit and the suit going through all the rigmarole of procedure. The application itself was not entertainable before the concerned court at the time at which it was filed. Notwithstanding the same, the concerned court entertains the application, renders an order rejecting the application. The rejection of the application cannot be found fault with, but the reasons so rendered appears to be on a slippery slope. Be that as it may, in the light of the application itself not entertainable at the end of the trial, I deem it appropriate to reject the petition, reserving liberty to the petitioner to urge all these contentions before the appellate court in the event he would get aggrieved by the judgment so passed by the concerned court, which is said to be listed for its judgment on 7/8/2025. Ordered accordingly.
Great.
Group still number 15.
Element of settlement.
That's the reason it was ordered to be referred to the mediation. But I don't know why it was listed.
Parties are before this court, my lords.
Parties are also there.
Sorry, mediation ಕಳಿಸ್ಬೋಣ?
My lords, one submission, my lords. 5 lakhs was borrowed in 1998, my lords. 4,70,000 is already paid, my lords. Now, our execution petition was dismissed on 2005, my lords.
Hmm.
After a lapse of 13 years, it was restored, my lords, which is bad in law. It's covered by Damodar.
Dismissed for what?
Non-prosecution.
ಎಷ್ಟು ಉಳಿದಿರೋ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾಗಿರೋದು?
Around 30 to 40,000 rupees, my lords.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಇನ್ನ 30,000 ಬೇಕಾ ನಿಮ್ಗೆ? ಹಾ, 3 ಲಕ್ಷ ಕೊಟ್ರು. ಹಾ.
After the restoration, they paid the amount of rupees 3 lakh.
Hmm.
Balance ಕೊಡ್ಬೇಕಾದ್ರೆ they filed a petition and they did not come forward. In fact, on the last occasion, they said we will settle it.
Lord.
ಅಲ್ಲ, ಬಟ್ 13 years ಆದ್ಮೇಲೆ how did the court restore it?
The only,
ನಿಮಿಷ.
Forego interest for that period.
ಹಾ.
13 years.
Oh, your foregoing of interest will take away limitation, is it? Oh. Otherwise, you're entitled to interest also for having kept quiet for 13 years.
my lord,
Address ಸಿಗ್ಲಿಲ್ವಾ?
the only reason that they have illustrated is they were unable to contact the counsel who were handling before the trial court, my lord. That was the only reason stated for 13 years lapse, my lord.
Hmm.
Relying on,
We'll set aside the order. 30,000 ತಾನೆ ಬಿಟ್ಬಿಡಿ.
30 ಲಕ್ಷ ಆಗಿದೆ.
30 ಲಕ್ಷ
They have
ಅದೆಲ್ಲಿಂದ ಬಂತೀಗ?
with interest, my lords,
ಅದೇ
21%.
you have foregone interest. ಈಗ ಎಲ್ಲಿಂದ ಇಂಟ್ರೆಸ್ಟ್?
ಈಗ ಅದು ಬಿಟ್ಟು ಈಗ 3 lakhs in fact we paid.
ಈಗ ಇಂಟ್ರೆಸ್ಟ್ you have foregone, sir. No interest. ಈಗ ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಎಷ್ಟು?
5 lakhs is the loan amount borrowed, my lords. In 1998, award was given for 7 lakhs.
ಹಾ. ಆಮೇಲೆ ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
Now 4,70,000 is what I'm instructed to state, my lords. 1,70,000 prior institution of award, my lords. After that, 3 lakhs has been paid recently, my lords.
ಇನ್ನ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
Another 30 to 40,000 is what we have to pay.
ಅಲ್ಲ 7 ಲಕ್ಷ ಅವಾರ್ಡ್ ಅಂತ ಹೇಳಿದ್ರು.
Award, for award ge 2 lakhs, my lords.
2 ಲಕ್ಷನ?
The difference amount have to be paid to award.
He's only talking about the principal.
ಇಂಟ್ರೆಸ್ಟ್ ಫೋರ್ಗೋ ಮಾಡಿಲ್ವಾ?
Interest forego for the period during which the miscellaneous was pending.
ಮಿಸ್ಲೇನ್ 13 ವರ್ಷ. ಈ ಅದು ಬಿಟ್ಟು ಇನ್ನು ಎಷ್ಟು ವರ್ಷದ ಇಂಟ್ರೆಸ್ಟ್? ಅವಾರ್ಡ್ ಡೇಟ್ ಏನು?
Award is dated.
29/12/2001, my lords. Award dated.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದು?
26/7/2002, my lords. It was dismissed on 11/7/2005, my lords.
ಹ್ಮ್.
Then miscellaneous.
Restored in 2018,
18, my lords. All ex parte awards, my lords. It's all gone on paper publication. Is 83 years old, my lords, the petition.
ಅವರು ಅವಾರ್ಡ್ ಎಕ್ಸ್ಪರ್ಟ್, ಆಮೇಲೆ ನೀವು ಎಕ್ಸ್ಪರ್ಟ್.
83-year-old petitioner, my lords.
ಅದೇನ್ ಮಾಡಕ್ಕೆ? ಯು ಸಫರ್ಡ್ ಎನ್ ಅವಾರ್ಡ್.
Covered by judgment, my lords, Damodar Pillai.
Kudi. We'll close it saying covered by judgment. Set aside the order in execution.
Lords, that is 7.5 years and the ours is 13 years.
ಬೇಕಾ?
Refer for the mediation at least. Original documents ಇದೆ. ಈಗ ನಾವು ಈ settle ಮಾಡ್ಕೊಳ್ತೀವಿ original documents.
Oh, threatening.
Threatening. The same, that was the.
Wow.
That was the only sole contention for mediation.
ಒಂದು 504, 506 ಹಾಕ್ಬೇಡ. Crime. ಆಯ್ತು, ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಲ್ವಾ? Mediation, yes. The issue is with regard to execution of an award. Award is of the year 2001 and the award is for an amount of rupees?
What was for
7,35,652 rupees.
7 lakh, so and so. The execution petition was dismissed for its non-prosecution in the year 2005 and restored in 2018. The learned counsel for the respondent parties submit that if the parties are referred to mediation, there could be a settlement of the dispute which is now 25-year-old. Therefore, the parties to appear before the Bangalore Mediation Center. ಯಾವತ್ತು ಹೈಕೋರ್ಟ್ ಇದೆ? ಆಯ್ತು, ಸರಿ ಇದ್ರೆ ನೋಡಿ. So and so on
Any date.
on 16th, on 18th at 3 PM. List the matter on 22nd. Settle ಮಾಡ್ಕೊಳ್ಳಿ. ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿರ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೊತ್ತಿಗೆ. ಇಲ್ದರೆ ಇವ್ರು ಇಂಟಿಮಿಡೇಟಿಂಗ್ ಅಂತ ನಾ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. Yes.
Okay.
16.
Just one, of course, these matters would have to be heard, but could I request?
ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
16.5, if my lords could kindly see, that is the one where there's some urgent interim relief that we're seeking. 16.5, 9757. Your lordship.
ಅಲ್ಲ ಬೇರೆ ಇದ್ರಲ್ಲೆಲ್ಲ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆಯಾ?
There is.
Interim order is already there. Interim order.
Not in.
Matter has to be heard.
kindly
My lord said,
16.5.
there is some urgency for the state. No,
No,
there's
I'll
a
point out with the
renewal
mistake the state is
RE
playing, my
policy.
ಇದು GM
Let's say it's a special orders matter, my lords. There's come up today before my lords. Earlier regular rosteral ಬರ್ತಾ ಇತ್ತು.
Kindly see 2nd April order, last two sentences.
2nd April order.
2nd April passed by your lordships. Objections, if any,
In which petition?
9757, 16.5.
ಅದು ಕೊಡಿ ಮೇಡಮ್. 16 So his lordship is disabled, is it?
I'm not sure.
No.
I'm not sure why.
Special order.
This number. 16 point.
I have granted an interim order.
Now, last two sentences kindly see, 2nd April. Now, initially interim orders were granted. Now, what happened is, despite interim orders being in place, they are still demanding the impugned levies. Now, we are paying 30% of the application, 100% of the application fee, 30% of the processing fee. Even then, now, in another matter, where your lordship's last sentence, first respondent state is restrained from precipitating the matter. They are using that to say, your lordship has restrained them from even considering our application for a GO. Not
ಇಲ್ಲ consider lords policy is with regard to
ಅದನ್ನೇ
consideration.
policy.
Policy is consideration including with regard to the fees. Now they are saying fees clauses are stayed. I am saying I cannot operate the policy. Court is accepted and race power has filed 2 cases. Matter is being tomorrow 2:30 it is being heard, my lords.
Where?
It was part heard, my lords, before Codal number 5. Codal number 7.
That is where that submission was made. Now that has nothing to do with this.
They have, my lords. No,
I'm glad.
They are relying upon this order there, and now they are coming and saying.
No, I want my GO to be processed. Now, when your lordship says no precipitation, that means not to recover the impugned levies. Doesn't mean don't process. Now that observation is being missed in.
Application process ಮಾಡಕ್ಕೆ ಏನಂತೆ?
Application process my lords, by virtue of.
It will remain subject to the result of the petition anyway.
My lords, 4 clauses have been stayed by my lords. Originally, my lords, all the clauses were stayed. Thereafter, it was modified only insofar as the petitioners were concerned. These petitions were filed subsequently, my lords. Earlier, it was filed with the association. There was a modification. The petitioner says that insofar as the applications are concerned, that we will not pay the amount. Application he wants to consider, but the stand of the state and credit
Will not pay the amount. They are paying. What is the amount being paid now?
100% my lords was in respect of wind. They are paying. We have made a submission in the before.
When there is a stay order of dishonorable court, why should I pay? If you're
Lords,
in the
there are
ground
total-
rent matters, for instance, when your lordship stayed it,
Yes.
there's no question of them saying no plan sanction.
No, that you
I
can't
process
say.
it.
Not to precipitate under doesn't mean that nothing should happen.
No, my lords, our contention
Not
is.
to precipitate, quay the issue here.
The issue is there, but the thing is, without those clauses being in operation, I cannot operate the policy. My policy is in a standstill. I want a final hearing in the matter.
Challenge the interim order.
My lords,
So want a final hearing in the matter?
my lords, insofar as other aspects are concerned, there are totally 10 applications of my learned friend's client, race power, 5 solar, 5 wind. All are, my lords, subject matter of matters which are coming up tomorrow. Where, my lords, insofar as wind, solar power, solar is
Where?
concerned.
Coming up where?
My lords, before
Issue
Justice
with regard
Devdas.
to GNA regulation, Mr. Kannur
That
is
is
appearing
before-
in that.
My lords, there we had made a submission.
Where we have been saying there is no such requirement for government order for getting the authorization. So that is the issue which is being considered by the learned
Lords,
single judge.
they-
That has nothing to do with this
My
matter.
lords, it is like this. Their main contention is government order is not required. But court said dehors that you process it. There we have said that 30% of 30% of processing fees, application fees, wherever they are paid, we are processing it. And that status I had stated, my lords, before the
Also, we
other
need to
bench.
pay that, fellows, despite there being a complete
My lords,
30%,
kindly,
100% we're paying.
my lords, tomorrow it is set down for final hearing because there was an order that we had taken up in writ appeal. Court had directed that the matter should be disposed of. Only race power has an issue here. Kindly note, my lords, other people don't have an issue. Race power
But they've
matter.
been given GOs. All
Tomorrow
the other
2:30
connected
matters are listed
petitions,
for
they've been
final
issued
hearing.
GOs.
My
That's
lords
why
may defer this matter. We want this matter to be finally heard, my lords. If my learned friend is wanting other additional interim orders, my lords, my respectful submission is we'll argue it finally. Let him argue the matter finally.
Just as I was drawing a parallel, if your lordship were to stay a levy, whether it's a tax or, I'm not bound to pay it as long as the lordship's order is in place. Either you challenge it or it gets vacated. I'm not bound to pay. Despite that, they are demanding, I'm paying to buy peace so that at least I'm able to do my business.
Now, what is the problem? They are not considering the application on the ground,
Correct,
not what
on the ground
application?
that there are some levies, my lord, which we have impugned on various grounds. There is no quid pro quo fee, all of that. Now, that is for final hearing. Your lord, in fact, the coordinate bench, my lord, initially had stayed the entire policy. Then only these clauses vis-a-vis these levies, it was restricted to those levies. Now, therefore, my lords, technically the state cannot levy even 1 rupee. Despite that, my lords, in order to carry on our business and to buy peace, we are paying 30% plus 100% of this fee. Despite that, my lords, they're not issuing these GOs.
Wherever they are paid 30%, 100%, we have processed matter. Even one application was sent to the SLAC, State Level Allotment Committee. That status, my lords, we had placed before the coordinate bench. Wherever he has paid, he has processed. He does not want to pay. In five cases, he has not paid.
We have stated that we are ready to pay. It's
No,
there in the writ petition.
My lords, out of 10 applications, he pays in 5. I have processed it. In respect of the other, my lords, without stating the correct facts, they are making these submissions before the court.
No, we've even given undertaking.
My lords, I will
balance
file,
about
my lords,
full indemnity will
my
give.
lords,
Full
I
indemnity.
will, my lords, we will file the status, my lords, of all his 10 projects. Kindly have it day after tomorrow. I'll file the status.
All right, we'll have it on Tuesday.
Please.
Your Lordship, before Your Lordship goes on to the next matter, I wanted to mention
Which next matter?
No, just within this matter itself, Your Lordship. I am appearing on behalf of one of the affected entities, which is Hexa Energy.
Petitioner or respondent?
Petitioner, Your Lordship. Petitioner, Your Lordship. And I had also filed a writ petition, which is writ petition number 18341. Now, Your Lordship, this matter had come up on the 30th, and there was a direction that it has to be listed along with this batch. Now that this batch is listed today, however, my writ petition has not come up.
That's all. That we'll see.
Please, my lords, Tuesday I will place on record
Please,
the
Your
status of his 10 applications.
There is already an order to tag the petition?
Yes, please, Your Lordship. On 30th of June, there is an order that to tag along with writ petition number 2290, which is listed today.
30th June idre, madam. 30th June order idre, tag that petition along with these.
Anything on my submission
Please,
on
Your
Tuesday will
will
remain the same. If there's a stay, there's a stay. Well, they have to get it set aside in a manner known to law. They can't pick and choose.
On Tuesday, we'll finish it the whole hog.
Please, my lords.
Interim order subsisting in all these cases stand
It's a
extended.
clarification that they should not use your lordships. One sentence, not to process. There's an observation. In fact, an observation says learned AG would submit that in WP 9757, there are directions issued to the state government not to precipitate. Therefore, no applications for solar projects are being processed.
Yeah, lords, the entire policy has come to a standstill because clauses are stayed. I am not the state, not only with respect to the petitioner, I'm not able to operate
What
the
is
entire
that?
policy.
I have not, I will clarify it. The order directing not to precipitate the matter will not come in the way of the state processing the applications submitted by the, what solar is the? What is
Solar.
that for?
Solar power developers.
For solar power projects, which will however remain subject to the result of the petition.
There is no, my lords, state and credit, Antaman.
State and renewable and credit, yes.
That is our stand. It is not that we are not processing.
ಅವ್ರು ಕೇಳಿದ್ದಷ್ಟೇ ಅಲ್ವಾ ಅವಾಗ್ಲೇ?
This observation, my lords, will not hurt us.
Then what's the problem?
Lords, I will come back on Tuesday. With
Well, that's all right, but
they're causing some mischief.
this is what Vikram sir asked.
That is not what is
No,
asked.
I'm reading from the order. I'm not making
No, if you are interpreting my order not to precipitate, so will not touch any application. That's
What
what,
is in the order?
that's
I
the
cannot
order.
reject this application ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. Not to precipitate ಅಂದ್ರೆ I cannot reject it, my lords. At the same time,
You have decided to reject it, so you can't.
ಹಾಗಲ್ಲ, if you have not paid the fees, I have to reject it.
Correct.
Not to precipitate this, I don't reject it.
All right.
Now whether I can
No,
process
these
it-
applications, you don't consider any applications not to precipitate ಅಂದ್ರೆ ಕಷ್ಟ.
ಇಲ್ಲ ಆ ಥರ ಇದೆ. That was not our intention. Please.
Just one thing, your lordship has said solar power projects. It may be renewable energy projects because wind and so I think.
Better word is renewable energy. Yes.
Yes, your lordship, because it shouldn't be
Renewable
interpreted to say only solar will be processed.
That's what. Yes.
projects and parks.
Project ಸಾಕು ನೀವು ಪಾರ್ಕ್ ಆರು ಮಾಡಿ.
Park ಬೇಡ ಸ್ವಾಮಿ. That is where they are coming at now. Park. Their contention is I don't need a GO. I don't need this policy for a park. Now they are coming and trying to
ಈಗ
take
ಸದ್ಯ
it.
ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಇರ್ಲಿ. Park will give rise to spark.
My lords, may I request that the matter may be listed at 2:30, my lords,
On Tuesday we'll see.
so that it can be finally decided.
Tuesday 2:30.
2:30 will make an attempt. Grateful.
Let's appear for the petitioner, my lords. For lack of jurisdiction, my lords. this
Matter is arising out of cyber defamation, my lord.
Cyber defamation.
my lords,
Ah,
out of
Section
an
19 is very clear on this.
Kodi. What's the matter, sir?
So they say that there's an alleged defamation, my lord. There's an alleged defamation, my lords, out of the email that I have sent it to them, my lords. My humble submission is, my lords, admittedly the cause of action and the cause of action arose in the Ramnagara district, my lords. However, they have filed a suit in Bangalore, my lords. My lords, if my lords kindly look at
Why Ramnagar cause of action?
my lords, because that was in the capacity
Email
of
was
this-
sent from there, is it?
Please, my lords,
Where did you send it to?
my lords, to the director, my lords. That was at the official capacity as the director of the company.
All right, where, who was the recipient of the mail?
My lords, recipient of the mail, my lords.
It is a copy to many people. It's copy to many people.
Recipient of the mail, sir.
My lords, recipient of the email is also one of the members, my lords, of the company itself. My lords, I'd like to clarify this, my lords.
So forget jurisdiction. Ramnagara, Bangalore, LL. Come on, merits.
My lords, in this matter, my lords, if my lords kindly look at the email communication, my lords, it's at page number 63, my lords.
The first time coming, is it?
Second time. my lords.
Sir, on the, you are here.
Yes, I am appear for first.
My lords, one of the members of the company resigned, my lords. Wherein I sent an email to them saying, my lords.
Now, who is the plaintiff?
My lords,
Plaintiff is one of the director having 30% stake in the company.
All right.
We are the
Now,
earlier co-founder.
this mail is communicated to all and sundry.
Yes.
my lords, I'd like to clarify on that, my lords. I had communicated only to one person. However, my lords, if my lords kindly look at page number 64.
ಅಷ್ಟೆಲ್ಲ ಯಾಕೆ? Where is your mail? CC ಯಾರ್ಯಾರು ಮಾಡಿದ್ರೆ ಹೇಳಿ.
63, my lords. Page number 63. In page 63, at 64 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ನಾನ್ ಕಳ್ಸಿರೋದು ಬರೀ ಒಬ್ರಿಗೆ. In fact, they have CC'd it.
One minute. 63 is your mail?
Please, my lords. My lords, 65 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಹಿಂದೆಯಿಂದ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
Resignation.
Please, my lords. There was a resignation by one of them.
It starts from 63 and ends at it starts at 66.
You start at 66, ends at 63.
Start ಆಗಿ 63 ನಲ್ಲಿ end ಆಗುತ್ತೆ.
Correct.
63
Now,
is the relevant
I
portion.
wish to resign. All right, that is the first.
ಒಬ್ರು ಡೈರೆಕ್ಟರ್ ನಾನು ರಿಸೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Next, now, after that.
ರಿಸೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಇವರು ಅದನ್ನ ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ 64 ಮೈಲಾಡ್.
ಆಮೇಲೆ
ಅದರಲ್ಲಿ ಅವರೊಂದು
1 minute, 21st January 2023, who has marked it to several people?
My lords, it's themselves who have marked that, my lords. CC ಮಾಡೇ ಕಳ್ಸಿರೋದು ನಮ್ಗೆ. To that email, we've replied, my lords. That's all.
CC ಮಾಡಿ ಕಳಿಸಿರೋದಕ್ಕೆ ಇಲ್ಲೇನ್ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಮೇಲೆ?
My lords,
The original mail is here. It began here at page 66. No CC.
Please, my lords, ಅದು ಒಬ್ರು one of the board members ಕಳ್ಸಿರೋದು ರಿಸೈನ್ ಮಾಡ್ತೀವಿ ಅಂತ.
ಹೌದು.
ಅದಕ್ಕೆ ನಾವು ಅವ್ರ ಒಬ್ರಿಗೇನೆ ರಿಪ್ಲೈ ಕಳ್ಸಿರೋದು ಸ್ವಾಮಿ.
ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ಬಿಡ್ತೀನಿ
Well, it's however kindly look-
63 ನಲ್ಲಿ ಒಬ್ರು ಡೈರೆಕ್ಟರ್ ರಿಸೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ. 64 ನಲ್ಲಿ ಇವರು ಡಿಫೆಂಡೆಂಟ್ ಏನಂದ್ರು, ಆಯ್ತು ನೀವು ರಿಸೈನ್ ಮಾಡಿ ಪರವಾಗಿಲ್ಲ, ಆದ್ರೆ ಇದರಲ್ಲಿ ಏನೋ ಒಂದು ಕ್ಲಾಸ್ ಇದೆ, ಅಂದ್ರೆ ನಾನ್ ಡಿಸ್ಕ್ಲೋಜರ್ ಕ್ಲಾಸ್ ಇದೆ ಇದರಲ್ಲೆಲ್ಲ, ಅದನ್ನ ನೀವೆಲ್ಲಾನು ಮೇಂಟೈನ್ ಮಾಡಿ ಅಂತ.
All right.
ನಾನು ಐ ಆಮ್ ದ co-founder, my husband and me the co-founder, first founder of this
All
company.
right, you-
ನಾವೇನ್ ಹೇಳಿದ್ವಿ ಅಂತಂದ್ರೆ, ನಾವ್ ಯಾವ ತರ ಈ ತರದ್ದೇನು ಮಾಡಿಲ್ಲ, ಆ ತರದ್ ಏನಾದ್ರು ಇದ್ರೆ ನಮ್ಗೆ ತಿಳಿಸಿ ಅಂತ ನಾವೊಂದು ಮೈಲ್ ಹಾಕಿದ್ವಿ. ಅದಕ್ಕೆ ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಯುವರ್ಸ್, ಇವರು ಆ ಮೈಲ್ಗೆ ಇವರು ಎಲ್ಲಾರು CC ಮಾಡ್ಬಿಡ್ತಾರೆ, including chartered accountant.
Kindly look at page number 64, my lords. That was CC
Now
by
come
them.
to 63, sir.
My lords, I've just replied to.
And he had an option to delete them. ಅವ್ರು ಮಾಡೋದಿಲ್ಲ.
Now come to 63. What is this 406, 420 and all that?
ನೋಡಿ ಸ್ವಾಮಿ.
ನೋಡಿ ಸ್ವಾಮಿ.
My lords, in this, my lords, I've just replied to whatever email they sent
Not
me at
reply,
64,
sir.
my lords.
Reply itself is defamatory and you have marked it to everyone.
My lords, they had already marked in the email, my lords, to which I've just replied, my lords.
No, there are extra CCs here.
My lords, may kindly.
All
look at
right,
page of
now
64.
when you are saying all this, please note, irrespective of existence of any written agreement, any act not in the interest of the company shall may so and so will definitely attract prosecution under 406, 420 leading to arrests, imprisonments both in civil suits.
ಇನ್ನು ಮುಂದೆ ಸ್ವಾಮಿ ಆ ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಚೆನ್ನಾಗಿದೆ.
ಚೆನ್ನಾಗಿದ್ಯಾ?
The statement of your impinges on the
The
basic
statement
duties
impinges on
of
the basic duties and
responsibility.
responsibilities directed to contention, illegal, misconceived, irresponsible, mischievous, immoral. What is immoral, sir? Company's interest and not safe. At this juncture, it's better you resign as director from the board.
My lords, because my lords, if my lords kindly look at the email they've sent it, my lords. They've sent if we know it,
ಈಗ
we will share.
ಇಲ್ಲಿಗೆ ಬಂದಿರೋದು ಯಾಕೆ ಹೇಳಿ?
My lords, because of lack of territorial jurisdiction, my lords.
Territorial, no, don't worry about territory.
Kindly look at the plaint, my lords.
Email ಅಲ್ಲಿ recipient, you have marked it to so many. One of them is not in Bangalore?
Course of the business, my lords,
He
carried out in.
he himself is in Bangalore.
My lords, kindly look at the cause of action.
You're on that jurisdiction.
Please, my lords.
Anything
My
else?
order 7 rule 10 was rejected, my lords. Challenging that,
Correct ಆಗಿದೆ. Anything else?
no, my lords.
ಅಷ್ಟೇ. You are a company based in Bangalore?
Ramnagar, my lords.
He himself is in Bangalore ಅಂದ್ರೆ ಈಗ?
ಅವ್ರ ಡಿನ್ ಅಲ್ಲಿ ಅವರ ಬ್ಯಾಂಗ್ಳೂರ್ ಅಡ್ರೆಸ್ ಹಾಕಿಟ್ಟಿದ್ದಾರೆ ಅಂತ.
Let's kindly look at the plaint for a moment, my lords. Page number 22, my lords. There, the
No, somebody is in Bangalore and email recipient, anybody.
My lords, no, none of them are made parties in the suit, my lords. It's filed only against the petitioner herein, my lords.
You have communicated to all and sundry, yes. And what is that language there?
ಐ ಆಮ್ 75 years old lady.
ಅದಕ್ಕೆ ಈ ತರ ಮಾಡಬಾರ್ದು ಅಂತ.
ಹಂಗಲ್ಲ, ಅದರಲ್ಲೂ ಕೂಡ cannot use such words.
25 years old ಆದ್ರೆ ಯೂಸ್ ಮಾಡ್ಬೋದಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಆ ತರ
ಮತ್ತೆ?
ಅಲ್ಲ. ನಾನೇನ್ ಹೇಳ್ತಿರೋದು
ಯಾವುದು ಯೂಸ್ ಮಾಡಂಗಿಲ್ಲ ಅಷ್ಟೇ. ಎಸ್, ಡಿಸ್ಮಿಸ್ಡ್. Cyber defamation.
Email coverage.
Oh, email defamation. Yes. Yes, next.
18.
Well, it's covered by judgment.
Respondent BWSSP.
ಇದು defamation.
No, my lord. GM BWSSP, my lord.
BWSSP.
Matter pertains pro rata.
Well, it's in the.
Pro rata ಅದಲ್ವಾ? Same order ಕೊಡಿ.
Well, ಇದು writ appeal ಅಲ್ಲಿ 50% pro rata ಇದಾಗಿದೆ.
Same ಅದು ಆರ್ಡರ್ ಏನಿದೆ writ appeal ಆರ್ಡರ್. ಪ್ರದೀಪ್, ಯಾವ ಆರ್ಡರ್ ನೋಡಿ ಅದು ಇದರಲ್ಲಿ? Which order?
My lords, it's at page number 15, my lords. Writ appeal 1575, my lord.
Madam, identical cases. BWSSB ಅಂತ ಕೇಳಿ ಹೇಳ್ತಾರೆ. BWSSB ಅಂತ ಕೇಳಿ ಹೇಳ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ you should make both the orders a part of this order. This flag ಹಾಕಿರೋದು ಎರಡು ಆರ್ಡರ್ ಇದೆ. Yes, disposed.
Grateful, brothers.
Prayer, the petitioner is before this court seeking the following prayer. In identical circumstances, this court passed the following order. First flag. The learned counsel for the petitioner submits the division bench has modified the order by the following order. Second flag. In the light of the order covering the issue that is projected before this court as modified by the division bench, the petition deserves to succeed in terms of the order passed by the division bench. Yes.
Grateful.
Next.
19.
I appear for the petitioner in this matter.
Notice and file objections, my lords.
Lord, in this, the petitioner, my lord, is the director of the accused 6 company. This is, the petitioner, my lord, is calling into question the application of rejectment, where they've rejected the defreezing of my account.
482.
Please, my lord.
As against rejection of the application filed seeking for defreezing the account, the present petition is filed.
Now, what's the prayer?
To
This is
set
called,
aside that order
set
itself.
aside that order, my lord.
Freezing order.
Rejection of application. As against rejection of the application.
Your lordships, my lord, have taken a view with respect to accused number 9 company.
There, my lords,
Phone pay,
No, Go Rupee company. But my lord, when the complaint was registered in the year 2022, I've resigned from that company, my lord, 2 years ago. And subsequently, 2 years later, it was filed, the complaint. And
this
registration of
particular
FIR.
case, my lords, the petitioners had resigned.
No,
Even
launch
I
of the
resigned.
app happens when?
My lords,
In this company, there's no launching of the app, etc.
then?
But it's the same crime number, my lord, and with respect to the freezing of the account. itself. And in this petition, where your lordships have taken a view, it's with regard to the accused number 9 company. And I'm allowed
Yes,
the accused
Rashek.
number 6.
That is insofar as the case where my lords petitioners had resigned from the company.
I've also
Here is a
resigned 2
case
years
where
ago.
my lords is a director and he claims that my lords is a manager.
He is also resigned.
I've also resigned
That's
2
what
years
they
ago.
say, my lords.
I'm the director only for 14 days, even according to their own
That
complaint.
is what they say.
Not same, my lord. It's there in the complaint. Your lordship.
Where is the complaint?
Complaint is at page 22.
Charge sheet ಆಗಿದೆಯಾ?
No, my lord. Page 28, my lord, is the relevant portion where they're talking about the accused number 6 company.
Which is your company, madam?
Go Rupi Infotech Services Private Limited.
All right.
See, in that table, my lord, Karthik Jain, 24/9/2018 is when I took over as the director.
And resigned on 8/10/2018.
Yes, only for 14 days. And now the present complaint is filed in the year 2022.
ಇದು ಯಾರು the complaint ಇದು?
Yes.
Part of, what is this? Part of the complaint?
Part of the complaint, my lord.
Yes, sir.
Yes.
28.
It is your case that it is 14 days.
But my
Yes. And your account is frozen now?
32 lakhs ಇದೆ.
The petitioner is before this court seeking the following prayer. Heard the learned counsel appearing for the petitioner Kirti Reddy and the counsel is Rajshekar representing, ನೀವು ಯಾರಿಗೆ Rajshekar? Complainant.
Respondent number 2 complaint.
Second respondent complainant and the learned HCGP. The learned counsel for the petitioner places reliance upon the judgment rendered by this court in criminal petition 5354 of 2024 disposed on 24th July 2024 in quashing,
Yes.
Proceedings.
allowing the petition and quashing the proceedings qua the accused number 9 in the same crime. The petitioner files an application before the concerned, the account of the petitioner comes to be frozen after the registration of the crime. Again, a registration of the crime in crime number 6 of 2022 for several offenses. The registration of the crime leads the investigating officer to communicate freezing of the account of the petitioner as well. Therefore, the account of the petitioner stands frozen. The petitioner then files an application before the concerned court invoking under section 451 and 457 of the CRPC seeking defreezement of the account. The said application comes to be rejected, rejection of which has driven the petitioner to this court in the subject petition. The learned counsel.
Really, complaint, commission of the offense. Kindly see page 17 for a moment. Commission of.
17.
Yes, please. From 2010 till 2022.
ಆಯ್ತು ಇವ್ರು 15 ದಿನ ತಾನೇ ಇದ್ದಿದ್ದು ಮತ್ತೆ
ಅಷ್ಟರಲ್ಲೇ ದುಡ್ಡು ಮಾಡಿದ್ರು.
ಬೇರೆಯವರೆಲ್ಲ 1 ವರ್ಷ 10 ವರ್ಷ ಎಲ್ಲ ಇದ್ದಾರೆ ಅದು ಬಿಟ್ಬಿಟ್ಟು. ಎಸ್ ಈ learned counsel, sorry, ಎಲ್ಲಿದ್ದೇನೆ?
Calling into question.
So learned counsel for the petitioner takes this court through the documents appended to the petition with particular reference to the complaint to demonstrate that the petitioner was a director for only 15 days from 24/9/2018 and to 8/10/2018. He went in as a director and resigned, and therefore no allegation can be made against the petitioner as there are several other directors against whom the allegation is made. Their entry and cessation is for a long period, unlike that of the petitioners, which is only for 2 weeks. The learned counsel for the respondent complainant would seek to justify the action, contending that in 15 days itself, the petitioner has amassed wealth, and therefore the order, the freezing of the account should not be diluted, as the petitioner will walk away with the funds that are there in the account. The learned HCGP would also toe the lines of the learned counsel appearing for the respondent. The afore narrated facts are not in dispute. The issue now lies in a narrow compass. What has driven the petitioner to this court is the is the order of the concerned court which declines to accept the application of the petitioner seeking defreezement of the account under section 451 and 457 of the CRPC. The afore narrated facts are not in dispute. The crime is registered against several persons, which becomes a crime in crime number. What's the crime number? 6 of 2022. The petitioner, you are not an accused.
No.
The petitioner is not named an accused in the said crime. The money trail leads to the account of the petitioner. The trail leading to the account of the petitioner is on the score that the petitioner was a director of the particular group for a particular period of time. The complaint, insofar as the present petitioner is concerned, is as follows, page 28. A perusal at the aforequoted chart would indicate that the petitioner entered the firm as a director on 24/9/2018 and ceased to be a director on 8/10/2018. Therefore, he was a director for 14 days. Except the petitioner being a director, there is no other money trail that led to the account or acts of the petitioner. The petitioner's account is frozen without any rhyme or reason, with there being no allegations against him. It is not allegation against him. If the petitioner had a let me not observe anything. Innೊಂದು crime register ಮಾಡ್ತಾರೆ. So in that light, the petition deserves to succeed, and the account of the petitioner is to be directed to be defrozen forthwith. For the
Obliged.
Quoting settlement number 20.
ಏನ್ ಮೇಡಮ್ ಎರಡು
For the petitioner.
offense
498. Point number 2,
complainant.
the parties are present.
All parties are present.
Yes, my lord.
Complainant is present.
Yes. More idare. Point number 2.
The petitioner ಎರಡು ಕೇಸ್ ಏನದು?
My lord, one is mother-in-law, one is husband.
ಯಾವ್ದು ಮಿಲ್ ಮದರ್ ಇಲ್ಲ ಯಾವ್ದು?
1671 is husband, my lord.
ಇದು ಮದರ್ ಇನ್ ಲಾನಾ?
And criminal petition 2103 is the husband.
Both these petitions both these petitions arise out of a solitary crime registered pending as CC 79 of 2023. The first petition, criminal petition 2103 of 24, is by the mother-in-law, and the second by the husband. During the subsistence of the proceedings, the parties to the list, family court alagide alli?
Family court, my lord.
The parties to the list were before the concerned family court in MC
4722 of 2024.
4722.
Of 2024.
4722 of
Page 4, page
2024.
number 5, my lord.
Before the concerned court, the parties to the list have settled the dispute amongst themselves. One of the clauses of the settlement of dispute is closure of the cooperation for closure of the present proceedings. Accordingly, the petitioners have filed a joint affidavit or filed an application under section 359 read with 528 of the CRPC and a joint affidavit to that effect. The affidavit reads as follows. In the light of the offense being the ones punishable under section 498 or 323 of the IPC and not being against the state, I deem it appropriate to accept the application seeking compounding of the offense and close the proceedings against the petitioners for the aforesaid reasons disposed, quashed.
Much obliged.
Yes.
ಸ್ವಲ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಟರೆ ಸೈನ್ ಹಾಕ್ಸ್ಬಿಡ್ತಿದ್ದೆ ಪಾರ್ಟಿ.
ಅದು ಮಾಡ್ಲೇಬೇಕು.
ಪ್ಲೀಸ್
ಕೊಡ್ತಾರೆ.
ಯಾಕಂದ್ರೆ ಇದೆಯೇ
ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ವಾ, ಅದರಿಂದ ತಮಗೆ
ಯಾವ ಕೇಸ್ ಆದ್ರೂ ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. ಮೇಡಮ್ ಅದು 2004.
Admission 2:30 PM. Password matters. List one, seal number 8.
I appear for responding to your motion.
1 minute.
One of the conditions they were saying it is covered by judgment. It is not covered by judgment. Acquisition is complete, your lordship. Also, a layout is formed. There is a road.
List on 19th.
Not
Is that
on
19th?
Not on 19th, lords.
Actually, a
Much
covered
earlier.
matter.
Covered alla anta idare ಅವರು.
It is covered.
It is
It
not
has to be
covered.
heard, yes.
My lord, 80%, 85% of all.
85% covered.
Allah, it's already been quashed, my lord. So there's nothing, there's no layout. Even, my lord.
You covered iದ್ರೆ covered ಅಂತ ಹೇಳಿ ಪ್ರಾಬ್ಲಮ್ ಏನು?
Cover ಇಲ್ಲ, sir.
BDL ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾರಾ?
ಅಲ್ಲ. See, they are saying that it is based on a Bandu Ramsamy judgment that is, it is a island. It is not a island, your lordship. I have produced
List on 12th.
Not on that aspect. My lord is seen in the order sheet also.
Now no time. 12th, yes.
Much obliged.
May I request 13th, my lord?
Why?
I will not be here on 12th.
She is there, leave it. Yes.
13th.
Much obliged.
You will give up. She won't give up. Yes.
Please, publish.
23.
ಇದು ಬೆಳಿಗ್ಗೆ VC ಕೇಳಿಸೋದೇ ಇಲ್ಲ.
Sorry, my lords.
ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡೋ ಟೈಮಲ್ಲಿ ಕೇಳಿಸ್ದೇ ಹೋದ್ರೆ ತಪ್ಪಾಗ್ತದೆ ಅಂದ್ರೆ.
Lords, on just about 4 dates I will give me, lords, and then I will take your lordships to the lords on 28 to 2020.
ಹೊಳ್ಳ ಎಲ್ಲಿದ್ದಾರೆ?
ಅವರು ಇದ್ದಾರೆ, ಅವರು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಅವರೇನಾ?
No, I am not Padmanabh Holla. I am appearing.
Filed the statement of objections.
You filed a statement.
ಇದು ಹಿಯರ್ ಮಾಡಿದ್ನಲ್ಲ ಸುಧಾಕರ್ ಪೈತಾನೆ.
Yes. Lords, the issue is very simple, my lords. The certain extents in my own property was referred to as a B kharab.
Interim order ಕೇಳಿದೀರಾ?
Lords, there is no interim prayer, my lords, but what has happened is the acquisition is of the year 2020. We are in 2025.
Compensation ಕೊಟ್ಟಿಲ್ಲ.
Compensation is paid only in respect of some small portion of the property. The larger portion of the property, we gave a representation saying that even prior to the acquisition, there is a direction to conduct the PODI because there was a wrong entry. Now, this is an order passed on 28 to 2020 by the competent authority. Then, after this order is passed, we give a representation to the project director. Project director in turn directs this special land acquisition officer saying that you please look into this issue because they are saying that the actual extent of the land which has been acquired is fact, but the extent for which the compensation which is claimed by them is a larger extent than the compensation which has been disbursed by them. Special land acquisition officer takes a decision saying that the order that is passed by the deputy commissioner or the technical assistant to the deputy commissioner was behind our back. So therefore, I will myself get the survey conducted. And he directs the surveyor to conduct a survey. Now the surveyor submits a report on 25/1/2022. Now at page 41, if your lords were to see me, lords, this is where it probably concludes what should be the scope of this litigation. Page 41, annexure J. ನೋಡ್ಸ್ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 75ರ ಅಡ್ಡಹೊಳೆ ಬಂಟ್ವಾಳ ಗ್ರಾಮದ ಸೋಂಡ್ಸೋ ವಿಭಾಗದಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಕೇಂದ್ರ ಸರ್ಕಾರವು ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 1920ರಂತೆ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದೆ. ಅದರ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಒಳಗೊಂಡಿದ್ದ ಮಾಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 128 B2 ಸೋಂಡ್ಸೋರಲ್ಲಿ 324 ಚದುರ ಮೀಟರ್ ಖುಷ್ಕಿ ಜಮೀನು ಮತ್ತು ಕಟ್ಟಡಗಳಿಗೆ ಈಗಾಗಲೇ ಅವಾರ್ಡ್ ಆಗಿದ್ದು, ಅವಾರ್ಡಿನಂತೆ ಸೋಂಡ್ಸೋಗಳನ್ನು ಕಚೇರಿಯಿಂದ RTGS ಮೂಲಕ ಪಾವತಿಸಲಾಗಿರುತ್ತದೆ. ಮಾಣಿ ಗ್ರಾಮದಲ್ಲಿ ನಿಮಗೆ ಸೇರಿದ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ ಸೋಂಡ್ಸೋ ರಲ್ಲಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ ನಂತರ ಇತ್ತೀಚೆಗೆ ದುರಸ್ತಿಯಾಗಿದ್ದು, ಅದರಂತೆ ನಿಮಗೆ ಪರಿಹಾರ ನೀಡಬೇಕೆಂದು ಅಧಿಕ ವಿಸ್ತೀರ್ಣದ ಜಮೀನು ಭೂಸ್ವಾಧೀನವಾಗಿರುವುದು ತಿಳಿಸಿ ನೀವು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ನಮ್ಮ ಕಚೇರಿ ಸರ್ವೆಯವರವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. Now that is referred to at serial number 1, reference number 1. Then ಅವರ ವರದಿಯಂತೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ಮಾಣಿ ಗ್ರಾಮದ ನಿಮ್ಮ ಜಮೀನದ ಸರ್ವೆ ನಂಬರ್ ಸೋಂಡ್ಸೋ ಅಂದಾಜು 384 ಚದುರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಖುಷ್ಕಿ ಜಮೀನು ಬಾಬ್ತು ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡು ಶೀಘ್ರವಾಗಿ ಅವಾರ್ಡ್ ಅಥವಾ ಒಪ್ಪಿಗೆ ಅವಾರ್ಡ್ ಮಾಡಿ ಪರಿಹಾರ ಆಗುವುದು. ಆದ್ದರಿಂದ ನೀವು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಕಾಮಗಾರಿ ಯಾವುದೇ ಅಡಚಣೆ ಮಾಡದೆ ಜಮೀನಲ್ಲಿ ಕಾಮಗಾರಿ ಮಾಡಲು ಅನುಕೂಲ ಮಾಡಿಕೊಡುವಂತೆ
ಏನ್ ಕೊಡ್ಲಿಲ್ಲ.
ಇಷ್ಟು ಮಾಡ್ಬಿಟ್ಟು ಇದಾದ್ಮೇಲೆ ಇನ್ನೂ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೆಸಿದ್ರು. ಆಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಲ್ಸೋ ವಾಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಟು ಸೆಂಡ್ ಆಲ್ ದ ರೆಕಾರ್ಡ್ಸ್. ವಾಟ್ ಇಸ್ ದ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ಬೀನ್ ಯುಟಿಲೈಸ್ಡ್. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಲ್ಸೋ ಸೆಂಡ್ ದ ರೆಕಾರ್ಡ್ಸ್. After these records are sent, what they are now saying is, as per the endorsement, the change of entries takes place after the acquisition notification of 1/9/2020. We will not pay you the compensation. Lords, one judgment, my lords, one recent judgment of the Delhi High Court said, this kind of frivolous defenses, when it is raised by the government, keeping the rights of the parties in jeopardy, more particularly the constitutional rights of the nature, where right of to enjoyment of the property, my lords, is now an essential concomitant of Article 21, notwithstanding 300 capital A. It says that these are the kind of cases where officers will have to be held personally responsible because they are taking.
We want to hold
Please,
that
my lords,
only. Yes, yes.
I will just pass it on, my lords. It's
Yes,
a division
Kodi,
bench
Kodi.
judgment of the Delhi High Court, which took note of the fact that the central government has framed a scheme as to this management. But still it said the officers are in a habit.
Should be held responsible, no doubt about it.
Lords, I'll just leave
It's
that.
high time we do that.
Yes. Lords, it takes note of all because the government advocate was called upon to say how you are preventing these officers from making false statements or conducting frivolous litigations before the courts. Because the fairness with which the rule of law has to prevail is from the state. It is commencing from them. Aberrations only should come before the court. They should not create aberrations before the court.
Except aberrations, nothing comes before the court. That's the whole problem.
That's the reason, my lords.
Kodi,
Now,
judgment Kodi.
Please.
Anything, sir?
Lord, senior is appearing through VC.
Senior.
My senior.
Milord, I'm so sorry.
Yura.
Please.
Nim senior.
Please.
Padmanabh Holdavara.
Allah.
He is Mr. Vidhan Chandra. Padmanabh Holla is also senior.
Yes, sir.
I'm sorry, Milord, my connection is a little, I have a problem with my Wi-Fi.
You want to come to the court?
Yes, Milord, I'll come to the court, Milord, any day.
When?
Next Tuesday, Milord.
Tuesday. Next Tuesday in preliminary hearing.
Yes.
Please.
Judgment Kodi.
Please, I will leave it, my lords. I have taken the printouts. I think.
29.
Judgment court.
12th. We'll take it on 12th. Yes. Government ಇದೆಯಲ್ಲ madam. ಎರಡು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ನೋಡಿ. ಕರಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
Number 2. Till number 6.
Six. 6, yes. Yes, sir.
Yesterday I get handed over.
Handed over.
Synopsis.
ಹೌದಾ? ಇದೆ. Yes.
Please. Dates will be little relevant, my lord.
Yes.
But the case of the prosecution, my lord, is that on 19th February 2024, an account was opened in Union Bank of India, MG Road, in the name of Karnataka Maharshi Valmiki Parishad Scheduled Tribes Development Corporation, which I will refer to as Nigama. There is a 330, will your lordship take up the 330 matter later, Lord?
Which one?
There is a 330, the National Commission for Backward.
I'll just finish this and take.
430.
430. Yes. IST.
Then, my lord,
Yes.
on 4th March 2024, 25 crores gets deposited into that account. 6th March, 25 crores gets deposited. 21 March, 44 crores get deposited. Then 22nd March, 33 crores get deposited, and 21/5, 50 crores get deposited. And totally 187.33 crores is transferred into the said account of the Nigama by way of these above 5 transactions.
Yes.
Now, between 5/3/2024 to 6/5/2024, by way of 18 transfers made to various accounts
Yes.
held by business entities, a sum of 94.73 crores
Yes.
was transferred. However, the actual amount is 84.63 crores.
Yes.
From these accounts, monies were dispersed to hundreds of different accounts. Then, my lord, this is important date, my lord.
Yes.
23/5/2024, the CEO of the Nigama questioned the Union Bank of India about the transfers. Immediately, 5 crores was restored in this said account, my lord, on 23/5. my lord. Then on 28/5/2024, complaint was filed in the High Grounds Police Station by General Manager of the Nigama, making allegation against the employees of the Union Bank of India, MG Road. The 28/5/2024 FIR number 118 of 2024 of the High Grounds PS was registered against 6 officials of the Union Bank of India. I am not named here, my lord, as an accused. Then 31.5, one Padmanabha JG, MD of Nigama, who was not named in the FIR, is arrested. Now, my lord, he is arraigned as accused number 5 in the charge sheet. Then Parashuram Durganavar, senior accountant, who was not named in the FIR, is arrested on 31.5, my lord. Thereafter, 3/6/2024, one Satyanarayana Itkari, who was not named in the FIR, is arrested. And now he is arraigned as A3, my lord. 5/6/2024, E. Nageshwara Rao, who was not named in the FIR, is arrested. A11 in the charge sheet. Nekkanti Nagaraj, who was not named in the FIR, is arrested. A12. 11/6 is important. My lord. Police officials from Karnataka CID approached the house of the petitioner herein at around 11:30 p.m. at Hyderabad and took him into custody, my lord.
Yes.
12/6/2024, petitioner was produced before the court of 13th AMM, Hyderabad, for issuance of transit warrant. The magistrate refused to grant transit warrant since the petitioner is not named in the FIR. Then 12/6/2024, one Chandramohan was arrested, my lord. 13/6/2024, even without transit warrant, petitioner was illegally kept in custody beyond 24 hours and is produced before the 3rd ACMM, Bangalore, and is given into custody. Lord, their arrest, my lord, is that, my lord, on 27/11/2024, my lord, or rather 5/8/2024, charge sheet is filed in this case, my lord, against where I'm for the first time I'm named as accused number 1, my lord.
In the charge sheet.
In the charge sheet.
No problem.
No problem.
Yes.
Lord, on 27/11/2024, my lord, I had applied for regular bail, which was rejected by the sessions judge. Then, Lord, 18/3/2025, my lord, I had applied for bail before this honorable court, which was withdrawn with liberty to fresh afresh.
Liberty.
Liberty to file afresh.
Bail matter.
Bail matter.
So bail is rejected.
Bail is rejected. Bail is rejected by the sessions court. My application before the court, my lord, is withdrawn, my lord. Then, my lord, 12/6/2025, petitioner filed writ petition to challenge his arrest without providing grounds of arrest and without transit warrant. This honorable court dismissed the petition on the ground that no documents were produced.
Page 200.
Yes. Now, that we, my lord, on the before the previous court, my lord, in the quorum, my lord, we had argued about res judicata and other things, but I will have to reiterate all those things. Now, my lord, after dismissal of the first petition, my lord, the second petition is now filed, my lord, for your lordship. Now, my lord, your lordships may see, my lord. The complaint is dated 28/5. I am arrested on 11/6, my lord. That is within 15 days. So one of the questions which was asked, my lord, before to the, my lord, prosecution was, what was the material that you had to indicate that he is involved in the crime? Nothing was told to this honorable court.
Charge sheet hakilwa.
Charge sheet hakidare. I can read the charge sheet
material.
also.
What else?
No, I can show the charge sheet, my lord. Please. Only omnibus, my lord.
You are accused number 1.
I am shown as accused number 1, my lord.
And against you only omnibus.
Only omnibus. That I was, my lord, the mastermind. Except that, my lord.
Mastermind.
Mastermind. Page? No,
Page.
Just give me 170. At 177, may I show, my lord, what was the first complaint, my lord, before the thing?
Complaint ನಿಮ್ಮ ಹೆಸರೇ ಇರಲಿಲ್ವಲ್ಲ?
ನನ್ನ ಹೆಸರಿಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ?
Then
For the first time you spring in the charge sheet.
I am, yes, my lord.
Yes.
Now, my lord, at page 178, my lord. ಆರೋಪಿ ಒಂದು ಸತ್ಯನಾರಾಯಣ ವರ್ಮ ಸೋ ಅಂಡ್ ಸೋ ಲಕ್ಷ್ಮಣ್, ಈತನು ಮೂಲತಃ ತೆಲಂಗಾಣ ರಾಜ್ಯದ ಹೈದರಾಬಾದ್ನವನಾಗಿದ್ದು, ಈತನು ಬೆಂಗಳೂರು ದಿನಾಂಕ 12/10/23, 15/10/23, 16/10/23 ಮತ್ತು 18/10/23 ವರೆಗೆ ಭೇಟಿ ನೀಡಿ ಮಾನ್ಯತಾ ಟೆಕ್ ಪಾರ್ಕ್ ಸಮೀಪ ಹೋಟೆಲ್ ರಾಯಲ್ ಎನ್ನುವ ಸೋ ಅಂಡ್ ಸೋ ಹೋಟೆಲ್ ನಲ್ಲಿ ಉಳಿದುಕೊಂಡು ನಂತರ ದಿನದಲ್ಲಿ ಮೊದಲನೇ ಪರಿಚಯವಿದ್ದ ಆಂಧ್ರಪ್ರದೇಶದ ಗುಂಟೂರು ನಗರದ ಆರೋಪಿ 2 ಕಾಕೇಶ್
ಚಾರ್ಜ್ ಶೀಟ್ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಚಾರ್ಜ್ ಶೀಟ್.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್.
No, what I want to show, my lord, is the illegal arrest and, my lord, the way in which I was illegally arrested.
Concentrate on that.
Yes.
Because charge sheet omnibus andre, it runs into 7 pages ashte.
No, 7
Only
pages.
against you.
No, no.
12 pages.
No, no,
12
they
pages.
only repeat the 18 transactions. Lord, and Lord, what has happened along with this is that, Lord, the bank filed a complaint with the CBI, Lord. Now, in that, Lord, they named, Lord, the bank officials, Lord, as the, Lord, as the accused persons. That, Lord, has been now, Lord, has been, Lord, your Lordship has passed an order where, Lord, your Lordship have asked this, the investigation conducted in this case to be, Lord, handed over to CBI. Lord. The report. The report.
Not the investigation.
No, not the investigation.
Hmm.
Lord, your Lordship will please come to, Lord, page 66. Page 66. On questioning accused number 13. Lord, at that point of time, accused number 13 was named as Satyanarayan Verma, who is now accused number 1, Lord. At page 66.
A13 in the complaint.
No,
Then?
he was not there in the complaint.
Then A13 ಯಾವ್ದ್ರಲ್ಲಿ?
ಅವ್ರು ಹೇಳ್ಬೇಕು.
Remand ಅಲ್ಲಿ.
Remand.
See,
if your Lordship sees
there are
page
2 or 3 circumstances where the accused can spring. First, in the first information report, he will be named as an accused. He is not an accused in the first information report, he can spring in the remand order.
Remand.
Next circumstance. ಎರಡರಲ್ಲೂ ಇಲ್ಲ. He can always spring in the charge sheet after investigation. So because his name was not there in the complaint, he cannot come in the remand. Because his name is not there in the remand, he can't come in the charge sheet.
No, I'm not going so technical.
That is, yes.
Page 66, Milord, only to point out, Milord, that accused number 3 is the accused number 1 at the first line. Then on questioning accused number
that is in the remand order.
Yes, Milord.
Yes, sir.
Then page 67, second paragraph, Milord, regarding the accused number 3 is concerned. He submitted that after arrest of accused number 13 conducted the search and seizure, some of the articles approached the Honorable Metropolitan Magistrate Court, so and so Rajendra Nagar, Hyderabad, for issuance of transit warrant. But Honorable Court refused to issue transit warrant at 5:30 p.m. on 12/6/2024.
One minute, sir. Where is that order?
That order they have, Milord, they have.
You don't have?
No, I don't have, but they had produced it before the court. It is probably in this court file, Milord.
Which court is that?
Milord, 13th Additional Metropolitan Magistrate, Upparapalla, Rajendra Nagar, Hyderabad.
It is refused, is it?
It is not refused, madam.
Then?
Returned and it is refused only.
Why was it returned?
Because he was not named in the FIR.
Oh, that is why it was refused,
Yes.
is it?
No other material was there. They had not placed any material before, Milord, the court.
Yes, sir. Where is that order? Sorry. You can continue.
Yes, Milord. Next line is, Milord, hence there is a delay to produce the accused number 13 before the court, same is accepted. This in my submission.
So belated production is accepted by the court
Accepted by the
at
court
Bangalore.
At Bangalore. So, Milord, it is
That
an
is in
admitted
violation
fact.
of law.
That's the question of.
Yes.
Two things, Milord. One, there was no grounds of arrest ever given till today. It is not.
Grounds of arrest ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಡಿ.
Lord, another document was also handed over, the memo of arrest, which was supposedly handed over to my wife, Milord. That also does not have anything.
Arrest memo ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರಂತೆ to my
Arrest-
wife.
arrest
That also
in-
does not have anything.
Arrest intimation letter ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
ಹಾ.
ಆಮೇಲೆ. Now you are in custody?
I am in custody since 1 year, Milord.
1 year?
1 year. And there is absolutely no chance, Milord, of trial at this stage. 197 witnesses. Milord, are named. I have gone through each one statement, Milord. Milord, except a driver who says that he saw me near Kanishka Hotel, Milord, there is nothing. One stenographer, one driver.
What was their position?
Lord, I was a railway thing, Lord. I'm not involved in any of this bank.
Are you a government employee?
No, my
Who
lord,
are
I'm not.
you?
I'm not a government
Who
employee.
are you?
Lord, I'm a railway contractor.
Railway.
That is what it says, my lord. The
Railway
charge sheet says-
contractor.
Charge sheet says I'm a railway contractor. Please see.
Hmm.
At page 122, my lord. Occupation is shown as railway contract kelsa.
What is the amount received into your account?
According to the documents, my lord, nothing.
According to the charge sheet?
According to the charge sheet, my lord, they say that they have recovered 8 crores from my house.
From?
My house.
Your house?
Yes. In Andhra Pradesh. In
Correct.
sorry,
I thought-
in yes, Hyderabad.
When was
Telangana.
the search conducted in your house?
On 12/6/2024 at 11:30 p.m.
The day you were arrested?
The day I was arrested. They land at 11:30 p.m.
11:30 p.m.
Yes, at
But
Hyderabad.
Fact is 8 crores is recovered.
Lord, that I am disputing, obviously.
Huh?
I am disputing that.
Mazar draw madilva.
Illa, there is no Mazar. I have gone through this. They are saying the Mazar witnesses again are some head constable from the Bangalore police.
Yes, we'll see. Yes, 8 crores recovered, and where is it? 50 kilos of gold. 1.5. 15 kilos of gold.
And Lamborghini vehicle which was purchased by paying an amount to
ಅದೇನ್ ತಗೋಬಾರ್ದು ಅಂತೇನಿಲ್ಲ.
Allah, that's correct.
ಇದೇ ದುಡ್ಡಲ್ಲಿ correct.
Allah, for 15 days, what is that material that they have? Within 15 days, my lord, they have come and seize these material, my lord. Now, my lord, the pertinent question was put to them, my lord. Show me what was the material when you landed at his house on 12th, my lord. Nothing.
Allah, show me what was the material when you landed in the house.
Yes.
Recovered 8 crores.
No, Lord, I was not named in the FIR. I am
all
not.
right, sir.
No, even if there is at least
There
a
is
statement of
no
a co-accused.
necessity. There is no necessity to.
No, at least the statement of a co-accused should be there, my lord. Otherwise, who am I? I'm in Hyderabad.
But you're not named in the remand order.
No, that is only afterwards. No, that is on 13th. That's on 13th. On 11th.
That is next day.
No, 2 days later.
Yes, sir. Amala.
Yes, my lord. No, my lord, I just want to point out, my lord, some law on this point.
What are your grounds? Grounds of arrest is one ground.
Lord, there was no Lord transit warrant. Therefore, I could not have been held beyond 24 hours. And if I have been held under 24 hours, and even if there is a subsequent order remanding me to judicial custody, Lord, that would be odious. That is my point. And for that, my lord,
No transit warrant. Then no grounds of arrest.
No grounds of arrest.
Amala.
That's
Charge
two
sheet vague. This is the first time you're calling in question the charge sheet, or earlier petition
No,
hakidra?
the charge sheet was not called.
First time charge sheet.
And my lord, obviously, my lord, that there is going to be delay in trial now that the CBI is investigating others, my lord. Your lordship knows about it. There are other people who are bigger people who are involved, and money is actually recovered from them. Lord, kindly have, my lord. Put it.
Yes.
This
ಕೊಟ್ಟಿದ್ದೀರಾ?
There is
Judgments ಇದೆ.
judgments, my lord. First one is, my lord, Priya Indoria, my lord. Your lordships may come. This refers to, my lord, transit warrant, requirement of a transit warrant.
Yes, sir.
Your lordship may please come to para 35 at page 56, my lord. Page 56, third line. Immediately upon effecting the arrest of a person outside the jurisdiction where the offence is registered, police is obligated to secure a transit remand. The arrested person has to be produced before the nearest magistrate. If such a magistrate finds that he has no jurisdiction to try the case in which the accused has been arrested, he may order the accused to be forwarded to a magistrate having the jurisdiction to try the case or to commit it for trial. Thus, the police is obligated to secure a transit remand of the accused for taking him from the place where he is arrested to the place where the crime is registered for production before the competent magistrate in terms of the requirement of Article 22. No, my lord. Your lordship may also see some other judgments, my lord, of the Telangana High Court, which is serial number 3, my lord. We can skip DK Basu, my lord. DK Basu is not on the point. Page 109, my lord.
Yes, sir.
Para 10.
Yes.
Personal liberty is one of the cherished objections to the Indian Constitution. Deprivation of the same can only be in accordance with law and in conformity with the provisions thereof, as stipulated under Article 21 of the Constitution. Article 22(2) of the Constitution of India and also Section 57 require that a person arrested or detained in custody should be produced before the nearest magistrate within 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person should be detained beyond such period without the authority of a magistrate. Lord, one moment, I'll just pause here. It is not in dispute that he was brought by plane, my lord. Last time it was accepted, he accepted it.
By road.
By road, and in fact, we have intimated each and every police station to cross it because we had a cash in our hand. Therefore, we can produce in that record also.
Please produce, because last time it was said, they admitted that he was brought by plane. The Criminal Procedure Code also made a similar provision in respect of persons arrested without warrant. The magistrate will not remand of the allow remand of the accused to custody under Section 161(7) of the CRPC, or allow remand under Section 309 CRPC without satisfying themselves that there are reasonable grounds for such remand. Now, my lord, your lordship may have page 113 in the same judgment. First line, my lord. When the time of arrest and production of accused before magistrate concerned is observed, no doubt the production of accused is beyond period of 24 hours. Proposition of law is settled that while calculating 24 hours, the time taken for transit of the accused shall be excluded. It is an admitted fact that upon reliable information with regard to the whereabouts of the absconding accused, the investigating officer intercepted the petitioner at so and so, near so and so. After completing all the required formalities, he produced the petitioner before the learned principal magistrate at 9:45 p.m. on the next day, that is on 18/7/2024. Admittedly, both the place of interception and location where the petitioner was produced are not at a distance which can invariably result in occurrence of delay in production of the accused beyond the period of 24 hours of his arrest, and hence the delay in production of the accused caused cannot be waived under the guise of transit. Further, except stating that due to the late night confessional statement of the accused could not be completed, no plausible explanation is offered by the investigating officer to give leverage or support to the delay occurred in production of the accused before the magistrate concerned. Even otherwise, the confessional statement of the accused was recorded on the next day. It does not take much time as so and so. That can be, then para 17, your lordship.
Yes.
When the above facts of the case, as well as the settled proposition of law laid down in this regard are considered, this court finds force in contention of the learned counsel for the petitioner that the magistrate remanding the petitioner accused to the judicial custody would not frustrate the legislative mandate of producing him within 24 hours of his arrest. As such, the subsequent remand order made by the magistrate would not legalize the prior detention, which was against the constitution and legal mandate. As such, producing petitioner to before the magistrate beyond identical. Then, my lord, your lordship may also have another Telangana High Court judgment at page 122, my lord.
120?
122. Para 3.
That's just Radharani. ಅದೇನೆ ಓದಿದ್ದೀಗ ನೀವು.
ಅಲ್ಲ, this is another judgment. Vishal Manohar Mandrekar.
Manoj is followed.
Yes.
Manoj is
followed.
Apex Court statement.
Yes, yes. Manoj also have, my lord. But
Interpreting section 57.
Correct.
Of the code.
Yes.
Yes.
But para 3, third line, my lord. Investigating agency had not obtained any transit warrant from the nearest magistrate at the place of arrest before bringing him to jurisdictional court in Hyderabad, which was against the spirit of section 167 of the CRPC and various judicial decisions. Notice of arrest of the petitioner accused under section 50A of the CRPC was given by the investigating agency to the brother of the petitioner. However, the said notice was signed by the inspector of police who was not even present at the place of arrest. Lord, then the facts are there, Lord. So I can skip that and come to page 126, 127. Para 10 and 11 again talks about personal liberty and all that, my lord. So I'll just skip that and take your lordships to Lord, para 10, 11, 12, 13 are important, my lord. Your lordship may kindly mark them.
Personal liberty.
Yes, my lord.
Yes.
12 and 13 also. Then, my lord, at page 130, para 17. Thus, obtaining a transit warrant is mandatory for the police to claim protection under Article 22 of the Constitution of India. The above judgment was rendered on the aspect of granting transit and anticipatory bail for the limited duration. It was further held that to maintain a delicate balance between the individual liberties and difficulties of the investigating agency in procuring the presence of the accused persons residing in other states, it was essential to follow the safeguards as mandated under Article 22 of the Constitution of India. Then, my lord, your lordship may see the quoted part at page 132, which says, my lord, that it's again Manoj, which says that, my lord, the arrest becomes
Manoj is the one the
odious.
Supreme Court said.
Correct, my lord. Now, I just wanted to point out that the Supreme Court also says
Section 57 is mandated.
Yes.
It should be, yes.
the arrest becomes odious is what is important. That is, then, my lord, there are another two judgments.
Vihan Kumar. Huh?
Vihan is there, my lord.
Vihan is for grounds of arrest.
Grounds of arrest, my lord. At page 160, 161. 160 is relevant, my lord. I will just read that. Para 16. An attempt was made by the learned counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody. And now a charge sheet has been filed.
No,
His
that is
submission.
Vihan Kumar.
Vihan.
Charge sheet filing will not take away.
That's all
the
I wanted to
initial,
point
that
out.
I am aware, yes.
That specific argument was rejected. As regards, my lord, Article 22.
Anyway, that's now
And
before another bench.
There is.
Whether it is applicable to IPC offences
Yes.
or not.
And Lord, one other important thing, my lord, your lordship will see. CBI first information report. The first information, my lord, FIR recorded by CBI, my lord. Here in this case, what the entire allegations made in the charge sheet is that the money, my lord, from 18 transactions went to 18 different accounts in, my lord, one corporation called the First Finance Corporation. And from there, my lord, it was distributed to hundreds of accounts, my lord. Now, my lord, on the very same transaction, my lord, your lordship will see the CBI, my lord, in fact, the bank itself has given, my lord, the
CBI investigation is over, is it?
No, it's not over, my lord. But what I'm pointing out is none of the accounts, my lord, have gone to, my lord, the First Finance, my lord. It has all gone to RBL Bank.
The subject matter of investigation.
No, but if that is the case, my lord, then the entire charge sheet has to go, because the 7 pages that your lordship said are show, my lord, that the entire money, my lord, was transferred to these very accounts. I'm not even disputing those account numbers. Account numbers and, my lord, the beneficiaries, my lord, are the same, but the bank is RBL Bank. All the 17, 18. Yes, please.
Yes, sir.
The bail issue, which delay and other things. I'll just only one aspect. The co-accused, accused number 2, sought for a bail before this court.
A2.
A2. And it was rejected.
Madam.
And it was rejected solely on the ground that Lordship may see.
Your bail apply madilva?
I'll come to that. Lordship may see page 10, para 8, madam. Para 8, madam, page 10. The only reason now this went to Supreme Court. That's the reason. Page 8, the allegation against accused number 2 in the charge sheet is that he, being a close friend of accused number 1, had conspired, transferred fixed deposit of corporation to some other account. It talks about he and accused number 1. The entire page, then your lordship may see at the next page also, 4th line. Accused number 1 and 2 are persons with a criminal antecedent additional state public so and so place a material before the court which prima facie shows that the accused number 1 and 2 are involved in crime number so and so registered in Raipur police station for offence punishable so and so. The modus operandi of accused number 1 and 2 in the said case or the present case is similar in nature. This is only to show that, my lord. Now this matter went to Supreme Court. The Supreme Court, my lord, dismissed it on the grounds.
Madam. Madam.
Your Lordship, is the Supreme Court order, my lord. Petitioner is an accused for the offence punishment so and so. The petitioner has criminal antecedents of the committing the crime similar nature. We are not inclined to grant bail. Now post
We're
this,
not inclined to grant him bail.
yes, post this, the petitioner seeks for approach this court, trial court, and the subsequently rejected. He came to this court, and this court, Your Lordship, may see the observation.
ಯಾವ ಜಸ್ಟಿಸ್ ರಾಚಯ್ಯ ಅವ್ರದ
ಅಲ್ಲ, Justice Vishwesh Shetty.
ಮತ್ತೆ ಇವ್ರದ್ದು
Yes, yours. The allegation against accused number 2 and the petitioner herein is similar in nature, and bail application accused number 2 is already been rejected by this court. And this stage, petitioner is may be dismissed.
with liberty to file fresh
But to
petition.
file fresh. I'm not on that. The only issue I'm allowed to show that there is no allegation against him and all those things. It is not true, but there is an allegation, and the bail to co-accused was rejected. Subsequently, Supreme Court also rejected this thing. He came before the trial court, the bail court, and rejected. And in fact, if I say, my lord, all these grounds he urged before the bail court, at the trial court, and of course in high court. Of course, there is no order. No problem, my lord. Then what transpired is
Now, you tell me one thing.
yes, my lord.
Transit problem, what was the transit problem here? He was taken into custody at 11:30
Correct, my lord.
on the 12th,
On the 11th.
on the 11th.
Yes, my lord.
And what time did you produce him before the magistrate?
Happened, my lord. 11:30, we've taken him to custody.
Huh.
And then conducted a Mazar, recovery Mazar at his house, which went on till 5:30 AM.
Recovery mass.
Recovery Mazar.
That is where 8 crores was
Yes,
seized.
8 crores was seized.
8 crores, 15 kgs gold.
15 kgs gold was subsequently recovered at different location belongs to him.
All
At
right.
Day one, only 8 crores was recovered.
So Manali 8 crores.
Yes, ma'am.
Cash.
Cash. So the Mazar is completed at 5:40, I'm sorry, 5:40 on 12/6/2024.
Hmm.
Then we have taken him to hospital for medical examination, COVID test
Elli,
in
Telangana.
Hyderabad.
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 Hmm.
Then we reached to the court at 1:15 PM.
1:15 PM.
1:15 PM.
Where, which court?
Hyderabad court.
But between 5:40 to 1:15 PM ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
No, we have taken him to medical examination also.
ಎಷ್ಟೊತ್ತು?
ಮಾಡಿದ್ದಾರೆ. Whole night the search was happening. It is not that 5:40, my lord, the Mazar was completed.
All right. Hmm.
Then medical examination, all those things. The magistrate court we went on 1:15, and magistrate court returned the transit warrant at 5:26 PM.
5:26 PM.
PM
On 12th.
on 12th.
Huh.
And then we've
Returned why his name was not found in the
the lordship may see that the order says Google Lens ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನು ಚೆಕ್ ಮಾಡಿ ನೋಡಿದ್ರೆ
Google Lens.
ಹೌದು ಹಂಗೆ ಬರ್ದಿದ್ದಾರೆ.
Google Lens ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ್ರಂತ.
Not seen the order.
ಕೊಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ ಕೊಟ್ಟೆ ಅದನ್ನ ಈಗ ಕೊಟ್ಟೆ.
ಈಗ ಕೊಟ್ಟಿದ್ದ?
ಈಗ ಕೊಟ್ಟೆ.
ಹಾ, yes. ಹ್ಮ್. ಹ್ಮ್.
The lordship may see it says
ರಾಜೇಂದ್ರ ನಗರ್ ಅದೇನಾ? ಹಾ,
ಹೌದು.
yes.
concerned police filed a request for issuance of transit warrant of so and so.
I have made efforts with my team so and so.
Para 3
Covering so and so.
Google Lens, but involvement of said so and so is not.
ಅಲ್ಲ ಲೀಗಲ್ ಲೆನ್ಸ್ ಬದಲು ಗೂಗಲ್ ಲೆನ್ಸ್ ಅಂತ ಹಾಕ್ಬಿಟ್ರ?
ಅಲ್ಲೇ ಇದೆ ಪ್ಯಾರಾ 3 ನಲ್ಲಿ
ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್,
ಪ್ಯಾರಾ 3 ನಲ್ಲಿ
ಕೌಂಟಿಂಗ್ ಮಷೀನ್
and written.
and written.
ಅಲ್ಲ ಟೈಪ್ ಕಾಪಿ ನಿನ್ನೆ ಪ್ಲೇಸ್ ದಿಸ್
Concerned police requisition at the requisition
Yes, yes.
Satnarayana.
Yes.
Photocopy of Panchnama. Later, the contents of the photocopy of Panchnama was checked through Google Lens.
Yes.
But the involvement of Satnarayana in commission of the alleged offence was not disclosed. Lens did not disclose. All the other offences so and so attracts allegations. 41A not complied,
Hence return.
hence return.
Return.
So transit warrant ಕೊಡ್ಲಿಲ್ಲ ನಿಮ್ಗೆ.
ಕೊಡ್ಲಿಲ್ಲ.
But how did you get him here?
That, my lord, when we produce before the magistrate court has three options. I'll rely on a judgment, my lord, has three options.
Yes.
One, he can give a transit warrant. He can remand it, he can release him. He can remand it to judicial custody.
So he only returned it.
He only returned.
The other two he did not.
Other two he did not.
Release ಮಾಡ್ಲಿಲ್ಲ, judicial custody.
Custody ಕೊಡ್ಲಿಲ್ಲ. Then we have no option. That is when we will have to, because we have arrested him. We have taken him to custody. When the magistrate has not acted, we had no option. So we'll have to travel. So we made an attempt to reach Bangalore, and we reached Bangalore next day morning.
That is 13th.
13th.
So 11, 13, the 13th ಗೆ you have been holding him and moving around.
Out. Holding him, moving around. We bring him to Bangalore. Again, medical was done. We produce him before the magistrate court, and the magistrate court accepted.
Judicial custody.
No, police
custody first.
Because we have, in fact, remand application in detail. We have narrated what transpired. Magistrate has looked into the narration which we transpired. Thereafter, he is given to the police custody. Again, we have taken back to Hyderabad because the whole purpose was thought for a police custody remand. We wanted to search other houses.
So Amali, you searched the other houses?
We went and searched other houses because this house where we got 8 crore rupees is a temporary house he rented very recently, so hoping that nobody will figure out. And we got a tip off, and then we went and we have did what we have to do. And your lordship may see there is in the entire episode there is no malicious. And I'll rely on judgment, my lord, which also speaks about.
ಈ 482 petition first ಇದು?
No, this is the second one.
This is second.
Second one.
First ಯಾವುದು?
Justice Rache's order.
ಅಲ್ಲ, that is, you had not challenged the charge sheet there.
No, charge sheet.
It was only grounds of arrest.
Grounds of arrest and transit warrant.
Your lordship may take my objection for a moment, my lord, before going.
Objection ಹಾಕಿದ್ದೀರಾ?
Yes, my lord, I filed objection.
Objection ಇದೆ.
It was filed on 11/7.
ಇಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಅಶ್ವಿನಿ ಕುಮಾರ್. ಇದೆ.
Your lordship may come to, may request your lordship page 55, the prayers in earlier petition.
55.
55. I
Very short objection ಇದೆ ಇಲ್ಲಿ. Not.
That must be our objection, but we have not.
ನಿಮ್ದಿರ್ಬೇಕು. Yes.
ಏನಿಲ್ಲ.
ನಿಮ್ಮ objection ಇಲ್ಲ ಜಗದೀಶ್.
ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ರ?
ಓಪನ್ ಅಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕೊಟ್ಟೆ.
ಒಂದು ನಿಮಿಷ ತಗೊಳ್ಳಿ, ಇಲ್ಲೇನೋ ಇದೆ. Just one second.
On 11/7.
It's here.
Page 55 is the prayer in earlier petition. Declare the arrest of the petitioner dated 11/6/2024 in crime number so and so, Bangalore illegal, and consequently release the petitioner from judicial custody forthwith with direction to respondent 3 to release so and so.
Yes.
In this petition, my lord, your lordship may request your lordship to, they have taken all contention. Your lordship may see at page 39.
So anyway, this is rejected.
This was rejected. Once this has been rejected, now question of coming back and adjudicating the same matter before same court does not arise is my first submission. May place this some judgment, my lord, which give them a call.
Change circumstance, Anil Khadkiwala says.
No, there is no change, sir. That is what I'm.
No, not only that change circumstance, my lord, not decided on merit. On that, my lord, your lordship have passed 2 orders, my lord. I have those.
No, the first judgment, my lord, with respect to what kind of order can be, what happens if the custody is illegal.
Give us also copy.
Given the copy. Given the copy, sir. Lordship may see this is, of course, my lord, this is a case where with respect to some rifles and they have kept in detention. Even there, my lord, your lordship may see. I'll skip the
page 8, my lord, sorry, para 8, my lord, page 3. From the order sheet produced before us, it is clear that petitioner was first produced before the magistrate on 3rd March 69, so on so. That though was roughly 2 months after the arrest of armed forces. Under section 5 of the Armed Forces Act, he had been made over to the office in charge of the nearest police station within the least possible delay. Now what's important, the least possible delay. Least possible delay, together with the respect of the circumstances occasioned the arrest, which is what his least possible delay in case depends upon each facts of the fact, that is to say, how whether and what circumstances the arrest was effected. From the affidavit of so and so, prima facie appears that the petitioner is connected with so and so. It is therefore necessary to question him about his association, etc. I'll skip, my lord. Your lordship may come to last 5 lines.
Yes.
The period each time was slightly longer than 15 days, but not so unconsciously long as to violate the spirit of the code. Therefore, the gap between the petitioner was custody of this court, but no request was made to release him. Now he is in a proper remand, and in fact has been remanded to custody of the magistrate by us. We cannot now hold detention is illegal. This is, my lord, is a 5-judge bench of this thing. Only reason I'm referring this, my lord, subsequently this judgment came to be referred in other judgment. Now the second judgment, my lord, now relies on the earlier judgment and says, my lord, that the mere delay.
Yes.
The grounds, my lord, at para number 2 in page 5. The learned counsel of petitioner says the petitioner is entitled to be released on 3 grounds. The original date of arrest being so and so, and the petitioner not being produced before the magistrate within 24 hours, the petitioner is entitled to be released. 2, the petitioner having been arrested in one case, and etc. Now they relies on, my lord, that the constitution bench which we referred to previously, and then say, my lord, this is not, there is no violation. Now the third, my lord, is the Pragya Thakur's judgment. Your lordship may request your lordship to come to page 60, sorry, para 60 at page 24.
Page 24.
Page 24, para 60, my lord. In the ground seeking bail earlier before the trial court or before the High Court, bail was not sought for the ground of violation of Article 22(2) of the Constitution, but was confined only to the plea that the charge sheet was not filed within 90 days. Therefore, the issue cannot be gone into in the SLP, more particularly in view of the weighty observation made by this court in para 14 of so and so, wherein it is clear laid down that inquiry is to an extent when the accused was arrested is neither contemplated nor provided under the code, even if it is assumed that the sake of argument that there was any violation by the police by not producing the appellant within 24 hours of arrest. The appellant could seek her liberty only as long as she was in custody of the police, and after she produced before the magistrate and remand to the custody by the magistrate, the appellant cannot seek a set liberty on the ground that there has been non-compliance of Article 22(2) or Section 167 CRPC by the police. Now, my lord, para 61, they refer to earlier judgment, and 62 also, my lord, they refer to earlier judgment.
Yes.
They request that para 63, my lord. The decision relied upon by the learned counsel for the appellant did not support the plea that every case where there is a violation of Article 22 of the Constitution, an accused has to be set at liberty and released on bail, whereas an accused may be entitled to be set at liberty if it is shown that the accused at the point of time is in illegal detention by the police. Such a right is not available after the magistrate remands the accused to custody. Right under Article 22(2) is available only against illegal detention by the police if it is violated against the while it's available against the custody in jail. The person pursuant to judicial custody, Article 22(2) does not operate against the judicial order. The decision in Manoj, my lord, is there.
Yes, we'll continue tomorrow.
Yes.
Rajesh sir, you're here.
Yes, yes.
ಇತೋಳಿ ಎಲ್ಲ ಇಡಿ ಮೇಡಮ್. ಅದು ಗವರ್ಮೆಂಟ್ ತಂದು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಲ್ಲ ಆದಿತ್ಯ,
Number 10.
ಅದು ನಾಳೆ.
ನಾಳೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಟ್ಯಾಕ್ಸ್ ಡೇ ಮೇಲೆ.
ಓ, ನಾಳೆ ಟ್ಯಾಕ್ಸ್ ಡೇ ಅಲ್ಲ. ಥರ್ಸ್ಡೇ Thursday tax day here.
Can 14th, I have another matter before your lordships.
We'll take it on 14th
My lord.
here.
Here.
Chintan. 15th. 13th is also fine. 13th is again a tax day. He has to be there. 12th also fine. Yes, Aditya. 12th is fine. List on 12th.
Interim order.
That will continue.
My lords, 36, my lords. The slum clearance board, where the matter is remitted back, my lords.
Yes. Yavudu serial number?
36, my lords. Compensation, my lord, should be under the Land Acquisition
Correct.
Act.
That I did not decide in the other case. 36 ಅಲ್ಲ? ಎಲ್ಲ LABD 12th ಬರಲಿ 12th or 19th ಯಾವತ್ತು ಬೇಕು ನಿಮ್ಗೆ?
12th.
ಎಲ್ಲ 12th. 41 ಆಯ್ತು. 12th.
Serial number
12th.
serial number.
ಇಬ್ರು ಹೇಳಿದ್ರೆ ಒಂದ್ ನಿಮಿಷ. ಎಲ್ಲ 12th. ಯಾವ್ದು ಮೇಡಮ್? ಯಾವ್ದು? 71 ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? TDR ದಾ? TDR 12th ಬರ್ಲಿ. ಯಾರು ನಾಟ್ ಅಪಿಯರಿಂಗ್? ಬರ್ತಾರೆ. ಸತ್ಯಾನಂದ್ ಇಲ್ಲ ಇದ. ಅದ್ರಲ್ಲಿ ಪವನ್ ಕುಮಾರ್ ಹೆಸರು ತೋರಿಸಿದೆ ನಿಮ್ದ?
Milords, further hearing matter, please, milords. Hits music, please.
Tuesday.
Please.
No, our objection haki. Let him take instruction.
I have given 9 sets. Initial
10th set ಒಂದು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಪೇಪರ್ ಅಷ್ಟೊಂದು ತಗೊಂಡು? ಇನ್ನೊಂದು ಕೊಡಿ. We'll post them all. Reach ಆಗ್ಲಿರೋ LABD divide on 12th and 19th.
47. List 1 49. 47.
ಒಬ್ಬೊಬ್ಬರಾಗಿ ಹೇಳಿ.
47.
ಏನ್ ಹೇಳಿ?
Sir, serial number 47.
ಏನ್ ಹೇಳಿ ಅದು?
Sir, next to
ಸೀರಿಯಲ್ ನಂಬರ್ ಆದ್ಮೇಲೆ ಏನಾರು ಹೇಳಿ.
Sir, next ಯಾವಾಗ?
ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್?
Yes, sir.
CPC na land acquisition?
Sir, land acquisition.
12th or 19th will post it. Yes.
My lord, serial number 69 and list 1. And for the impleading applicant, there's emergency. I'm the auction purchaser.
GMCPC na?
LABDA, my lord.
12th.
12th, my lord.
Serial number 44. 44, my lords.
All, madam, 12th.
Serial 63.
1 minute.
Covered by this.
7th LABDA ಇರಲ್ಲ. Tax alone. ಡೇಟ್ ಎಷ್ಟಿದೆ? 12/7. ಯಾರು ಸರಿ? Well, all on 19th.
My lords, covered by decision, my lords.
Whatever, covered, not covered, ella 19th. 131 matters are there in 12th. No.
Serial number 44, interim
No,
order
sir.
may be extended.
Ella 19th. If you want it 19th or 29th.
My lords, interim order may be extended.
Interim orders will get. Interim orders ಯಾವತ್ತು ತೊಂದರೆ ಕೊಟ್ಟಿದೆ? Yes. 103 pages. Yes. Not tomorrow ಆಗಲ್ಲ. ಅದು 12th ತಗೊಂಡು. RP ರಿವ್ಯೂ ಪೆಟಿಷನ್ 12th ಹಾಕಿ ಮಾಡಿ. ನೀವು 103 pages ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ರಿವ್ಯೂ ಪೆಟಿಷನ್. ನೀವೇ 103 pages. ಕರೆಕ್ಟ್. ಇಲ್ಲ 206 pages ಬರಿಬೇಕಾಗುತ್ತೆ. 230 matter. Wait, there are some 230 mood matters. Fakirappa, wait. Interim orders will get extended. Please don't mention about interim order extension, madam. ಎಲ್ಲೆಲ್ಲಿ interim order ಇದೆ ಹೇಳ್ದೆ ಹೋದ್ರು ನಾನು extend ಮಾಡಿದೀನಿ next day. ನಾಳೆ ಆಗುತ್ತಾ? ಇಲ್ಲ ನಾಳೆ. ಕಮತ್ ಸರ್ ನಾಳೆ 150 ಪ್ಲಸ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 100 ಇದೆಯಂತ. 13th, yes. 12th ಬೇಡವಾ? ಆಲ್ ರೈಟ್, 13th. ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ ಅದು? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ? ಅಲ್ಲ, ಅಡ್ಮಿಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಹೌ ಕ್ಯಾನ್ ಐ ಪೋಸ್ಟ್ ಇಟ್ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್? ನಮ್ದಲ್ವಾ ಅದು? ನಮ್ ರೋಸ್ಟರ್ ಅಲ್ವಾ? It's a GM roster. I can't post it in preliminary hearing. Further hearing ಅಲ್ಲೇ ಇರ್ಬೇಕು. 13th. 11th again 300, 400. Yes.
13th, my lords.
Oh, you are here. Yes, sir. 13th.
Please.
I know. No, I've heard at length, not only heard at length.
Except for allowing it, my lord, nothing is pending. That's why we live, my lords.
All right, yes. 13th, sir. 13, AG ಅವರ. 13th.
13th, please.
Who are you? Serial number? 52. Land acquisition, madam. Land acquisition. When do you want? 12th you want? 12th.
My lords, serial number 63, my lords, covered by decision. IA is pending, my lords. If that is allowed, amendment IA, I'll carry out, my lords.
Along with the main, yes. Now call the 230 mood matters. Yes.
30 more matters.
Hari Prasad, one ನಿಮಿಷ. In terms, withdrawal, one. Counsel for the petitioner files a memo seeking to withdraw the petition in terms of the memo withdrawn. Next.
Number 2.
Abdul Majid. ಇಷ್ಟೊತ್ತಲ್ಲಿ ಯಾವ ಪಾಸ್ ಓವರ್ ಕೊಡಿಲಿ, ಏನ್ ಫೈಲ್ ಏನಿದು ಗವರ್ಮೆಂಟ್? ಯಾಕೆ ಅರೆಸ್ಟ್ ಇವ್ರಿಗೆ? List the matter on 13th in preliminary hearing. The warrant of arrest hanging on the head of the petitioner shall remain state till the next date. The petitioner shall serve on the counsel represent state ida learned HCGP for the first respondent, petitioner to serve on the decree holder, counsel for the decree holder, and file an acknowledgement of such service on or before the 7th of August. In the event no steps are taken to serve the decree holder, the interim order granted will automatically get vacated. ನೀವೇ petitioner? Where is your advocate? Tell him stay ಮಾಡಿದ್ದೀನಿ. Yes.
Number 3.
Withdrawal. Counsel for the petition for withdrawal. Memo ಇದೆಯಾ? In terms of the memo, madam. Yes, next.
Number 4. Srimati Kavita.
This is a
ಏನ್ madam?
OTS
CPC ಯಾ?
execution warrant, arrest warrant has been issued.
Why?
OTS proposal has been arrived, my lord, for 6 lakhs. Out of that, I have paid 2 lakhs as per the earlier order.
Sundaram Finance.
Sundaram Finance. Now 4 lakhs is that due.
4 lakhs?
Only amount is due, my lord. Total outstanding amount. 1 lakh I'll deposit, my lord.
Deposit. Surface is ಇಲ್ಲಿ.
Yes.
Emergent note, sorry. Petitioner shall serve on the counsel who represents the respondent in the trial proceedings. The impugned warrant of arrest against the petitioner shall remain stayed subject to the condition of deposit of 1 lakh before this court by the next date. List the matter on 3rd September. Yes.
And delivery.
Tomorrow. We'll see.
Tomorrow.
Tomorrow. And delivery tomorrow. But ಬೆಳಗ್ಗೆ 10:30 ಗಂಟೆ ಕೊಟ್ಬಿಡಿ. Yes, next.
5.
Pradeep Naik.
This is covered by a lordship's judgment in Kudla rampage.
Let's I take notice, my
Similar
lords,
situated
I may request
defendant
my
number-
lords to post this matter day after tomorrow. I just.
ಇಲ್ಲ ಇದ್ದಾರೆ. That order applies to everyone. ನೀವು 66 ಅಂದಿದ್ದಕ್ಕೆ 66 ಹಾಕಿ.
In fact,
Reason ಇಲ್ಲ ಅಂದ್ರೆ reason ಇಲ್ಲ.
ತಾವು
That order is not in existence today at all.
Correct. ತಾವು 66 ಅಂತ ಹೇಳಿದಿರಿ ಅದ್ರಲ್ಲಿ.
Correct. ಅದು ಹೇಳಿಲ್ವಾ?
ಹೇಳಿದೆ. That is why, my lords, let me go through the petition if they have made any allegation against me, my lords.
Against you ಅಂದ್ರೆ?
Literally, my lords. Against the respondent, I'll go through this petition and my lords may call this matter day after tomorrow or Monday. my lords.
What happened before the concerned court?
ಇಲ್ಲಿ ಇವತ್ತಿಗಿದೆ.
It was there today, date has not been assigned. Lords, all of the.
But sir, trial court is hearing the matter on IA 1 and 2.
I have
and
directed
also
it to
3.
be heard.
And now the court is also, my lords, accused earlier court, my lords.
ಅದನ್ನ ಮುಂಚೆನೆ ಮಾಡ್ಬೇಕಾಗಿ.
Lords, this was also mentioned today. There are multiple suits that are filed in identical circumstances where John Doe order.
That is on insofar as
John
different
Doe
cause of
orders
action.
are passed against others and you are not a part. You are on John Doe orders?
Yes, my lords. Your lordship's judgment covers that also. Paragraph 20 is clearly covers John Doe orders as well.
Yes.
And it's identical circumstance. Your lordship may consider, because I have nowhere else to go. It will only come before your lordship.
All right. The orders passed by the civil court, is it?
Civil court, yes, my lords.
Then not GM.
No.
Morning somebody moved
Yes,
the
my lords,
matter.
my colleague mentioned.
Sorry, because I thought you were
No, my lords, it's a civil
telling
court.
about independent orders other than orders of the civil court.
Civil court.
ಬೆಳಗ್ಗೆ
order.
rush ಅಲ್ಲಿ you
Please,
can't
I
know.
appreciate.
We'll take it tomorrow.
Please.
No, it's not tomorrow, day after tomorrow.
Thursday.
Yeah.
Both.
ಇದು ನಿಮ್ದಲ್ಲ ಬಿಡಿ.
I'll serve. I don't know if you're not a part.
No, that is John Doe orders
John Doe orders.
or Ashok Kumar order.
That's
Ashok Kumar order.
Ashok Kumar.
You
orders.
should
Please,
say
my lords,
Ashok
Please,
Kumar.
my lords. Ashok.
Lords
Not
may call
John
this
Doe.
matter on
Both
Monday.
used simultaneously.
My lords may call this matter on Monday.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. We'll stay further proceedings then.
Lords, day
Oh,
to day.
sir. I have rendered a judgment, he is here. Because there are others were not there, so I had not said it.
Lords, in case
Fact,
if stay of further proceedings order is passed, my lords, then trial court cannot, my lords, take up the matter.
All of your lordship's observations
saying, my
apply
lords,
across the board to all defendants, my lords. There's nothing particular about it.
Somebody else was before the court, I had to restrict.
I appreciate.
Lords, only my request is, my lords.
In fact, it will now result in 90
Multiple
90
petitions.
defendants coming to your lordship saying, please extend it to me.
At least 328 my lords are there. If they are come, then
328 will come.
if they come, my lords, so that is altogether different.
All right.
My lords,
Monday.
Monday.
Both cases, my lords.
ಅದು ಅದೇ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಮಂಡೆಗೆ ಹಾಕ್ಬಿಡಿ.
Grateful.
ನಾವೇ ಹಾಕಿರೋದು. ಇಲ್ಲ. Interfere.
Silamar?
I appear for the
Question.
petition, my lords. In this, 3 orders are passed by this honorable court, asking the trial court to dispose of my application for vacating the temporary injunction. First order is at page number 104, my lords.
2:30ಗೆ ಮೂವ್ ಮಾಡಿದ್ರೆ ಇದು ಯಾಕೆ?
I just mentioned my lords only gave for 2:30.
Yes.
First order is
Can
at-
we take it tomorrow? We can
Please,
pass
my
it.
lords,
We'll take it tomorrow.
fresh matters, means?
Huh?
Fresh matters.
మీరు ನಾಳೆ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಎಲ್ಲ.
Please. Grateful.
ಆಗುತ್ತೆ ಮೇಡಮ್ ನಾಳೆ? ಜೋಸೆಫ್ ಕೊಡಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್. 1:30 ಮೂವ್ ಮಾಡಿದ್ದ. ದ ಡೆಲಿವರಿ ವಾರೆಂಟ್. ಮೂವ್ ಮಾಡಿ, ದೇ ಡೋಂಟ್ ಕಮ್ ಅಟ್ ಆಲ್. ಅದು ನಾಳೆ ಇದೆ ಅಂತಲ್ಲ ಹೇಳಿದ್ ಮೇಡಮ್. List tomorrow.
Minutes.
8
minutes. And then it is serial number 2 minutes.
Where are you, sir? ಮೂವ್ ಮಾಡೋದು ಆಮೇಲೆ ಬರೋದೇ ಇಲ್ಲ.
My lords will come minutes. I have one.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇರಿ.
My
Petition
lords,
is dismissed.
my lords, kindly pass for minutes. Will come minutes. In 5 minutes will be there, my lords. Please, my lords.
Counsel for the petitioner files a memo seeking to withdraw the petition. Petition disposed as withdrawn. Serial number 8 ಅಲ್ಲ? ಇನ್ನೊಂದು ಜೋಸೆಫ್, if he comes, just ಜೋಸೆಫ್ ಅನಿಲ್ ಕುಮಾರ್ whoever petition ಕೊಡಿ, ಸುಮ್ಮನೆ ನಾಳೆ ತೊಂದರೆ. ಇವರೇನೋ ಬರಲ್ಲ ಅಂತ. Two 4/2025 order. List tomorrow.
Serial number
number 16, list number 1, my lord. It's covered by judgment, my lord. Change
ಎಲ್ಲ
of,
12th or 19th?
Short date, my lord, the top of the list.
12th or 19th or 29th?
12th, my lord, kindly.
List 2.
Parole ಏನಾಯ್ತು? I asked you to get Rahul Karyap. ಯಾರಿದ್ದಾರೆ? Government? Yes, Rashmi madam. Parole ನೀವಿಲ್ವಾ? Will take it day after tomorrow, Guruvara. Fakirappa on Tuesday. ಅದು Thursday ಇಲ್ಲ, Thursday ಆಗಲ್ಲ, tax day. Fakirappa ಅದು Tuesday ಗೆ ಹಾಕ್ಬಿಡಿ. Yes.
One submission, my lord. Serial number 53, connected matter, the next survey number was disposed last month, my lords. Now the difficulty is they are trying to get the plan approved, my lords, but it is already covered by your lordship judgment only.
We'll see, ಅದು post ಆಗುತ್ತೆ.
My lords,
Land acquisition.
short date, yes, my lord.
12th or 19th? Sir?
My lords, 12th is coming.
That's all. Next date is-
Auction, my lord, serial number 66. I have interim order is there, despite that auction has been proceeded with BDM, my lord.
Where is that? BD? 20?
20th.
Interim order ಕೊಟ್ಟಿದ್ದೀವಾ?
Interim order is here, my lord.
ಮತ್ತೆ why are you proceeding?
And I have,
How do you say that they are proceeding?
there's a notification, my lord, I have produced.
After the interim order?
After the interim order, last week, my lord, interim order was in September.
Interim order
Last
date,
time-
interim order date ಹೇಳಿ?
Lord, yes. Sorry.
First.
Yeah. I'll provide it, my lord.
ಮತ್ತೆ
Sorry.
when you allege, you should be having all facts at your fingertips.
I believe it was 26/11, my lord, I'll just.
Your belief won't result in an order.
Yes. 12th, my lord, if I may.
Lords, list 2, serial number 24, your lordship will please to post it on 12th, my lords, the review petition. The senior advocate Srivatsa is not there on 12th. He is requested for 13th if it is.
12th, 4th, we'll take it on 19th.
That order is 8/11.
12th release.
That order is 8/11/24, my lord.
We'll see, yes.
12th, my lord. Interim order maybe.
Madam, 12th.
Serial number 74.
66. 12th.
Madam, serial number